all to the third Health Law International Online Seminar. I'm Henry, and my colleague Stevie will virtually guide this online seminar today. His Excellency MOH, represented by Deputy MOH, Professor Dr. Dante Saxono, Rector of Sugiya Pranata Catholic University, Dr. Ferdinandus Hindiarto, the Dean of Faculty of Law and Communications, Sugiya Pranata Catholic University, Dr. Marcella Elwina Simajuntak, the Head Study Program of Master Health Law, Faculty of Law and Communications, Sugiya Pranata Catholic University, Dr. Endang Wayati, all invited speakers and participants. This international online seminar consists of keynote lectures, 4 parts of seminar on digital health transformations, focusing on electronic medical record and personal data protections. This seminar brings together academia, researchers, practitioners, policymakers, and health law enthusiasts. It provides a great opportunity for all the participants to share their theoretical and practical knowledge, research finding, and experience in this area of health law. Excellency, participants, ladies and gentlemen, we are now going to listen to the organizing chairman report. Ladies and gentlemen, please welcome Dr. Gede Putra Semarajaya. Please welcome Dr. Gede Putra Semarajaya. Time and place is yours, doctors. Dr. Gede, are you with us?
Excellency, Mr. Ferdinand Hindiarto, Rector of Sugiya Pranata Catholic University. Excellency, Ms. Marcella Elwina Simanjuntak, Dean of Faculty of Law and Communication, Sugiya Pranata Catholic University. Excellency, Ms. Endang Wahyati Justina, Head of Master of Law Program, Faculty of Law and Communication, Sugiya Pranata Catholic University. Respectively, all the teachers and guests, and the last, honorable all the participants. As the organizing chair, let me present a brief report about this event. Health Law International Online Seminar is an annual Health Law conference since 2020, hosted by Master of Law Health Law Program, Faculty of Law and Communication, Sugiya Pranata Catholic University, Semarang, Indonesia. In this third event, the registered participant and invited guests almost reached 300 persons. The event theme is Digital Healthcare Transformation, Electronic Medical Record, and Personal Data Protection, which aims to understand the legal aspect of electronic medical records and digital healthcare data protection. Second, to understand the application and challenges in implementation of EMR and digital healthcare data protection. The last one is to understand and develop insight to application of EMR and digital healthcare data protection. On behalf of conference organizing committee, I would like to thank each of our leading speakers in the fields for taking part in this event. And this conference will be divided in 4 sessions, 2 sessions of practice sharing on EMR and PDP, 1 session of health law perspective on EMR and PDP, and in the end session is the organization perspective, the healthcare organization perspective on AMR and PDP. At the end of this conference, there will be a paper presentation. And until now, we received 43 papers and will be divided into 4 breakout rooms in Zoom with the following topics: telemedicine, medical malpractice, health policy, environmental health policy, legal aspect of electronic medical records, human rights and health, hospital law, and drug and food law. Ladies and gentlemen, let me once again thanks our fantastic speakers for giving their time and insight today. And I hope you all watching this event will enjoy the conference. Thank you. Good morning.
Thank you, Dr. Gede Putra Samarajaya, for the organizing chairman report. Excellency, distinguished guests, participants, ladies and gentlemen, now we are going to listen to the welcome remark delivered by the rector of Sugiya Pranata Catholic University. Ladies and gentlemen, we present the recorded opening speech by Dr. Ferdinand Hindiarto, MIC.
The Honorable Keynote Speaker, Mr. Dante Saxono Hari Buwono, distinguished international speakers and national speakers, Dean of Law and Communication Faculty, distinguished all participants, presenters, and guests. Good morning. It's an honor for me to welcome you for the third Health Law International Online Seminar Virtual Conference. The theme of the conference on digital healthcare transformation, electronic medical record, and personal data protection is highly relevant to the world's recent conditions. We are all required to change and adjust to the changing societies that are increasingly dependent on technology. Because technology has become a common language for young generation and society today. The boundaries between countries, organizations, and people become almost invisible because of the technology utilization. Currently, disruptive innovations do not only make the business people prepare many strategies to survive in the competition. People in the education sector are also required to prepare many plans to face the current and future changes. Forcing ourselves to stay unchanged will make us lose a lot of opportunities in educating of younger generation. Understanding the changes in technology will allow us to integrate the good values into our teaching materials. However, the challenge is how to prepare ourselves to be able to adjust to the current situations that may not be our nature. I hope the ideas raised by all speakers, especially from the countries of Taiwan, Netherlands, Portugal, India, Philippines, and Indonesia, will significantly contribute to the development of our respective disciplines. I congratulate the committees of lecturers and students who have organized this event. I wish you all a fruitful conference. Thank you.
Thank you, Bapak Ferdinand Hindiarto, for the opening speech. Excellency, distinguished guests, ladies and gentlemen, we are now continuing our meeting to the next agenda. that is to hear the keynote speech, which will be delivered by Professor Dante Saxono from Ministry of Health of Republic of Indonesia. Professor Dr. Dante Saxono Harbuono completed his medical specialty in endocrinology in 2004 from Faculty of Medicine, University of Indonesia. He earned his PhD from Yamanashi University in Japan and medical doctorate from University of Indonesia. He is a well-known expert in diabetic molecular medicine and lecturer in University of Indonesia. He is currently serving as the Deputy Minister of Health, Republic of Indonesia. Ladies and gentlemen, we will present the recorded keynote lecture from Professor Dante Saxono.
Good morning for everybody. Thank you for inviting me to in the symposium of the Health Law International Symposium today. I would like to talk about the regulation, some regulation relating with the law and also relating with the data that Ministry of Health have. Let me share the slide now. And I would like talking about the digital transformation of in the Ministry of Health in Indonesia to achieving interoperability through the development of integrated and standardized big data platform. Right, please. So the governance of health data and health facility is mostly not digitalized, thus decreasing productivity. It's because the manual or non-digital health service interfere with effectiveness and efficiency, and further threatening quality of public health in our working in Ministry of Health that are already going now. So the wasting on resources due to suboptimal implementation of digital technology has disastrous consequences for health facility. So we try to make this problem will be solving with some approach that we implementing in our transformation. Slide please. So an integrated health system increasing workload of healthcare worker, like you will see here, between maternal child health, immunization, nutrition, infection, disease, they all have their own inputting data. They all have their startup data. So health facility are not integrated. One health worker need input 60 into 70 spreadsheet system, need to remember a lot of logins and password, and so they spend more in front of the computer to providing the service. It's not a good environment to make everything become more simple. So we will try to make a transformation to make everything become more efficient, more easier, and decreasing workload in our healthcare workers. Slide please. The problem is in health technology are spread across multiple health sectors like primary healthcare, secondary healthcare, pharmaceutical, medical device, health equipments, and human capitals, health financing, organizing, management, and biotechnology. All problems are spread across multiple health sectors. They have 70 applications per system. They have more than 10 applications per system. They're not precise and haven't fulfilled the information analytical needed. They're not fully integrated yet, and they don't seem and genome data government or fusion need to be enhanced. So we should make some analysis and try to make us have a good system to make it more as simple as possible. Slide. And the focus of digital health technology will shift us from reporting services so that all health facility innovated to create application technology system that best serve for the people who interact with them. That is our minister, Mr. Budi Sadikin, always say to us to make a transformation of digital health technology to be safe from reporting to services. And we have Minister of Health have committed to transformation, and we have 6 pillars of transformation. There are primary service transformation, secondary service transformation, related to the hospital, health security system transformation. It's related with improving pharmaceutical and medical equipment sector resiliency and strengthening laboratory-based surveillance and resiliency emerging health response. And we also the pillar of health financing system transformation, and we have health human capital transformation, and the last one is health technology transformation that we are going to talking deeply today. Slide. So the Indonesian health transformation will integrate all health data with this life cycle basis approach and digitizing the health services. So in these years, we current progress, we already developed single health identify based big data system. We already integrated health facility information system development, and the expansion of telemedicine to support our infrastructures transformation. In the next year, we try to implement of our artificial intelligence basis, the implementation of integrated health facility information system and artificial intelligence, blockchain, Internet of Things-based regulation sandbox implementation is very important. This should be do in the near future. And our next step will be more expanded cover the single health identify, expanding scope integrated health facility, and licensing expansion of health technology innovation. Slide. And integrated solution health system, we have Indonesian health services we call as Satu Sehat, that the Satu Sehat will be connecting all players within the health industry ecosystem like hospital, primary healthcare, startup, pharmacies, the health services, and laboratory, and etc. And we try to make integrated in health in system will provide specification and standardized mechanism for business process data and security, and we try to make developer have flexibility to use any programming language as long as they follow the specification and information exchange mechanism defined by IASS. So IASS number of the unique identified patient in a health information ensure continuous access to health facility. It will be connecting more than 10,000 primary health care, more than 5,000 general practitioner, more than 10,000 hospital, and also more than 11,000 clinical, and more for laboratory, and more than 30 key of pharmacies will be integrated in one application that we call as Satu Sehat application, Indonesian Health Services. Right? And the health data integrated interoperability benefit patient by encourage data-driven policy making and easy access to personal health data with sharing and access in the all of states of health services like hospital, primary facility, pharmacies, and laboratory. They can, the patient can access what they are already done in their facility. It's not about only treatment, but also access the personal health data services, as we call our health in individual, that personal health data services. Personal health data stored in the citizen health application, it will be integrated in Satu Sehat data, and it data stored in the health data dashboard, and the health data dashboard will be accessed to public dashboard support driving policy making that we need in the future to decide it as well as possible to policy making in Ministry of Health. Slide. And development of citizen health application encourage the implementation of personal health services like medical resume, health promotion, medicines profile, health diary, hospital bed availability, early warning system, tracing and testing methods, integrating telemedicine and personal health education. Patient will have complete control over data stored at Satu Sehat. Data cannot be stored in Satu Sehat and or accessed by IS without the consent of the patient. It's very important for confidentiality, and also patient can give their consent to the Peduli Lindungi application. Peduli Lindungi application, you know your customer solution to ensure data accurate and account ownership. So Satu data, the personal health services is very important in our transformation of data system in our Ministry of Health. Slide. So Satu data kesehatan provide region-based health data dashboard for database policy formulation. They will be integrated system in a facility of health, and they also integrated platform for data existing system, and they will integrate it with our Peduli Lindungi platform that we already have, and that system with from ecosystem Halodoc, Primaku, etc. will be integrated in the one of platform we call as Satu Sehat. The region-based health data dashboard is very important for national level dashboard, provincial level dashboard, city, district level healthcare, primary healthcare, village, and public dashboard. The data policies are starting from public relations. All data integrated with Satu Sehat it display in one health data dashboard, or system-related dashboard, and data analysis in the Ministry of Health are one in the hand data dashboard, and this data visualized display on the dashboard based on the priority of Satu Sehat use cases, and the one health data dashboard has access sharing up the provision the city regency has so far, so that this unit do not need to build their own dashboard system. It will be implementation as soon as possible based on our single startup of implementation in data storage. Slide. Ladies and gentlemen, Indonesian government supports the transformation of health technology generally through various regulation. We have already some law about some regulation about that, but Satu data platform in the citizen health application data standardized and reset policy is the support of some regulation that we already have, and we already make to making this data will be have based on precisely a regulation in every part of the data architectures. Slide. So regulation support a medical record implementation. It will supporting the digital transformation. Health regulation support is needed to ensure transformation can run well. The Ministry of Health has made change update to regulation from previous misregulation become latest regulation, namely misregulation, the electronic of medical record regulation. After 14 years. Slide. So the Ministry Regulation Medical Record update the governance of electronic medical record to make healthcare facility must implement it in the electronic medical record. Electronic medical record must be integrated with the Ministry of Health programs, and data and system standardizing must be followed of Ministry of Health regulation, and data management for health intervention and policy making should be integrated, and patient-referred health facility have access to electronic medical record data. Satu Sehat Citizen Health Application data standardized and research policy is very important to make it in one standard regulation that we should make it in our regulation. So that is all that I can share to you today. I hope the information of ministry program will make our transformation in our startup data, will make Indonesia bureaucracy more simple, more simply, and we have invite you to have some support of this plan, and in the near future we already have some regulation and some consolidation of the data in our own based on the needed of health needed for Indonesian people. Thank you so much for your attention and good afternoon.
Well, thank you very much for the insightful keynote lecture from the Deputy Minister of Health, Republic of Indonesia. While we all are very happy to learn that the Ministry of Health finally rolled out the health technology transformation as one of the 6 pillars of health system transformations as a strategy to advance and improve Indonesian health sectors. Well, we hope that the Satu Data Kesehatan developed by the Ministry of Health can address the challenge and concerns regarding the security of the health data. We hope that the policy and regulations can play an integral part of enabling the successful rollout of these digital health transformations. And we will now continue to our next agenda, ladies and gentlemen, which is the first sessions of the seminar on the practice sharing on electronic medical record and personal data protections, which will be chaired and moderated by I myself. Okay. Allow me to shortly introduce myself. I'm a physician currently pursuing health law study at Sugia Pranata Catholic University. I currently serve as the Executive Director to Bali Peduli Foundations, a non-profit NGO for community health, sexual health, and HIV. I also serve as a research manager and involved in a few joint partnership research UK and Indonesia in infectious diseases by Oxford University, Atmajaya Catholic University, Center of Public Health Innovations of Udayana University, and Wellcome Trust UK. Well, on these sessions, on the first sessions of the seminar, we are honored to have 3 speakers from 3 countries, Taiwan, Netherlands, and Portugal. And each speaker will give a very insightful presentation, a 25-minute presentations. And after that, we will have a 30 minutes of Q&A at the end of the session of the presentation delivery sessions, and after the speaker has all finished the presentation. And if those of you who wish to submit questions, you can submit via the chat, and also we open for live Q&A session at the end of the presentations. Without further ado, I would like to invite our first speaker, Associate Professor Huang Chin Chen, PhD from College of Law, Tung Hai University. Professor Huang Jingchen, are you with us?
Yeah, yes.
Okay.
Good morning, everyone.
Can the administration, can the committee show the CV of a professor? So I'll shortly read through the CVs. Okay, so this is the first speaker for these sessions, the Associate Professor Huang Jingchen, PhD from the College of Law, Tung Hai University. He received his PhD degree from Ludwig Maximilian University of Munich, Germany, and he is currently a professor at Tung Hai University College of Law and the former dean of the College of Law from 2001 to 2004. He also served as the director of Medical Law Institute, College of Law of Tung Hai University since 2010. He's also the editor of this slide is
Of one medical law
okay.
review.
So Professor Tung is really have a Professor Huang. Sorry,
Yes.
Professor Huang has a very in-depth knowledge about the law and as seen in the CV. And without further ado, I offer to you to deliver your presentations.
Okay, thank you, Professor Luis. Hello. Good morning to every distinguished guest, and I'm very happy and pleasure to thank you for the invitation to attend this forum. And the following is my presentation. In Taiwan,
sorry to cut you. Good morning, Prof. Huang. How
yes,
are you? I
I'm
just
fine.
want to say hello. Okay, please. Thank you very much for your coming.
Yeah, thank you. Yeah, my pleasure. Okay, can I speak right now?
Yes, of course.
Okay, as we see in the screen, my theme is the latest practice and the development of the electronic medical record and data protection in Taiwan. It's very fortunate. After I received the invitation of Dr. Elvina in Taiwan, our constitutional code have made a judgment, as we see right now in the screen. The date is very new. So I said the latest development, 2022, August 12th. And at first, I would like to read the tenor of this judgment. And it's very important for us regarding the personal data protection and also the EMR in Taiwan. Yeah, the tenor including 5 points. The first one is the Article 6, personal data related to medical records, medical treatment, genetic health, examination may not be collected, processed, or used. However, under any of the following circumstances, but not limited to, where's next? The fourth paragraph, okay? Public agencies or academic research institutions are necessary for statistical or academic research for the purpose of the medical treatment, healthcare, and the data cannot be identified after being processed by the provider or by the collector according to the method of disclosure specific parties. Our constitutional code said there is no violation of the principle of legal clarity and proportionality, and it is do not violate the intention of Article 22 of our Constitution to protect the people's right to privacy of information. The second point, based on the overall observation of the personal data protection law or other relevant laws and regulations, there is no independent supervision mechanism for personal data protection, and the protection of personal information privacy is insufficient, which may be unconstitutional. Within 3 years, the code demand formulate or amend relevant laws and established relevant legal system in order to fully protect the people's right to information privacy in Article 22 of the Constitution. The code also demands within 3 years formulate. Yeah, I have next one, please. Next one. The third point, please. Next one. Yeah, relevant agencies shall formulate or amend relevant laws within 3 years from the date of the announcement of this judgment, clearly specified the subject, reasons, procedures, effects, etc. of requests for succession and exceptions not allowed to succession. If relevant laws are not enacted or amended within the time limit, the parties concerned may request to stop the above mentioned use beyond the purpose. The fifth point, the rest of the application of the petitioner will not be accepted. The cause, background, and effects of this case. Since 1984, Taiwan has implemented the national health insurance system. All citizens who meet the statutory insurance requirements are all eligible to participate in the international health insurance. National health insurance recipient receive the medical care services from special medical service institution, and the medical service institutions share, in accordance with Article 80 of the National Health Insurance Law, report to the insurer, the Central Health Insurance Administration of the Ministry of Health and Welfare, to provide relevant information, including relevant medical, also drug records. Here, the medical records, that's why this judgment is very important for this forum and conference, and is informative for or meaningful. Even the information, the relevant information is very wide, but it including the electronic medical records. That's the main content of this forum. That's why I want to introduce this judgment. Okay, prescription, medical records, etc. of the insured to declare medical expenses. Therefore, in order to handle the national health insurance business. The National Health Insurance Administration has collected a considerable amount and types of national health insurance data over the years, including personal health insurance data. The health insurance data collected by the National Health Insurance Department include health insurance, medical service declaration summary form, details, medical order files, health insurance, underwriting files, health insurance card upload files, inspection and inspection upload files, including medical image data, and also virtual private network upload files, special medical institution files, health insurance payment items, and payment standard files, etc. Very wide. The National Health Insurance Administration previously authorized the National Institute of Health to build a national health insurance research database, which has been provided for use since 1989. The National Health Insurance Research Database was commissioned to build using the relationship. It was determined on June 28, 2015, and is no longer provided by the National Institute of Health. The National Institute of Health has also handed over the original data and the CD-ROM data files to the Department of Health Insurance. The National Health Insurance Administration currently has the National Health Insurance Insurer Information Integration Application Service Center in accordance with its own National Health Insurance Insurer Information Integration Application Service Center operating points. National Health Insurance Insurer Information Integration Application Service application case review operating principle, etc., to provide external health insurance information, which has been, pseudonymized through encryption algorithm. Government agencies that need to use the data of the center due to official needs or academic research or other professional institution may submit relevant documents, including the certificate of the Ethical Review Committee to the National Health Insurance Department for review. If the application cannot be identified or has doubts, it will be re-examined by external experts. So the procedure is very strict. If there is an application for medical imaging, it will be deliberated by a National Health Insurance Image Data Application Review Committee. We have set up a lot of organization to control, to oversight of the data. In addition, the National Health Insurance Administration will encrypt the general form, details, medical order files, and the health insurance coverage files in the health insurance information and provide them to the Ministry of Health and Welfare to establish Health Welfare Data Science Center, formerly Collaborative Center for Value-Added Application of Health Data. In addition to health insurance data, the center also contains other health and welfare data, including birth notification files, death notification files, disabled people files, national health interview surveys, etc., and has been available to the outside world. According to the 6th point of the operation point of the health data value application collaboration center of the executive end, that's the administrative regulation, internal. Department of Health published on May 12, 1999, when requesting to provide data for user, one should submit a document to the Statistics Office of the Department for application. After the center was renamed the Health and Welfare Data Science Service Center, the Ministry of the Health and Welfare Statistics and Application Management Review Committee was set up, and the Ministry of Health and Welfare Data Application Management points the Ministry of Health and Welfare Data Application Case Review Operation Principles, etc., were also established. The first label data collected by the center is the data with numbered fields and processed to make it impossible to identify specific individuals, can only be used by government departments, academic and research institutions, or health and welfare related industries that have obtained the written consent of the parties to use health and welfare data, of course, including the EMR. The documents to be attached to the application include the certificate of the Ethics Review Committee after the application is first reviewed by the Ministry of Health and Welfare. On the procedure, external experts will review the content. The petitioners of this constitutional lawsuit of this case believe that the National Health Insurance Administration will submit the health insurance data to the National Health Insurance Research Database established by the National Health Service for external use and transit the health insurance data to the Health and Welfare Data Science Center of the Ministry of Health and Welfare for external use. The personal health insurance data, including, of course, EMR, protected by the constitutional right of privacy, is used for purpose other than health insurance business, for purposes other than the original purpose of collection, and they are violation of laws. The National Health Insurance Administration reject the petitioner's claim. The reason were as following. The National Health Insurance Administration handles health insurance business and possessed the medical insurance and medical treatment information of the people across the country in order to promote health insurance related research and improve medical health for development, especially for the development of the medicine. Even providing information to the outside world, it is handled in accordance with the provisions of the Computer Processing Personal Data Protection Law, formulated and in effect in 1984. It's very earlier. And the provision of the data has strict data management measures, which are sufficient to protect the reasonable use of research data and other languages. The agent believed the protection is enough legally. The petitioner was dissatisfied and file an appeal, which was rejected. They filed the lawsuit against the agency and eventually to the Constitutional Court. That's the story of this case. My conclusion, we know nowadays the people pay more attention on the personal privacy. And so this issue become more and more important in the society. So the meaning of the self-control of personal data, we should reiterate again, according to our law, the legislative purpose disclosed in Article 1 of the Personal Data Protection Law regulate personal data collection, processing, or use to avoid infringement of personal rights. This regulation should be refreshed and keep in mind in today's. Second, in the free and democratic country, human dignity and respect for the free development of personality are the core values guaranteed by the Constitution. Among them, the privacy is the core value. The Personal Data Protection Law regulates also the principle of party participation in the process of collection, processing, and utilization, the so-called individual participation principle. Regarding the scope and the degree of disclosure, and individuals has the right to know and control the use of their personal information. Thank you for your attention.
Thank you very much for your insightful presentation, Professor Huang. Ladies and gentlemen, if you have questions, you can submit the chat through the chat column, or we can do the live Q&A sessions after all the speaker has finished their presentations. All right. We are now continuing to the second speaker. We have Professor Andre Den Exer, PhD from Erasmus School of Law. Is Professor Andre with us? Yes, Professor Andre is with us. Okay, I will shortly read his CV. So he's an associate professor of health law from Erasmus School of Law, Erasmus University Rotterdam in Netherlands. He's also a visiting professor at Danilo Medical University of Lviv in Ukraine and National School of Public Health of Nova de Lisboa University in Portugal. He has published more than 200 scientific contributions and received a lot of rewards. And Professor Andre, you will have 25 minutes to deliver your presentations. Time and place is yours.
Thank you very much. So, okay, so it is late night in Portugal. This is a picture from my university during the day, but now it is 2:30 a.m. But I am very honored to be with you today. And I would like to thank a lot Dr. Marcela Elvina Siman Juntak for the invitation, and also my good friend, Dr. Nasser, from the World Association for Medical Law. He organized a wonderful meeting in Bali some years ago, and I see Dr. Marcela here in the screen.
Very good night, dear Professor
Yes.
Andre Dias.
Thank you.
Okay,
Nice to
thank
meet
you very much for your coming.
Thank you. I can share my, maybe I will share my screen so I can control easily what I say. Okay, to the audience with more than 100 people, so congratulations, it's a great success, this event. I will speak about digital healthcare transformation, electronic medical record, and personal data protection. And as you see, I am from the University of Coimbra, Portugal. So I am not from Rotterdam, and I am not Den Exeter, I am Pereira. I am also André, but first of all, I'd like to show you that we have a new basic healthcare law from 2019. I was part of the team that prepared this law, and we introduced a basis modern in the sense that, sorry, as you see, it speaks about information and communication technologies. It speaks about personal data, health information, and cybersecurity. Very, very important, cybersecurity nowadays. For example, our Ministry of Health was under attack 15 days ago, and we are not sure if our health information has been taken away. In fact, there has been a lot of cyber attacks in European countries. It probably has to do with the ongoing war in Europe. This is a real war in many approaches. So also the cyber war is very strong. And this reminds us of the importance of privacy and cybersecurity and personal data. But we must use information and communication technologies in a people-centered approach for improving the provision of healthcare, safeguarding equitable access to quality health services, and efficient management of resources. On the other hand, telemedicine, digitalization, is a way to improve people's access to health services and to maximizing working conditions of professionals and efficiency of organizations. What is telemedicine? Telemedicine is different from telehealth. Telemedicine is the practice of medicine using technology to deliver care at distance. There is one physician and there is a patient. Telehealth is a broad meaning of electronic and telecommunication and services used to provide care and service at distance. So telehealth is broader than telemedicine. In Europe, there are many documents about this, and European Communication has a broad definition. The health professional and the patient are not physically present in the same location. We can use it for teleradiology. Very, very important. As we speak, there is a lot of teleradiology going on around the globe. Indeed, there are radiologists in several parts of the world working for other continents. Myself, I have a niece. She's a doctor. Although she's working abroad in England, she works very often to Portuguese institutions through teleradiology. Teleconsultation is also going on very frequently, and telesurgery is much more complicated, but is also present. So the first approach is the following. I have here a mathematics formula. Medical law is a complex issue. Information technology law is also problematic. So with digitalization and telehealth, we have legal problems twice as much. So like the mathematics like to state. Now I will only tell you some deontological problems. When we have telemedicine, there is a problem of trust. There is a problem of the independence of the doctor. There is a problem of autonomy and confidentiality. There is a special duty of care of the doctor to evaluate information. And in emergency situations, the doctor is responsible for the decision to be taken. So the deontological code of the Doctors Portuguese Association has some interesting norms concerning telemedicine. And this is important to maintain trust, to maintain even with telemedicine and telehealth. That means keeping a human face. We don't want to be treated by a robot, by artificial intelligence alone, without feelings, without compliance. Secondly, there is a danger that the organization or other powers, economic powers, will take off the independence of the doctor decision. We want doctors to decide what is the diagnosis, what is the medicine, what is the treatment. And also telemedicine associated with artificial intelligence algorithms may endanger patient autonomy and also the doctor's independence, in the sense that the algorithms may push us to a certain decision, even if we do not agree with the decision. So we must keep the basic principles of medical ethics. The trust of the doctor-patient relationship. They must overlap a face-to-face consultation. And the doctor, a human doctor, must have a clear and justifiable idea of the clinical situation. Now we will move on into some legal problems. First of all, in order to perform telemedicine in Portugal, you need administrative authorization, as you need for any other medical clinic. If you want to open up an hospital, you need administrative authorization. That's the same if you want to do telemedicine, in the sense of having so it is not a free space. It is not a free online service. You need to have doctors and you need to fulfill the administrative procedures. Secondly, you must be especially attentive to data protection regulations. Informed consent, the medical prescription of drugs, and the telemedicine across European countries and liability. Let's take a look at these topics. A telemedicine company needs to have a physical address, and it needs to have doctors. Of course, we are not in the point to be treated by robots, by artificial intelligence alone. But I will tell you, we must fight, and doctors must fight to keep their profession. 15 years ago, if I wanted to buy a plane ticket to go to France or to Germany, I would go to a travel agent. Nowadays, with my cell phone, I can buy a ticket and fly with an airplane. Well, what does it have to do with telemedicine and telehealth? It has to do because the big companies want to move into the health market. The healthcare market is a wonderful market. It represents 10 to 15% of every country, especially developed countries' internal product. It's a big market, even bigger than war. That's why doctors are under great challenge to keep the market, because the information technology big companies want to take over these markets. That's why we still want doctors. In telemedicine, you need to have informed consent, but 3 informed consents, which are very different. The medical service, we must follow all the information, respect for refusal. But also you need consent to deliver an electronic service, and very often a consent to use the information, the personal information. So very often there will be 3 consents, but you should not make a confusion. The informed consent for medical service, for a prescription, for a consultation, for a treatment, for a chronic disease surveillance, is different from the consent for data protection, and also to have a digital service. Concerning the data protection, of course, everyone has the right to the protection of personal data, as the Charter of Fundamental Rights of the European Union states. And so we have here many legal values. You have the value of privacy. It is an old value. In the field of healthcare, you have the value of confidentiality. But now, in the last 30 to 40 years, the Council of Europe was the first to develop the idea, and many other countries, and now the European Union has the regulation, data protection. And this is an important idea. Data protection is different from privacy. They all come from the same basis. We can say that data protection derives from privacy, but their scope is different. Data protection, as you know, is a very detailed branch part of legislation with many sub-rights and a very specialized field. This act is a very important one. It is a regulation of European Union, so it shall apply to all the European Union countries directly, although also each country had to write down a specific law to regulate, for example, the age when adolescent may be in TikTok or Instagram. I don't know if Indonesia, what is more popular for kids, TikTok or Instagram. In Portugal, the legislator said you must be 13 years old in order to give your consent for this information technology industry. But of course, my children, they are 10 or 12 and they are all on TikTok. So at the end of the day, it is not working, the legislation. A very important idea is that even if you have a company in Indonesia, you have to fulfill the regulation on data protection. Companies based outside the European Union must apply the same rules when offering services or goods to, or when monitoring the behaviors of individuals within the European Union. Imagine you have a telehealth company in Indonesia with an app, a mobile app, and that I pay with my credit card your service. You are treating my data. You are treating my personal data. So you must fulfill the regulation of the European Union. This is very important. The ultra vires effect, the ultra border effect of the regulation. Another idea is the cybersecurity. We have specific legislation on cybersecurity. Naturally, all other European countries have legislation as well. And first of all, if you have a medical service on telemedicine, you are a digital service provider. Therefore, you must fulfill the rules of cybersecurity. And if there is an attack, you must notify the government. There is a special agency on cybersecurity. If your hospital is attacked, if your telemedicine clinic is under attack, you must notify this administrative authority there in order to protect from this terrible modern situation. It is very important to speak about European health data space. The European Union wants to create a European health data space, both to help people and to help science. To help people because, as you might have an idea, in Europe, first of all, you live in your country. So the most important approach is your country, especially in the health field. The policies are national. There is no power in Brussels to regulate health, or very few powers. But now, Brussels, when we say Brussels, we say the European Union, the European Commission leading this trend, wants to create a European health data space so that you can go easily from one country to another. And it is true that often people are moving around. For example, in Portugal, we do receive many retired people from France, Germany, the Netherlands, and they come to spend months and even years in our Portuguese sun. By the same token, unfortunately, we do have many young Portuguese people from all professions moving up to richer countries. My niece moved to England, my daughter is in the Netherlands, so we are losing good people to other countries. But this is life, this is the European Union, and this is an open market. And what is important is that you can keep your health information, your digital information, and bring it to your doctor in the Netherlands, bring it to your doctor in Spain, bring it to your hospital in Italy. And this is the way forward. Also, the prescriptions, the drug prescriptions, the summaries, the images, the image reports, the laboratory results, all this medical information, there will be a common European format so that doctors all around Europe can interpret and treat patients from all over Europe. And of course, a lot of other rules so that you can move around with your information. By the same token, this will speed up science, since if you have so much powerful information, medical information is very powerful. That is why 2 weeks ago, the Portuguese Ministry of Health was under attack. Probably spies, there is industrial spies, there are war spies, but there are also research spies. And if someone can get 10 million files in a cyber attack, it is useful for research. Of course, the European Union also wants to use this, but this is a problem for privacy and data protection. What they say, the access to such data by researchers, companies or institutions will require a permit from a health data access body to be set up in all member states. Access will only be granted if requested data is used for specific purposes, for example, to do research on cancer, in closed, secure environments, and without revealing the identity of the individual. So the idea of anonymized information. And this is very important. Can we use anonymized information for research? Can we use pseudo-anonymized information for research? Indeed, the regulation of 2016 already opened that possibility. The more progressive doctrine, and I do agree with that idea, that health information shall be used for research in order to improve science and improve medical services. Very important is the genetic information, because genetic information is a source of problems, since it might lead to discrimination, not only of the patient or the person, but also of his or her family. Secondly, it gives you information not only about the present, but also about the future. And you cannot change it, and you cannot change it. So that's why we have special rules to protect genetic information. Very important is to say that according to Portuguese law, as you already understood, health information is the property of the person and shall only be used for health care to treat the person or for health research if the person consents or if it is anonymized. Concerning the predictive information, the genetic information that you will have a genetic disease, for example, Huntington, for example, Machado Joseph, some ataxias, some other genetic problems where in 10, 15, 20 years, this shall be kept in specific records of genetic services, because you are not ill. You will be ill in the future, but you shall not be discriminated. Another problem in telemedicine is the prescription of drugs. Is it allowed? Yes. In fact, nowadays in Portugal, doctors are obliged to carry out the prescription of drugs by electronic means. They must use certain equipment, certain software that is recognized by the Ministry of Health. And also at European Union level, there is a recognition of medical prescriptions. This is very important. You are an old person from Germany who comes to spend 2 months of winter in Portugal, but you need to take your prescription. You need to go to a pharmacy. It is very good if you can use the German doctor's prescription, even if you can call or email your doctor and your doctor sends you a prescription and you go to a pharmacy in Portugal and get the drugs you need for your heart, for your cardiocircular system, etc., etc. This is very important. Finally, the question is, are we allowed to deliver telemedicine services to other European countries? And the answer is yes. The answer is yes. As a health services, telemedicine is included in Article 64(6) of the treaty and is a service, and so there is a general freedom of movements of services. This is one of the ideas of the European Union, that there is free movement of services. You can build a Portuguese entrepreneur, builder, can build a house in France. A German construction company can build a bridge in Spain. There is a general freedom of movements and services. By the same token, a Swedish doctor may provide services to an Italian patient through telemedicine. What is the problem? The problem is who pays, is payment. Because normally national health services, they don't like to pay in a cross-border relationship. If you have a health insurance, it is easier, and much easier if you pay with credit card. So if you pay out of pocket, of course, you can have health services through telemedicine. The problem is national health services, the state medicine does not pay telemedicine except in rare circumstances under previous administrative authorization, which will happen very rarely. A second problem of cross-border telemedicine is the language. As you know, in medicine, trust is paramount, and language is the basis of trust. That's why patients like to go to doctors in their own language, in their own nationality, because they feel trust, they feel safe. It's not easy for me to follow a Swedish conversation. I do not understand anything. Of course, a very cultivated people speak English and other, but this is quite rare. So this market is not important, although it is completely legal. And which law applies? The law applies is the law of the member state in which the healthcare provider is established. For example, I know that in Malta, a small country in the south of Italy, they do have strong telemedicine services, and it is completely legal, no problem. Which law applies? The law of Malta. If you create a telemedicine clinic in Portugal, Portuguese law applies. Important is that there is a European Union prescription model, and you can prescribe drugs to another country following this legislation. Finally, liability. Of course, telemedicine creates problems of liability. Criminal liability in you may injure the life or the physical integrity or the confidentiality, or you may falsify prescriptions, you may falsify documents. Of course, there might be criminal liability. There might be disciplinary liability, and of course, civil liability, as well as administrative liability. And we don't have to go into details. I thank you very, very much for the invitation. It was an honor. You're welcome to come to Portugal in the future. And I open for any question. So Dr. Andre Luis, as a doctor, you see that we want doctors to keep treating us, not robots.
Yeah, thank you. Thank you so much for your presentation, Prof. Andre. Well, my very bad to badly to not properly introduce your institution. My mistake to wrongly notice the same name of the second speaker, Prof. Andre from Netherlands, and your names happen to be Andre as well. Well, let me introduce your profile properly to the audience again. So this is Professor Andre Dias Pereira. He's a professor from the Faculty of Law from the University of Coimbra, Portugal. Am I right? And you are also currently serving as the Director of the Center of Biomedical Law from the same university, and also the Vice President and Counselor of the National Committee of Life Sciences, and also the member of Ethic Committees and Medical Legal Council of the National Institute of Legal Medicine and Forensic Science. Yeah. So we're still waiting for Professor Andre from Netherlands. Is Professor Andre from Netherlands on the online now or not? If not, probably we can continue to the discussions. So let me invite Professor Huang, and we will start with the Q&A sessions. Professor Huang, are you with us?
Yes.
Okay. So the audience are welcome to directly raise your hands if you have questions to Professor Andre and Professor Huang. And if you have questions, please mention your name and your institutions and to whom your question will be directed to. Anyone from the online audience who would address questions to Professor Andre and Professor Huang regarding the digital health regulation and legal issue in both country, and all the good practice sharing shared by both speakers. Okay, I see the Retno Mrati Hani, please.
Yes, thank you. Good morning. Thank you for the speaker for today. I want to ask to Prof. Andre Gonzalo Dias Pereira, PhD. Thank you for your presentation. I'm interested with HLIOS, where people in your country in control of their own health data, and they can share their data by themselves. My question is, what about people with disabilities? For example, seniors who cannot accept equipment, children, people with mental disorder, and abandoned poor. Is there any special treatment and how to collect their data to purpose example for public health. Thank you.
Okay. Thank you for your question. If I understood correctly, is about consent of children, consent of disabled people, and also other vulnerable people.
Yeah.
There are special rules concerning children. Normally, parents shall authorize the procedures, but if you are 16, 17, or even 14 to 15, your opinion shall be taken into account, and even you can decide in a lot of issues in when you are 16, 17, and also in the field of reproductive health and sexual health. There is also autonomy of the adolescent in order for them to come to doctors and to nurses to avoid other problems. Concerning handicapped, mentally disabled people, often elder people, and that is a big topic in Portugal, in many European countries, with an incredible aging population. And of course, the idea is to keep their autonomy as much as possible. So we defend and we are implementing slowly the ideas and of healthcare proxy, advanced directives, and also the so-called aging planning and healthcare planning, so that way, if you have Alzheimer or other dementia, you choose one child or a friend or a close person that will help the medical team to take the best decisions, and also that you nominate a representative that will help you also in financial issues. The legislation changed in the last 10 years. I will not go into details, but this is the idea, to promote autonomy at the end of life. And one way to promote autonomy is that you can choose which child, which person will best take care of you. Very often it's the spouse, very often it's a son, the daughter, but it depends on you and it depends on your will. Concerning other vulnerable population, it is interesting you spoke about poor people, which is a very interesting point of view, because in our discourse in Portugal and in Europe in general, we tend to forget poor people as vulnerable population. Now, so I learned we do have, there is the certain idea of the liberal autonomy, that every individual is free and has free will and has capacity, but you are absolutely true. There are socio-economic disadvantages that make you feel that this freedom and this autonomy is very theoretic. Well, what we can do is at the level of public policy, so to have a good national health service, to have free medical services, that is very, very important. And we do have a national health service where sometimes it's good, sometimes not so good, but it works. Well, so those are some answers to so thank you very much.
Thank you, Professor Andre.
Thank you.
is the questions well answered to those who ask? It's okay. Okay, if okay, and then let's continue with the next next participant who wish to ask questions. Is there any questions from the offline audience who wish to ask questions to both the speaker? For the online participants, you may raise hands if you have questions, and you can also submit your questions via the chat features and Q&A features.
Okay, thank you. Good morning, doctor. I have a question. My name is Yunita Rustiani. I'm from Indonesia. I have a question. Are there incidents of patient data leak in your country? Thank you.
Sorry, can you repeat the question again? Is there any incident of?
Incidence of what? I did not listen. Incidence of what?
Are there in your country are there incident of patient data leakage in your country?
So the incident of, is there any data on, sorry, is there any data or any report of the incident of patient data leakage to both country or just to one of the speaker, to both speaker?
What is data linkage?
Leakage. So
leakage data, doctor.
So it means the data is breached.
Okay. Yes. Well, very fast. As I told you, 15 days ago, the Portuguese Ministry of Health was attacked. We don't know details, if it was Russian attacks or whatever attacks. So probably my information was attacked. So the situation is really catastrophic. But there is a kind of a blackout on the news. The news, they are not speaking about it, but there is a lot. Secondly, small leakage, yes, it exists. For example, nurses and doctors. I will give you an example. The president of a football team, a soccer team, had a heart attack. In that night, 200,000 people, doctors and nurses, saw his medical file. It is a violation of confidentiality. It's a violation of data protection. But as you know, according to our system, doctors do have access to all files. They should not read the files except if they are treating you or if they are serving you. So doctors do not have the right to curiosity. However, this is a terrible example. It happened some years ago that in one night, 200,000 people went to see the medical file of that president of a soccer team. So it's a daily basis. We must increase ethics, deontology, and also punishment. There must be also some punishment and education of everybody, including doctors.
Thank you. So there must be law enforcement here to really ensure the data security, and it happens in Portugal. How about Professor Huang in Taiwan? Is there any incident for medical data leakage or medical data breach and get published to the public, which cause medical dispute to the public?
Cause medical, pardon?
Medical
breach
dispute
of
or
the-
any issue of the medical data leakage to the public.
Yes, the
Taiwan.
data bank was hacked by outside world, but so far we don't find the damage to the individual.
Okay.
Yeah.
So it happens, but there are no significant detrimental damage to the persons. Will there be any severe punishment to medical staff or any health facility who are proved to be not properly handling this medical data?
Also, if the the doctor or the nurse handle the EMD not in appropriate way and release the to the outside world or on the website, it happened. Yeah, some cases. Of course, such persons will be punished. Because now the people pay much more attention on his privacy. So they keep eyes, the society keep very close eyes on the personal data. Yeah.
Okay. In Taiwan, what is the legal consequence for medical professionals and health facility?
You mean the punishment?
Yeah.
Will be fined.
Or fines? Any
Yeah.
imprisonment?
If worse, of course, if the case is severe, the damage is severe, even to the penal code. We punish according to the penal code. Otherwise, usually will be fined.
Okay, so mostly the punishment is the fine, and if the damage is so detrimental and the penal code also.
That's the punishment from the government. Of course, inside the hospital, the institution, of course, they will take some measures to such people to
Thank
remove
you.
or to another position, maybe.
Okay, well, we have two participants from two online participants who raise hands. I will first invite Mr. Jaka Kusnata to ask questions to either of the speaker or to both of the speaker. Please, Pak Jaka.
Okay, thanks. Please allow us to ask Prof. Dr. Andre Pereira. Good morning, Prof. Introduce us Dr. Jaka Kusnata Wahyuntara from Pusdokes Polri. With the existence of electronic medical records in Indonesia, where medical record data can be accessed by the Minister of Health, meaning that many hands and eyes can access the medical record in the hospital. My question is, how is the implementation of medical scripts that, according to ethics and law, must be kept secret by doctors, hospitals, and those who can access medical record in hospitals? If you look at the current condition, especially in Indonesia, which is indeed in data security, it is still concerning atau amburadul bahasa kami. Thank you.
Okay, Prof. Andre. So this is Dr. Jaka from Medical Center of our national police institutions.
Thank you for your question. The idea is that the law must state that also informatic workers, administrative workers, and financial workers are also obliged to confidentiality. Therefore, if they have knowledge of health information from someone, keep confidentiality. And if they disclose that information to a newspaper, to relatives, to other people, it shall be punished. Secondly, the data should be organized in a way that you should know as less as possible. For example, those who pay the bills, the financial sector, they must know if a certain hospital provided certain services, of course. So they must be sure that a surgery was performed, a chemotherapy was performed, a treatment was performed. But they don't have to know the details of the treatment. So, and there is a whole field of research in the field of healthcare information, so that doctors have all information, administratives have less information, the financial sector less information. And there is also codification. But I'm sure that in Indonesia is the same. That is to say, the hospital will not say that Andre was treated to cancer. He will say that patient number X had a certain procedure that costs $10,000. And there is a language, a financial language. So two ways to protect. One is that all of those in the system who have the right to know, they must keep confidentiality. Secondly, you need to have different layers of information and only provide as few information as possible. So doctors will know the full information, but the financial sector does not have to know the full information. That's the way, if I understood.
Thank you, Prof. Andre. So there should be some level of data some level of data sharing and anonymity. So we, Dr. Jaka, are you happy with?
Yes, enough. Okay. Thank you very much.
Okay, so we will have we have two participants who raise hands. Bu Widya Ikawati, then after that,
Okay.
Dr. Nasser. Yeah,
Thank you for the opportunity. Introduce me, Mr. Andre and Mr. Huang. I'm Vidya Ikawati from Bandung Institute of Technology. Data is very important in the development of technology in the past, now especially in the future of era artificial intelligence. Without strong collaboration in data management in the field of engineering, we will not be able to produce technology, Mr. Andre. In my institute, very intense developing a telemedicine to collaboration between clinics and public to medical record free of charge. One reason is that artificial intelligence require data, but our goal is purely not commercial, but for the advancement of technology and science. My question to Mr. Andre, what is the clear mechanism in your country, especially, to be able to collaborate in assessing data? Is any there special constitutional or other? Thank you.
Okay, Professor Andre.
Thank you and congratulations for your work. I'm not pessimistic in the field of artificial intelligence. I'm optimistic I think it will bring us a lot of tools, instruments to have better healthcare. But of course, we must always point out some dangers and risks. And I want to have a medical doctor, to have a face, to have treating only a robot. But saying that, it is important, and we know that artificial intelligence is growing. And the idea is the subject, so the person may consent to offer his or her data to your company or to your hospital. So if there is informed consent, there is no problem. You can use the information. If there is no consent, it is still possible to use health data if it is anonymized. Of course, anonymized data may lose some importance for the researchers like you, because you want to know the full details of the disease and the treatment and the outcome. But still, there is a way. If there is anonymized data, we are, and I showed on the PowerPoint this European health data space. So they want to create electronic, there is already electronic medical records, and they want to have a kind of a European format of the electronic health record, and so that you can use all that information for medical research, and including artificial intelligence research. If you give your consent, you give your consent for research, and it can be quite interesting according to your characteristics. What is your outcome? What is, if the treatments worked, if the drug, well, all the work you do is interesting. So, that's my answer. It is possible with informed consent, and it is also possible without consent if it is anonymized.
Thank you, Prof. Andre. How about, oh, you still have questions?
Yeah. Are there any laws passed for this data collaboration in your country? Especially are there any laws passed for this data collaboration?
Yes. So the law nowadays is the European Union regulation on data protection. Yeah. Secondly, our constitution protects confidentiality, but research and medical research, scientific research is also a very important constitutional value, and therefore in this equilibrium we tend to accept this situation. Just then there is a special protection of genetic information. Genetic information is specially protected, but still also you can consent, and even if in some you can consent and you can use genetic information.
Yeah. Okay. Thank you.
Science must go on. We will all be healthy and live long. That is our mantra, to live long and healthy.
Okay,
yeah.
so
okay, thank you, very clear.
Yeah. Regarding the data collaborator and data collection by AI, Professor Huang, do you have any insight to share from Taiwan regulation and legal perspective before I come to the next participants' questions? Professor, you're muted.
Sorry. Yeah. You mean the data cooperation between the different institutions or what?
From artificial intelligence, the questions asked to Professor Andre before, is there any legal or any regulations to regulate the data collection or data collaborations by artificial intelligence in Taiwan legal and regulation perspective?
Pardon me, sorry. The sound is not so clear. Pardon me, would you please repeat, Mr. Luis?
Okay. It's the question from Ibu Widya to Prof. Andre. So I just wish to know if there is any. I wish to know the legal and regulations perspective from Taiwan perspective on the data collection or data collaboration by artificial intelligence.
Artificial. No, yeah. Sorry, maybe later I can answer the question.
Can you hear my voice, Professor Huang?
Not so clear. Yeah.
Okay. Is it clear now?
Yeah, it's better.
Yeah. So I repeat the questions from Ibu Widya to Prof. Andre. I want to know the perspective from Taiwan legal and regulations on artificial intelligence, collecting data and collaborating data from many platforms. How is it regulated in Taiwan?
Yeah, AI. You mean the AI?
Yeah, artificial intelligence.
Right now it's a very hard thema issued in Taiwan, and the new regulation is still at the age of the first age. Yeah? We under the administrative regulation, the parliament so far, as I know, has not enacted, and the regulation is still at the age of the administrative regulation. Yeah.
So it's really new and
really new, yes,
and hasn't been enacted by the parliaments in Taiwan. Okay,
yes.
So we will go to the next participant, my teachers, Dr. Nasser, please.
Yes, thank you, moderator. Dear Andre, how are you, my friend?
Very good.
Yeah, I'm
nice
happy that you look, yes, nice to meet you also. I'm happy that you look prosperous and healthy today. Yeah, you are fit, right? I have a question, Andre. What do you have to say, the point regarding the informed consent substance in EMR? Please. Thank you.
Informed consent in emergency
EMR.
Electronic medical record.
Electronic medical record. Okay. Very nice to see you, Dr. Nasser. Thank you for the invitation. And I wish you also health and good luck and all the best. So the informed consent for the electronic medical records. Let me try to understand. So the question is if there is a telemedicine, if you accept, for example, informed consent by putting well, it's
yeah, medical record.
So you need informed consent if you to speak to a doctor to give the information. You need informed consent if he prescribes a drug, and even if there will be telesurgery or teleradiology. Which is a good topic because most patients have no idea that the radiology service is done in other countries. As I told you, during the night, there are few radiologists working, and there are some companies working abroad. Sometimes there are even Portuguese companies with doctors from England or from other countries or even from India, and they do the service. Does the patient have the right to know that his or her information is in India or in Indonesia or in England? It's health information, which is private information, and is going outside the country and even outside the European Union. It's a very interesting issue. And I would say that there should be informed consent. Okay, concerning the electronic medical records. Well, if the state or if the system creates electronic medical record, and now it exists everywhere, you must accept it. Which brings us to a very interesting philosophical question. In the times of artificial AI, digitalization, and all these digital services, do we have the right to keep out of digital services? Do we have the right to say, no, I want a traditional medical record, I want a human doctor, I want a face-to-face consultation. I do not accept that the Ministry of Health or my health insurance company obliges me to have a telemedicine consultation or obliges me to have electronic medical records to avoid costs. No, I want it like it was 20, 30 years ago. There is a German thinker who says that we have the right to remain out of the digital world. But I think he is a poet. That's just poet. That will not happen. You will be obliged to live according to the rules of power and according to the rules of efficiency, including digital services. So if the Ministry of Health decides that to follow a diabetes patient, to follow a dermatology patient, to follow you don't have the right to go to the hospital. You must have a teleconsultation in your laptop so that you don't spend the risks of COVID, the risks of other flu, the risks of and the spending of having doctors in hospital. It would be an efficiency methods to implement more and more telemedicine. And I think it will happen even if patients don't want it, which will create another problem. And it brings us to the question that the colleague raised, the vulnerable people, the poor people, and people without education in information technology. Because it seems to be very easy to open up a laptop and to have a medical consultation or to have an academic conference with the other side of the world. But first you need electricity. There's a lot of people without electricity, and it's not only in Kiev, Ukraine, but also in other parts of the world. you need to have a computer, you need to have Wi-Fi, and you need to have skills, intellectual skills to deal with the digital health. So digital health brings us the problem of vulnerability of populations. And therefore, the question of Dr. Nasser is interesting. Do we have the right to remain digital medical records? And I think the government should provide medicine in accordance to the needs of the population. And there might be population who does not need electronic or medical record, but a human face, a nurse or a doctor who can treat them when they need. But this is more philosophical. Thank you.
Thank you, Prof. Andre. Dr. Nasser, do you have more questions?
Yes. No. Thank you, Andre. Thank you. My people in Coimbra. Thank you.
Dr. Nasser, may I extend your questions to Professor Huang to see Taiwan perspective? Professor Huang, can you share us the perspective of informed consent in electronic medical record in Taiwan legal and law perspective?
It's the judgment of the Constitutional Court. So far, the regulation of our personal data protection law, lack of enough regulation regarding the control of the individual about his or her personal EMD. It means the individual has no possibility to stop the use of his or her personal data. But about the informed consent, of course, it must be. But during the procedure, the individual, the subject has no right to demand the stop of his own personal data. That's why so far the constitutional law said this law in this case is unconstitutional and it should be amended within 3 years. And if the parliament so beyond this period, over 3 years, if the parliament has not finished the enactment, then the individual, the citizen, has a right, according to this judgment, to ask to stop the use of his personal EMD. Okay.
Professor Huang?
Yeah, you hear me?
Yeah, thank you. Thank you for your
okay.
explanation. So the Parliament hasn't really enacted very specific regulations on the informed consents for the electronic medical record. While in Portugal, it is required for prescriptions for teleradiology and telesurgery. Professor Andre. Okay. Now, any more questions from Professor Nasser?
No, enough. Thank you.
So we'll go to the next participants, Dr. Muhammad Irshad, who has raised hand from the online participants. Please, Dr. Muhammad Irshad.
Okay. Thank you for the time, Mr. Henry Lewis. I will ask to Mr. Andre Diaz, PhD, from Portugal. We know one of kind of electronic medical record is website basic. And then electronic medical record can access in many gadgets. One of gadget is personal gadget of the doctor. I will give the scenario of the problem. We can imagine, for example, when the doctor or if the doctor input the medical assessment of the patient in medical record, but the doctor don't visit the patient, mister. They work from home. I hope there is no problem like the scenario. But we must know how to regulate or how to organize the scenario problem. Thank you.
Please, Professor Andrew.
Well, we must, so telemedicine has many advantages. It can provide medical service to more people who live far away from the cities, or also bring specialists, knowledge of specialists, medical doctors who can cooperate with general clinicians. So there are many, many advantages. During the COVID pandemic also, worldwide, telemedicine was important to keep some medical services. But you are absolutely right. There are all the disadvantages of a digital service where you lose trust, you lose the connection, you lose empathy. It happens also with education. Nowadays, you go to a classroom and people are always with digital interactions and not paying attention to the professor. And even professors like me, when they are listening to a conference, we are always in different worlds. We're always looking at our digital life. It's absolutely difficult to deal with this. So what is the solution? The solution is to have, in fact, medical education, medical ethics, that we keep those values of trust and medical confidentiality, and that the patient is at the center of the system. And that we use telemedicine in the interest of the patient and not in the interest of the system, for example, the financial interest of the system or the interest of the doctor. Also very important is the data protection and the cybersecurity. And one example, in Europe, WhatsApp is very popular. Maybe in Indonesia it's the same. I don't know, I'm not sure, since it was bought by Meta, and Meta is, as you know, a Facebook company, and but well, in some countries it's not so acceptable. It's not, of course, the case of Indonesia. Indonesia is accepts Facebook, of course, and WhatsApp. But it is forbidden. The medical doctor should not use WhatsApp for telemedicine. Telemedicine should be done in proper channels, in proper informatic systems, with cybersecurity and with some dignity, with a lot of dignity, because the medical consultation is the highest standard of dignity. So you should not use WhatsApp or other media, of course not Messenger, but to have a proper situation. That's why I said that the telemedicine clinic or hospital should have a physical standing and should have an administrative authorization to provide services, and not an application that you do in the middle of nowhere, done by a robot or by non-doctors for patients. Thank you.
Thank you for the answer, Mr. Andre Diaz. It's clear for me.
Thank you, Dr. Muhammad. Thank you, Professor Andre. Well, due to the time constraint, we'll have to wrap up the first sessions. On behalf of the organizing committees, I would like to say thanks to both our excellent speaker who have delivered a great presentation and share their insights on electronic medical records and data protections from both countries. And I also would express sincere apology for any inconvenience from the preparations and the deliveries of these sessions. Thank you very much to both of you. Yeah.
Thank you.
Well, ladies and gentlemen, we will proceed to the second sessions of this seminar. The second session of the seminar will be chaired and moderated by Fiona Cristabella. Dr. Fiona, are you with us?
Thank you, Dr. Henry Luis. Could you hear me?
Okay. Yes.
Okay.
Well, let me briefly introduce her before I hand over the sessions to her. Fiona received her dentistry degree from Maranatha Christian University. She currently pursues her Master of Health Law at Sugia Pranata Catholic University and clinical dentistry rotation in Maranatha Hospital. Miss Fiona, I over this floor and time to you. Thank you.
Okay, thank you, Dr. Henry. Good morning, everyone.
Good morning.
Okay, welcoming you to the second session. It's the practice sharing on EMR and PGP. My name is Fiona, and currently I'm a dental co-assistant at RSKM Maranatha, and today I will be serving you as your moderator. Okay. And now you will be hearing the presentation from Professor Dr. K. Rajkumar on this very timely subject. But before we get started, I want to take some of your time.
Okay, so do you hear me?
Yeah.
Okay.
Yeah, Prof.
Yes.
Good morning.
Yeah, very
Prof.
good morning.
Rajkumar Kanan.
Yes, very good morning.
Nice to see you, and thank you very much for your coming for the seminar.
My pleasure. Yes, yes. Still, I remember my visit to Unica just before the pandemic in 2019. Yes.
Thank you.
Okay. Before the presentation started, I'm gonna read a little bit of the curriculum vitae of the Professor Dr. K. Rajkumar. So this is the fourth international speaker as a Professor Dr. K. Rajkumar, Associate Dean, International Relations Coordinator Department of Data Science, Bishop Harper College, India. The educational background, PhD in Computer Science, National Institute of Technology, Tiruchirappalli, Master of Science, Computer Science, Bharat Widyasam University, Tiruchirappalli, and Bachelor of Science, Computer Science, Bharat Widyasam University of Tiruchirappalli. And the working experience, it's the Dean General International Relations, Bishop Harper College, Tiruchirappalli, Professor and Head Department of Science, Relation, Bishop Harper College, Tiruchirappalli, Professor and Head Department of Computer Science, Shift 1, Relation, Bishop Harper College, Tiruchirappalli, and many more. But to minimize the time, now I let Professor Dr. Rajkumar to start the presentation.
Okay.
And yeah, for the audience, now you will be hearing the presentation from Professor Dr. K. Rajkumar. On this time, the Professor, time is yours.
Okay, so thank you for your kind introduction. Yeah. So by the way, I'm Rajkumar from Bishop Heber College, Autonomous Tiruchirappalli, in other words, Trichy, India. I work as a professor of computer science and department chair for the Department of Data Science and the Department of Computer Science as well. Besides, I am the Dean for International Relations Operations in our institution. And today I'm going to talk about the India standards for electronic medical records or electronic health records. So the outline of my talk, I would introduce the audience, the basic objectives and background of electronic medical records, and a few benefits of electronic medical records and the standards that are followed in India. And I will explain a little bit about the data set types that are required for creating, maintaining, and archiving electronic medical records. I will also explain a little bit about the details about the hardware requirements, storage and archival requirements, as well as software standards that are required to be maintained, to be followed by the industries. And then I will touch about ethical issues, privacy and security issues for the creation of electronic medical records in India. I will also tell you a little bit about the mobile electronic records as well. So the members of the task force for creating electronic medical records that were constituted in the year 2013, there are three different groups for creating standards. One group will focus on the standards that are required for maintaining electronic medical records, and the second group will concentrate on the connectivity requirements, and the third group will focus on the ownership requirements. So these are the different elite renowned experts from industries, from academia, and from startups, from different governmental agencies from the government of Tamil Nadu. And the group head for standards is Dr. S.P. Mani, is the head of the standards requirement from Tata Consultancy Services India. And the group head for data connectivity is Mr. B.S. Bedi. He is the scientist from CDAC, Government of India institution. And the third group is chaired by Professor Saroj K. Misra, is from SGBGI. So he focuses on the ownership requirements. And what are the objectives of the electronic health records or electronic brain records? We can identify few objectives. So because you see the healthcare requirements or healthcare systems are really complex. They are very complex in the size, variety of data, voluminous, voluminous of the data, and variety of data. And also they are fragmented in the sense they spread across many different types and which are to be integrated. And also when the different vendors who create electronic medical records, they follow their own standards themselves. And thereby, it's very complex for the government of India to integrate the different standards that are used by different vendors of the devices. Okay, and obviously the details of the patients, okay, they are kept in many different silos, many different types, many different places, and many different ways, and it becomes very complex to connect them, to integrate them together. And also there are a couple of things that are to be concentrated on: the standardization, integration, as well as the exchange formats of electronic health records, different formats that are to be followed. So these are some of the objectives of the standardization process. And if you look at the healthcare background of India, so India has witnessed substantial growth in the healthcare side, in terms of the quality, in terms of the capacity as well. And not only that, because of the low cost of creating, maintaining, and distributing healthcare products, services, and systems, India has been a major destination for healthcare services. So obviously, what happens, there are a very large number of service providers and service sectors, okay, and obviously they contribute to the GDP of the Indian financial system. So obviously, besides the requirements from the perspective of the vendors and the consumers, and the usage of information communication technologies in India is vast. So it's extensive use, and obviously, and we need systems to standardize these details of patients and service providers as well, in terms of the policy definitions and policy requirements. And also, there is a requirement from the computational perspective. We call it like interoperability. That means you need different systems, different devices, different services in terms of software and hardware. They need to just collaborate, cooperate with each other. And that is the idea of interoperability, and data that is to be shared among these different vendors and devices. So some of the benefits of electronic medical records or electronic health records is you have 24/7 access from anybody, anywhere, wherever you require, whenever you require, you will be able to access the details, access the records of the service providers and service consumers. And the decision making is very easy. It has become very easy because you have data at your hand, and also follow-up will be very much easy. As you have data, and as the healthcare practitioners have real-time information about the consumers, so follow-up would be very easy, and automation can be 100% possible for the follow-up. And also, it's a level of convenience. So if you have data at real time in your hands, so it's very easy, very convenient than maintaining your data on the files or paper-based ledgers and files. So to summary, the benefits for the electronic medical records is a paperless medical history, and healthcare cost is substantially reduced, and all stakeholders can collaborate with each other, and evidence-based medicine that is possible, and you can also accelerate it. It accelerates the research and building or creating a better medical practices. So these are some of the benefits of maintaining electronic medical records. So health information about patients, so that can be maintained properly, and taking backup in terms of voluminous data in hard devices or in cloud servers has been very easy and easily maintainable. And then obviously it also improves as an overall experience in terms of the patient's health, thereby increasing the lifespan of the patients. And safety, that is 100% possible with proper access and proper audit examination, as well as proper maintaining a proper level of authentication control that is possible. Authentication means you specify whom can be accessed, okay, when can they access, okay, and so on. That is possible. We can set up the different levels of authentication to the data, and then faster search and faster updates or faster changes. That has become very easy. So if you look at the recommended healthcare IT standards for India, so these are some of the healthcare standards, like unique health identifier. So that will be something like a patient ID that is to be required. And XML is the data sharing, okay, format that has to be followed. So, you know, XML is the extendable markup language. So that specifies data that should be created based on the XML, okay, type. And then that is for data, okay, exchange. And then is RxNorm or ATC, that is the drug classification standard that is to be followed while creating electronic health records. And you have a couple of other standards like FDP standard from USA and Indian drug classification list that is to be followed. So these are some of the drug classification standards that have to be followed while creating medical records from India. And for messaging, it should use at least HL7 protocol version 2 at least. And for disease classification, vendors have to follow WHO standard for the disease classification 10, ICD-10 protocol recommendation. And the architecture, so this ISO architecture has to be followed, architecture number 18308. And also EMR vendors should follow the European standards called the CEN and Technical Committee 251 13600. And then it should follow American standard for testing and materials for continuity of care record. And then the messaging HL7 platforms to be followed. And then from the Indian perspective, National Electrical Manufacturers Association, NEMA standard for ICT in medicine has to be followed. And then ONCHIT is the recommendation from US for electronic health record for the meaningful use. So these are some of the standards that are to be followed while creating electronic medical records by Indian vendors or anybody. And the issues and the trends, there are a couple of issues, okay, that are to be considered in future. That is unique identification. Obviously, since there are various kinds of data and then devices, and obviously everyone will use their own IDs. So unique common ID, okay, would be highly recommended. And interoperability issues have to be still considered, and integration to be carried forward, and ethical, logical, privacy, security issues, technical issues, and these are some of the things that needs to be improved. And common record architecture, and you might see we use only XML. Probably in future a common architecture would be much more required. And then protocols to be improved. Protocols are nothing but the set of software programs that specify what to do and how to do. And then these are some of the issues that are to be focused. And then there is a trend going in the direction of the national ID for healthcare and distributed electronic healthcare concept that is being emerged. So distributed architecture or distributed health record means like, so you want to just spread your data and information to multiple cloud servers across the globe. Thereby, it minimizes the physical requirement of maintaining data in one location. And the minimum data features that are to be used. So obviously, all the vendors should use only alphanumeric characters. So alphanumeric characters means is a combination of letters, alphabets, and the numbers 0 to 9. So obviously, when data can be created with alphanumeric type, data can be created with numbers as well as with alphabets. And patient details are must, such as ID, and the name of the patient, date of birth, age, gender, occupation, address, phone number, email, and so on. So these are some of the details about the patient and details about the caretakers and the emergency contacts and details about the insurance information and clinical information about the patients and diagnostic details. So these are the minimum number of features that are to be used while creating or while maintaining the electronic health records. And the medication details of their visits, name of the drug, medicine name, and all those things, they have to be included in the while creating the medical records. And the hardware requirements, so it should follow the hardware protocols specified by the Bureau of Indian Standards, BIS, NEMA, ISO standards. Okay, and these are some of the standards that have to be followed while creating a hardware infrastructure. That means while purchasing servers, while purchasing workstations, by purchasing connectivity, and so on. And then proper backup and data preservation methods have to be used, and system redundancy have to be ensured. That means system redundancy means if one server goes down, one server fails, then backup alternate servers have to be ready. So thereby there is no delay in providing services to the community. So redundancy have to be avoided at multiple levels, from the data disk level or power electricity level or network internet level, and so on. And then proper network and data security protocols have to be created and then maintained. So that is another requirement. And then hardware should be checked. Periodic checkup of the hardware is must. And then the capacity and quality requirements of the organization is to be maintained. Also, updates, periodic updates is necessary, and upgrades is necessary. That means periodic updates may be once a week or once in a few days or every day. So whatever it is, so that has to be updated. And networking, so it's essential, internet, LAN, WAN, okay, and different mobile protocols like CDMA, GSM, and so on, and cloud computing, all those different networking and connectivity features are mandatory, and they should follow while maintaining, archiving electronic medical records. And the system should be fast enough, reliable as well as fast. That is a requirement. And besides, it should provide an appropriate, acceptable level of user experience. So when I say acceptable level of user experience, users, that is patients or others, should not complain about the delay of the services, delay of running the program, delay in terms of uploading data, delay in terms of the conversations. So all these things should be taken care of, and users should feel an adequate level of satisfaction while using their system. And then data exchange should be done properly and also securely. So secure data exchange have to be followed. So appropriate encryption standards have to be followed. And the softwares, obviously, as I mentioned in the previous slides, and while creating softwares, it should be interoperable, and it should maintain the privacy and security of the users, and it should provide an advanced level of search, merge, that is combining data and dividing data, and properly maintain medical records, and digital archival is necessary, in terms of the physical network or physical systems such as huge hard disks or at the cloud service. And then the software should provide the medical or clinical summary of the patients about their visits whenever needed. And then rapid data capture, yes, because the system has to upload very big size files in terms of images, videos, and other X-rays, scans, and everything with the high resolution data. So the data archival should be very fast, should be rapid as well, should be as quick as possible. And then the softwares that are created for maintaining electronic health records should follow a proper user authentication and authorization. When I say proper authentication means only the right people should access the right data. Only the person responsible, only the person who owns the data should be able to access the data, but that is the level of the authentication required while creating softwares for electronic medical records. And also, recently, electronic medical records are created, populated, shared among mobile devices. So from the perspective of mobile data, the electronic health record should include all the features that are required for the exchange of data between mobile devices. So all the quality standards of the healthcare, basic information about the patients, medical condition, everything should be available on mobile phones. And it should share the basic details, medication details, and all the different devices that are required by the patients or also by the providers should be properly maintained and properly shared among the mobile devices. So obviously various data compression methods have to be followed up. And finally, as far as the mobile electronic health record is concerned, it should satisfy the requirements of the mobile governance. So it's called the M governance guidelines given by Government of Tamil Nadu. And there is a unit called the DEITY, DEITY, Department of Electronics and Information Technology. And so all the mobile electronic health record, okay, vendors have to follow the guidelines given by the DEITY, Government of India. And all the ethical issues, legal issues, social issues have to be followed as outlined in the protected health information or electronic protected health information such as passwords and disclosure rights or disclosure approval and masking data or masking some private data, okay, while distributing. For example, like in India, we use a common identifier called Aadhaar, and AADHAR. Aadhaar is the number, and that cannot be shared. That is to be masked whenever data is being transmitted over network. And then proper digital signatures should also be maintained, created and maintained.
Sorry, Prof. Sorry for the interruption, Prof. You have 5 minutes remaining for the presentation.
Okay, yeah, thank you.
Okay, thank you.
Yeah, and then data privacy and security issues. So in terms of access rights and in terms of the audit, maintaining logs of audit and automatic log off should be available and authentication should be available. Encryption, proper encryption protocols have to be used and physical safeguard and redundancy have to be properly eliminated. And this is the list of electronic medical record standards, Indian standards, and the name of the item and then the details. Okay, so just to give you a glimpse of those details. And various protocols from ISO standards and data exchange standards and other standards and treatment summary standard provided by Medical Council of India to be followed. And these are some of the additional supportive standards from ISO that is to be followed, okay, in India. Yeah. So today I have just given highlights of the Indian standards that are to be followed while creating electronic health records. And I've given an overview of the Indian standards, benefits of electronic medical records, and the different standards in terms of software, hardware, and network devices, and also the disease types and classifications. And also I outlined the attributes that are to be used as a minimum set of attributes that are to be used while creating electronic medical records. Thank you. These are some of the references. So my reference is from Electronic Health Record Standards for India, Ministry of Health and Family Welfare, 2016, and all other references that are used while creating this presentation. Thank you.
Thank you, Prof, for the super great presentation. And for the audience who has the question for the Professor Dr. K. Raj Kumar, you can keep the question and then you can forward the question letter at the Q&A session. And next, we move to the fifth international speakers. Okay. I will read a little of the speaker's profile. The fifth international speaker, Roberto P. Villanueva, MD, JD, Chair of the Department of Legal Medicine, College of Medicine, West Payasa State University, Philippines. And for the educational background, he has Biological Science, West Payasa State College, Doctor of Medicine, West Payasa State University, Residency Training in Pediatrics, West Visayas State University, Bachelor of Laws, converted to Juris Doctor by Legal Education Board, Memorandum No. number 19 series of 2018. The work experience, I will read the top 3 of the list. Associate Professor, College of Medicine, West Visayas State University, Chair Department of Legal Medicine, College of Medicine, West Visayas State University, Associate Professor of College Law, West Visayas University. And now we will be hearing the presentations of Dr. Roberto. Dr. Roberto, the presentations will be given time for 25 minutes, and then now the time is yours. Sorry, you have unmute the microphone.
Okay.
Okay.
Yeah. Thank you, Fiona. Thank you for that introduction. Yeah. So let me share my slides.
Good morning, Dr. Villanueva.
Yeah. Good morning. So as mentioned, I come from West Visayas State University. So as mentioned by Fiona, I come from the West Visayas State University that is located in Iloilo City. Iloilo City is actually located in central Philippines in the island of Panay here. So this is Iloilo City, and the Western Visayas region comprises these 2 islands. Okay, so Panay and Negros. So we come from that area. So West Visayas State University actually has a total of 7 campuses with a total of 21,650 students. And we also operate, our College of Medicine operates the West Visayas State University Medical Center which has 11 clinical departments. Okay, now I will now go to my lecture proper. So we were asked to talk about digital healthcare transformation, electronic medical record, and personal data protection. So it's a good thing that that the previous speaker was the IT expert. So I don't really have to explain so much about electronic medical record, but for completion purposes, I just state that briefly. Well, electronic medical record is actually an automated systems based on document imaging, and the systems developed within a medical practice or community health center. So the patient identification details, medications, prescription, generation, and laboratory results. These are all the contents of proper electronic medical record. And usually, as mentioned by the previous speaker, the digital version of the healthcare information is recorded by the doctor during each patient visit, starting from the very first visit. The electronic record system may also be found not just in individual clinics, but in the hospital. Okay. So the advantages, as mentioned again, we have quick access. These are just a few of the advantages. The previous speaker actually was more, had a complete list. So, it gives quick access. Storage requires less space and manpower, easily secured, and it is easily managed and easily shared. But with the advantages come with it certain disadvantages. And at present, however, here in the Philippines, the use of EMR is mostly limited to large private medical facilities and medical practitioners in Metro Manila and Metro Cebu. Remember that Iloilo is probably the third or fourth largest city in the Philippines, but the first two are Manila and Cebu. So most of the EMR, most of the doctors and hospitals who use EMR are found in Manila and Cebu, and probably to a certain extent Davao, which is in the southern part of the Philippines. Okay. In fact, we have the government hospitals under the Department of Health had for several years have a system called the HLIOS, or the Integrated Hospital Operations Management Information System. However, the data that is included here are mostly patient details, mostly patient's name, patient's address, contact number, person responsible, again, insurance details, etc. So that is just the contents of the HLIOS system. No patient data whatsoever. However, the HLIOS Plus, which will now include the electronic medical record, will be piloted at our medical center, West Visayas State University Medical Center, and a few selected hospitals in the country starting next year, hopefully. But I hope that they can actually implement this, because the planned implementation actually was supposed to be 2020. However, as is the common experience here in our country, there's always a delay when it comes to government programs. It's sad to say, but that is a sad reality in our country. Okay, now, with regard to electronic medical record, there has been several studies. Well, a study in 2020 by Victor Michael de la Cruz et al. Entitled User-Centered Approach to Developing Solutions for Electronic Medical Records, Extending EMR Entry, showed a mean system user suitability score of 70.76%. The threshold here, or the passable score is 70%. So the score of the Philippines is actually lower than the result of a 2013 study by Xia in the sub-Saharan Africa, which even then already gave a score of 77.5%. The sad fact was that in the Philippines, in that study, some respondents even scored lower than 40. Okay, so among the problems, among the respondents, only 62% answered that they were confident of the technology. 28% showed that they were only somewhat confident of the technology, and 10% were not, in fact, confident of the technology. So what were the issues that were identified that led to the low adoption rate? The first would be the availability of service due to connectivity problems. I don't know how it is in your country, but in the Philippines, we really have, of course, in the urban areas like in the large cities, major cities like in Iloilo City, we have good connectivity problems. However, when it comes to the municipalities in the provinces and even in smaller cities, there are connectivity problems that would lead to low adoption rate. Okay. Second is interoperability. There are so many systems that there are so many companies that are trying to create their own system, and the problem of interoperability comes in. The third issue that led to low adoption rate is slow typing speed of doctors. And the fourth is redundancy. I have seen some hospitals here where they are trying to adopt EMR, and even in some clinics where some doctors have already EMR, but even then they insist on having another separate record using pen and paper. So there is redundancy when you have, because they have both the electronic record and the paper record. Okay? So also the study concluded that there is also a need of more policies and infrastructure, both electronic infrastructure and electronic and physical infrastructure when it comes to adoption of EMR. There are very few policies actually when it comes to electronic medical record in the Philippines right now, but I will just discuss them later. So among the barriers also, another study in 2017 by Ryan Ebardo and Nelson Celis showed that there are three types of barriers. The study was entitled Barriers to Adoption of EMR in Select Philippine Hospitals, a case study approach. And they found out that among the barriers, the technological barriers included complexity, second, the weak infrastructure, and the third is poor interface design. The second, for the organizational barriers, we have the user interface, user resistance, and unskilled IT staff. Now, as I said before, there is user resistance. That is why probably there is this redundancy in the clinics. The third is the environment itself, where we have privacy regulations and medical school orientation. In medical school, I teach in medical school, and we really haven't taught. I think that's one thing. That's one thing that we should look into. Training students and even resident physicians to do EMR, because even now, even in hospitals, and even when students do their internship in the hospitals, they still use paper records. Okay, so with regard to privacy regulation, the problem here is privacy regulation, which I will discuss in a few moments. There is this regulation, there's this law in the Philippines with the Data Privacy Act of 2012. The law actually states that the Data Privacy Act of 2012 established the National Privacy Commission, And the National Privacy Commission was tasked with creating the IRRs, or the implementing rules and regulations within the year. However, they were only able to release that IRRs on August 2016. And the IRRs were to take effect 1 year after the IRRs were take effect 1 year after the publication, so 2017. And that was during the time when all the medical practitioners were really afraid of Data Privacy Act. And because of that, they were also afraid to shift to electronic medical record, because at this time, because this study was done in 2017. Okay, another study by Aclaro et al. So this was entitled Microanalysis Approach in Understanding Electronic Medical Record in Rural Communities, Comparison of Views on Performance Before and During COVID-19 Pandemic. And it showed that these were significantly dependent on the performance of the rural health units. So the COVID-19 actually either in some instances significantly increased the usage. However, in some it only decreased. And there was extremely uneven level of implementation. Thus, however, the most common features used in the EMR was only the patient profile and the add patient feature. So meaning the EMR, the data in those EMR, the so-called EMR in the rural areas, which would probably include iHomes, is just the patient profile. And another most common use is, of course, when they want to add additional patients. So in that case, it was not really a proper electronic medical record, because patient's clinical data was not really included. Here in Iloilo City, out of the six largest hospitals here, only one have a proper EMR. Okay, there's another one. There are 3 others that use iHomes, but as I said, that's purely patient details. And for clinics, mostly in-house, they are not connected to a service provider, so they just have somebody make an application in their computer and probably do that, have the patient's data and some type of clinical record, and that's it. But there's no interconnection with other service with a service provider. Okay. Now, in the province of Iloilo, aside from the DOH or the Department of Health hospitals which use iHomes, no private hospital facility use EMR. Okay. Now, this is despite the Republic Act 11223, which is the Universal Healthcare Act. In the Universal Healthcare Act, there is a provision there that states that health service providers and insurers are required to maintain a health information system. So this health information system is supposed to include, among other things, enterprise resource planning, human resource information system, electronic health records, electronic prescription logs, electronic health commodities logistics management information, and these are supposed to be electronically uploaded on a regular basis through interoperable systems consistent with the standards set by the Department of Health, PhilHealth. The PhilHealth is actually the national health insurance system of the government. So they have to be interoperable with that, with those agencies. And this establishment of this health record system, electronic health record system, should be done in consultation with the Department of Information and Communication Technology and the National Privacy Commission. However, again, while this Universal Healthcare Act was was supposed to be implemented even before 2020. Most of the clinics here from my colleagues in Iloilo City, they do not have, they are not connected with, they're not yet connected with the DOH and PhilHealth. So again, the implementation is not yet 100%, even up to now. With regard, however, as mentioned, that one of the advantages of electronic health record is easy data sharing and storage. However, these advantages will also result in some problems, and this major among these problems are the resulting confidentiality issues, which usually arise when there is when you share data or when there is a problem with the way you secure your data. Okay. Now, we have in the Philippines, we do not have a law which is specific for medical records, for the confidentiality of medical records. However, we have the Republic Act 10173 or the Republic Act or the Data Privacy Act of 2012. This was from the implementing rules and regulations, were only promulgated on August 14, 2016, or a delay of 3 years. So because they were supposed to be promulgated 2013, so there's delay, and it was the IRRs were only promulgated in August 14, 2016, and the IRRs were supposed to be effective 1 year after publication. So what is the policy, the declared policy of this Data Privacy Act? The declared policy is that it is the policy of the state to safeguard the fundamental human right of privacy of communication while ensuring free flow of information for innovation, growth, and national development. So it must be stated that it was implicitly stated in the declaration of the Data Privacy Act that there is the recognition that the law may provide, while the law is to provide the right, is to protect the right of privacy of people, of the population, it also has to ensure that free flow of information should be ensured in order to, and so that there will be freedom of the press and there will be easy access for research to help in national development. Okay, now, what are the things that are to be safeguarded? So we have personal data, and personal data, I'm sure you also have your own privacy laws in your respective countries. So personal data may be divided into personal data, personal information, and sensitive personal information. I'm not going to discuss the difference anymore, but suffice it to say that personal information will only refer to information that will allow you to be identified, whereas sensitive personal information will cover more, will include health information, educational information, etc. So many other things, even civil status, age, sex, profession, except if you are in the government. Okay. So who will be the persons who are supposed to process data? This will be the personal information controllers. And who are this? These are these are individuals or corporations or another body who will control the processing of personal information. In other words, he is the person who will decide what type of information will be obtained, how will it be obtained, how will it be secured, when will it be destroyed, etc. And the other one who will process data will be the personal information processor. These are corporations or persons who give service, who are service providers who will process personal data for the personal information controller. And this will now include the electronic medical record providers. Okay. So
sorry, Dr. Roberto, for the interruption, but the presentation time is only 3 minutes remaining.
Okay, so I'll just go directly to the rules now. So there was a question before about consent. Now, so I'll just take this because there was a question about the consent. In the Philippines, we don't have a specific consent for electronic data, for EMR, but we have rules on electronic evidence, and it says that electronic document shall be regarded as an equivalent of an original document. So if you have an electronic consent, then that consent shall be equivalent to an original document. There are other rules here, the manner of authentication, the disputable presumptions in the Supreme Court. We also have to have security measures under the Data Privacy Act, which consists of organizational, physical, and technical, which its aim is confidentiality, integrity, and availability. What is important is with organizational measures, the organization should appoint a data protection officer, conduct a privacy impact assessment, and create a privacy management plan. This privacy management plan should include a privacy policy, which should be seen by everybody in the clinic, in the hospitals, or even in the offices of EMR providers. Okay, then this privacy impact assessment and privacy management plan should be regularly reviewed and monitored, and there should be regular monitoring of privacy policies. This, by the way, are part of the provisions of the Data Privacy Act of 2012. Like I said, the Data Privacy Act is not specific to health laws, but it includes health data protection. The National Privacy Commission also have circulars 1601, where they have recommendations on what type of encryption is supposed to be done. I'm not an IT expert. Perhaps Professor Kanan can enlighten us later about this AES 256. Then there is also what to do when there is data breach. You have to report immediately if there is a data breach. You have to report within 72 hours within the knowledge of the breach based on available data, and you have to submit a follow-up report within 5 days from the knowledge of the breach. Okay. Contents, what are the nature of the breach, what sensitive personal information was involved, measures taken to address the breach, and contact details of the contact person, plus instructions on how to get further information and recommendations to minimize the risk of to data subjects. Also, if you are a PIC or a PIP, or you are a person who is processing data, you are supposed to register your systems with the National Privacy Commission, especially if you have a firm with 250 employees, or even if your company has less than 250 employees, but you are processing data every day, or almost every day. And or if you are processing records with sensitive personal information of more than 1,000 or more. Okay? So if you're processing more than personal data of more than 100, numbering more than 1,000, you are supposed to register your systems with the National Privacy Commission. And how do you register? You include those, plus you include your privacy impact findings in your privacy impact assessment and in your privacy management plan.
My apologies, Dr. Roberto,
Yes.
because
Okay,
of the time limitation. Maybe you could move immediately to the conclusion. Thank you.
Okay, so the conclusion is that we have separate laws for separate subjects, for not specific for health laws, but we have laws on privacy which are applicable to health information. which we use when we do when we handle health information, especially when it comes to electronic medical record and when it comes to handling data, when it comes to clinical research. And another takeaway here is that the use of electronic medical record is still a long way, has still a long way to go in the Philippines. So thank you very much. By the way, this is Boracay, Aklan, which is just near our island. This is a famous resort. Thank you.
Wow.
This is also located in Western Luzon.
Hope we could visit the Boracay.
You will be welcome. Just contact me.
Thank you. And thank you for the excellent and the super informative information. The audience maybe have the question for you, but we could talk at the Q&A session later.
Thank you.
Now, because of the time limitation, we gotta move to the next session, to the next speaker. The sixth international speaker, Dr. Marcella Elwina Simanjuntak, Bachelor of Law, Candidate Notary, and Master of Humaniora, Faculty of Law and Communication at Unika Sugiya Maranatha, Indonesia. The work experience of Dr. Marcella, Associate Professor, College of Medicine, with the curriculum vitae.
Yeah, and I think that's mine.
Mine. Yeah. It's okay.
Yeah. Okay. Sorry. Okay. Dr. Marcella currently works at Faculty of Law and Communications Sugiya Pranata Catholic University, Semarang, Indonesia, since 1994, and the Dean of Faculty of Law and Communication since 2017. The latest education law doctorate program at Diponegoro University at 2010. And then the additional activities or courses of Dr. Marcella is visiting lecturer at Tunghai University, Taichung, Taiwan, and then Summer Institute, International Higher Education and Leadership Development, Western College, Chestnut Hill, Massachusetts, USA. And then the summer course, Leadership and Management for Integrity, LMITG Integrity Policy Lab, Summer University Program, Central European University, Budapest, at Hungary. And Dr. Marcella, you could start the presentations.
Yes, I think yesterday I asked the committee to display the PowerPoint presentation. Could anybody? Okay.
Okay, time is yours.
Okay, so very good morning for all distinguished keynote and guest speakers and also all seminar participants. Greetings from Semarang, Indonesia, and may I extend a warm welcome to you to the seminar. Though our rector already given the opening speech, before beginning my presentation as a Dean of Faculty of Law Communication of Sugiya Pranata Catholic University, I personally and our institution, especially Health Law Master Program, are most gratified to see all of you here in our seminar. And I also send my gratitude to the committee that allows me to present my presentation today. Okay, my name is Marcella Elwina Simanjuntak. You can call me Marcella. I work and teach at the Faculty of Law and Communication of SU in Semarang, Indonesia. Okay, I cannot see the because it is a black. Okay. Okay, The paper presentation is issues and challenges in Indonesia, as we have a new hot medical record regulation. I will I will tell you later. The title of my presentation is E-Medical Record Regulation, Issues and Challenges in Indonesia. Okay, unlike Taiwan, Portugal, or maybe the Netherlands that have developed sophisticated regulation for EMR, as presented by the former speaker, Indonesia is just to begin the transformation onto electronic medical records. India and the Philippines might have, I think, the same issue as and challenges like Indonesia, as the demographic and geographic condition or situation is mostly the same. Yeah, the first may be lower cost of healthcare. Yeah, but India, I think, as Professor Rajkumar Khannan already presented, have moved forward, as it is already have the law from 2030. Yeah, according to him. So they already have a very sophisticated law. And also the Philippines, yeah, but maybe the situation is almost the same because of the geographic and demographic situation. Okay, next. Okay, this is my CV. Okay, you can skip this one. Okay, the basis legal framework for our health rights would be traced to our constitution. This is some of articles in our constitution and national laws, like the one I have in this PPT presentation. And yeah, we have the article in our constitution that we are entitled to receive health services, the right to good and healthy environment, and then the rights to health, access to health resources, access to healthcare, self-determination, healthy environment, health information, education, and so on. And also it is the duty or the responsibility of the state to promote, to respect, to protect, and to fulfill these rights. And one of them is provide the quality of health services. Okay, next. Okay, this is also the personal data protection legal framework. It is also written in our constitution that everyone has the right to personal self-protection, including personal data protection. And also the law, the health law also said that everyone has the right to confidentiality regarding their personal health condition. We have also some laws about administration of population, which we call Adminduk, administrasi data kependudukan. It also said that personal data is certain or specific individual data that is stored, maintained, and confidentially protected. So is the medical record then. Okay, next. This is also the legal basis of framework for the personal data protection. We have information and electronic transaction law that in its article, it says that unless otherwise stipulated by laws and regulation, the use of any personal data information through electronic data media needs the consent of the person concerned. And also everyone whose rights are violated can file a civil lawsuit, even a criminal lawsuit. Okay, and we have also the newest law, which is enacted just 2 months ago. It is the Personal Data Protection Law, and in some of its article, it is also said that everyone is prohibited from obtaining or collecting personal data for their own or others' benefit, which can result the loss or damage or harm or disadvantages of personal data subjects. Yeah. And everyone is prohibited from disclosing personal data that does not belong to him. So this is some of the law. Yeah, we have also the public information disclosure law that also has the same regulation or norms, that every person who deliberately and without the right to access and to obtain provides information on personal data shall be subject to imprisonment and so on. And we have also the criminal code, that also said that whoever intentionally disclose a document that is obliged to be kept by her or him, because of her or his position and occupation, is punishable by imprisonment. So this is some of our laws, that saying about the personal data protection. And this is some legal basis of framework about medical record health information. Confidentiality, we have a law on medical practice. It says that physicians and dentists are required to record a certain information in their patient records. And the medical records are the property of the patient, while the documents belongs to the physician or healthcare unit. And patient records must be kept confidential. It is also set in the law of health workers, almost the same. Health workers and head of health service facilities have to maintain and protect the confidentiality of medical records. And the last one, I think, is a law or act on hospitals that say that all hospitals are obliged to maintain medical records. Okay, next. We still have a government regulation on health information system. I think it is almost the same in India, in the Philippines, that in one of its articles said that security of health information is carried out to ensure that health information, confidentiality is maintained primarily for specific secure health information. And we have also the law of medical privacy. Okay, next. Okay, so the hot the newest issue is in August in August this year, the Ministry of Health promulgated the regulation number 24 year 2022 on medical record. It repealed our old regulation, which is promulgated in 2008. Okay, next. Yes. So what's in this regulation that all doctors, midwives, nurses, physician, and also pharmacists are then really maybe confused, because in one of the article it says that all health service facilities have to organize electronic medical records following the provision regulated in this ministerial regulation by December 21, 2023. So it is 1 year from now on. So it is begin the issue, and then we have to talk about the issue and the challenges in Indonesia. Okay, next. Okay, this is the personal data protection law. I already mentioned before that the Ministry of Health regulation on medical record is enacted on 21st of August 2022, and we have the newest yeah, law for personal data protection is law number 17 year 2022 that is enacted on 17th of October 2022, yeah, which is enacted to be the general codes for personal data protection, yeah. The purpose is good, I think, yeah, for the ministry regulation. It is to integrate the whole health data system in Indonesia, yeah. But many issues and challenges remain, yeah. The goals or the purposes is to improve the quality of health service, I think, to ensure the security, confidentiality, integrity, and availability of medical record data. So it will become the big data for the health situation, personal health situation, yeah, for Indonesia. And also this regulation is to provide legal certainty in the implementation and management of medical records, which is EMR, and to actualize the implementation and management of digital-based and integrated medical records. So the goals is good, yeah, but the issues and challenge remains, yeah. Okay, next, the first issue is the personal data protection issues, yeah. In daily life, for examples, yeah, not any single day, I do not get the short message service in my mobile phone, yeah, offering to get credit for cars or motorcycles, for examples, yeah, insurance, yeah, traditional healthcare, even massage, traditional massage. I get short message service in my mobile phone for a massage, yeah. I don't know where they get my number, yeah. Yeah, now even in my university email, I found advertisement, yeah, offering lots of seminars, yeah, goods, insurance, yeah, opening bank account and so on, yeah. So, and my personal email were also hacked once, yeah, some years ago, yeah. I never give any of my mobile number or university email to anybody. Yeah, I don't know well, but how do they get my number or my email? So this is about the cyber security, yeah. And we are talking about the medical records that is that has to be confidential. Yeah. So data and network security issues become crucial, yeah, as medical records are confidential, yeah. The second issues next, the second issues is about, okay, this is the personal data protection law, yeah, the article, you can see that. And for the data and network security, the notes, my notes is who will take the responsibility when something goes wrong, yeah, because sanctions are imposed, yeah, sanctions are imposed, yeah, in some of these laws, yeah. A civil suit, yeah, criminal suit, administrative sanction is also imposed, yeah. Okay, next. The second issues is regarding to Indonesian geographics and demographics condition. Yeah, this is Indonesia. I think the Philippines also have the same problems. Yeah, but Indonesia has like 17,000, more than 17,000 islands. The Philippines, I think, have more than 7,000. Yeah, so we have 10,000 islands. Yeah, more than the Philippines. Yeah, and this is a very big issues because okay, you can move to another to the next slide. Yeah, the total land area in Indonesia is very huge. We are the largest archipelago country in the world. Yeah, more than 70,500 islands. Yeah, and the big issue is the outermost, the frontiers, the remote and disadvantaged region in Indonesia, what we call daerah 3T. Yeah, it is the three is tertinggal, terdepan, terluar, terbelakang, yeah, four, yeah, even four, yeah. So it is the this issues, yeah, when the EMR will will have to be realized. The issue is this. Yeah? We are also the fourth most populous country in the world. Our total population in this year is more than 273 millions. Yeah, I think India has a big problem on this. Yeah, because I think India already reached 1.3 billions. Yeah, of the population. And it is also connected with the healthcare situation in Indonesia, which is still very poor. Yeah, okay, we have a number of primary healthcare, yeah, increasing in 2021. It is good. Yeah, this is below you can find the number of hospital, and this one below is the private one. Yeah. So the private hospitals are more than public hospitals. Yeah, and having the regulation of EMR is very big issues for these hospitals. Yeah, because of the cost and so on. Yeah. So the first one, there are maybe the next slide, please. Just want to show you the next slide. Okay. Yes, this is the number of primary health education without physician. So we still have like 42.6 healthcare primary unit that do not have even doctors. Yeah, they only have maybe midwives and nurse. Yeah, or the paramedics. Yeah, but without any doctors. Yeah, medical doctors or physician. We have like 42.6, and then the 23 in Maluku. In the West Papua, we have 20. Yeah, this is the very remote area. Yeah, very remote area around Indonesia. Yeah, that do not even, yeah, in their primary health care unit, that do not have a physician. I got this from the Ministry of Health of the Republic Indonesia. Their books. Yeah. So there are so many primary health care units, what we call puskesmas, lies in the very remote area of Indonesia that do not even have access to internet. So this is the same with the Philippines. And the number of private hospitals are more than public hospitals. How could they get the money for building the infrastructure for using e-medical records? Yeah? We still have many basic health issues to handle. Yeah. In example, the number of physician, yeah, distribution of physician, yeah, of doctors, of quality doctors, yeah, midwives, nurses, yeah, quality laboratory, pharmacists, and so on. Yeah. Who will bear the cost for building the infrastructure, as the time is very limited for the transition? It is we should move in 31 of December next year. Yeah. So e-medical records need next. Okay. Next. Yeah. E-medical records needs internet network or connection. Yeah. Though yeah, pandemic changed a little bit. Yeah, of using, yeah, increasing the use of internet, but it needs the network or connection. Yeah. We can say also that every hospital, every healthcare unit needs server, yeah, a router, yeah, network attached storage, yeah, because in the ministerial regulation, it is said that the storage should be kept for 25 years, yeah. The wireless card, yeah, the LAN card, yeah, the USB Wi-Fi adapter, and so on. Yeah, who will bear the cost? Yeah, yeah. Especially for the private, yeah, for the private hospitals. Yeah, yeah, and we also have some issues about human resources education, yeah, or literacy about uh, the doctor, the midwives, the nurse, yeah, literacy of IT, yeah, lack of literacy of maintaining data and so on, yeah. And the next one is who will take the responsibilities when something goes wrong, yeah, as administrative sanction will be given to those health facilities according to this Ministry of Health regulation, yeah. The administrative sanction, yeah, they will close the healthcare facilities and so on, yeah. And what about the cyber attacks, yeah, for example, yeah, it is a lot of things, yeah, issues that we have to realize, yeah, or to manage, yeah. I don't want to sound pessimistic actually. Yeah, I know that there are many advantages of using EMR. Yeah, but I think the government of Indonesia still have a very big challenges to realize this regulation. Yeah, and okay, to close my presentation again for the all keynote and international and national guest speaker who have taken your time off from your normal schedule to be in this seminar. On behalf of Faculty of Law and Communication of SU, please accept my sincere thanks for your remarkable participation. May I also express my heartfelt gratitude to all the participants who sincerely committed to this event to make it a success one. Thank you.
Thank you, Dr. Marcella. Highly appreciate the presentation. And maybe to minimize the time, we move to the question and answer session.
Okay, but sorry, Fiona, can I ask you? I wonder whether Prof. Exter from the Netherlands is already here, so he can join this session. Professor Exter, are you here? Because he joined the trial yesterday. I hope he is all right.
Yeah, and the committee could help to find the Prof.
Is he here? If not, okay, we can move. Thank you.
Okay. Okay. And for the audience who have the question, maybe you could use the raise hand features. For the fourth, fifth, and sixth international speakers. Dr. Marcella, I've got the information from the committee. There's no, the professor from the Netherlands did not join us today.
Oh, I wonder why. Because yesterday he joined the trial, yeah?
Yeah, the committee told me that yesterday the professor has joined the trial, but today, yeah, he's not here with us.
Okay, you may proceed.
Okay, the other speaker, please open the camera. The audience who have questions could use the raise hand features or simply write at the chat column so I can read for the speaker. And for the on-site audience, could convey the question immediately Okay, please, Miss Vida.
Okay. Yeah, thank you for the opportunity. My question is direct to Raj Kumar Khanna. Is there any Mr. Raj Kumar Khanna?
Professor Dr. Kumar, are you with us?
Okay.
Please
I'm cancel my question. Okay. Thank you.
maybe the other question.
Maybe I can ask a question to Dr. Marcela.
Okay.
Dr. Marcela. Well, in the first session, there were questions about electronic consent in the clinics. What is the policy in Indonesia?
Actually, in when we have the EMR, yeah, I think using for the telemedicine, yeah, I think the consent are then have to use electronically. Yeah, we have to register electronically, and then when we sign electronically, then or register electronically, then we have the consent, yeah, to electronic consent, yeah, to the patient consent. I think that's the answer, I think.
Yeah, what I meant was, what are the contents? Will it matter? Will it still be the same?
I don't actually quite know the details of the regulation, yeah, but I think when EMR are to be used, yeah, then the registration will be the same, yeah, like when you, yeah, I think
I asked that question because when I was still the lawyer for one of the hospitals here, one of the first things that I did was to change all the consent forms of the hospital, to revise it, because in accordance to the provisions of the Data Privacy Act of 2012. Remember, well, unfortunately, I wasn't really able to discuss that lecture. Well, actually, I have a lecture on data privacy. It's about 2 hours. So I tried to fit it in. I couldn't find it. But anyway, well, when it comes, one of the principles of Data Privacy Act is transparency. And that would include that the patient or the data subject should know what is the data that will be taken,
yes,
who will have access to the data, well, what will be who will have to whom will the data be shared, how will that data be stored, how long will that data be stored, and how will it be destroyed. Now, usually you cannot do that. You cannot include that in everything in a consent form, because the consent form will be very long. But what the Data Privacy Act does is recommends is that you just have to say that by signing this, I agree with that. Short that this data will be processed for a legitimate purpose, etc., something like that. and you sign it. But you have to have available a data privacy policy, which if that person wants, he can examine. At least that's what our Data Privacy Act recommends or provides for. Again, but unfortunately, it's not really being followed here in the Philippines. I tried looking at some clinics of my colleagues, but most of them do not have this data privacy policy. I said, well, I thought you were registering in, you have already registered in the National Privacy Commission. Well, they say, well, we registered, but after registration, they forgot about us. So it's not a problem.
Yes. Yes, I think the problem is almost the same. Yeah.
Yeah, it's more of the implementation actually.
Yes, yes, I think because the literacy of the IT, yeah, or information system, yeah. But once we agree, because we have a password, we could go to the facilitation, yeah, the electronic the electronic telemedicine, for example. So we agree, yeah, that the consent is there.
Yes. But again, it's just a culture problem of Filipinos. While we have a Data Privacy Act, Filipinos do not really care about sharing their data, even health data. When I lecture about data privacy, I always say Filipinos have a sharing culture. In fact, if you look at this noontime shows, they love to share that their family, they have somebody who is sick, etc., etc.
Yes, yes, it is almost the same. Yeah, the culture in Indonesia and the Philippines, I think, is almost the same. Yeah, it's more maybe different in Europe, a European country. Yeah, because we are like a communalistic society, so it is almost the same. Yeah, and when we share our information of our health data information, so we then pass the law. Yeah. It is written in this regulation and also the data protection law. Yeah, we just have it for 2 months because it is enacted on October 2022. So it is just 2 months.
It's just new. Actually, ours was enacted 2012, but the implementing, as I said, the implementing rules and regulations were only promulgated 2016, and they became effective 1 year after it was printed. It was published, so 2017. But even that, but actually since 2018, I've had several cases on data privacy, both mostly administrative, because rules for data privacy violation, there are two types. You could file an administrative case with the National Privacy Commission, and after they will if they find you liable, they will give you a fine, but they will also refer that, in some cases they will refer that to the prosecution service, to the prosecutor's office for criminal prosecution. Or you can directly, if you are the victim, you can directly file with the prosecutor's office. You don't go to the National Privacy Commission office anymore. You just go file directly a criminal case. And usually, in our setting here in the Philippines, when you file a criminal case, a civil case is deemed filed with it.
Yeah, I think the problem is almost the same. Yeah, but for example, I told in my presentation. Yeah, so today not every day I got the SMS. Now it is already in WhatsApp. Yeah, I got this advertisement. Yeah, they are offering some insurance, some.
I get at least 5 of that every day.
Yeah,
I have,
me also.
But
yeah,
with the National Privacy Commission, I've handled cases in the National Privacy Commission.
And I'm annoyed. Yeah, I'm annoyed because in WhatsApp it is very easy to get hacked. Yeah, so it is annoying, but I don't know where to go or how to stop it. Yeah. Yeah, it is also the ethical issue. Yeah. Maybe I open account in one bank. Yeah, and then she or he, the staff is moving to insurance company, and then they send me this advertisement, yeah, asking me to join them and so on. So it is
Yeah,
also
yeah. The problem there is when you go to the bank, they have this where if you sign this, it shows that it means that you agree to our data privacy policy, but
Yes.
nobody looks at the data privacy policy, which is very long. Okay.
Yes.
But with regard to health records, well, that's the issue. Of course, I'm also very involved in clinical research, so I look at when I review clinical trial protocols for new drugs, for example, being developed for this global clinical trials, I review the protocols. Then I really check the data privacy provisions.
Okay, I think
Yes.
we have
Okay.
Mr. Jaka Kusnanta to ask.
Okay, thank you, Dr. Roberto and Dr. Marcela for the very interesting quick sharing. And before we move to the next question, I will inform that unfortunately, Professor Dr. Rajkumar is not with us now because he suddenly has something to do. But for the audience that wants to ask him a question, the audience could write down the question below the column chat, and later the committee will deliver the question to Professor Dr. Rajkumar. And now we move to next question. Mr. Jaka Kusnanta, please deliver your question. Thank you.
Okay, thank you, moderator. Good afternoon, Dr. Marcela. Sorry. Do Dr. Marcela think for now is ready to enact electronic medical record? What bio is associated with the side effects that will occur and cause that must be ensured in case of unwanted things. Maksud saya adalah apakah memang Indonesia sudah siap dan kita sudah siap gitu, Dr. Marcela. Terima kasih.
Okay, you are asking about the readiness, yeah, of our government to realize or to have this EMR, yeah. My presentation is actually about that, yeah, because before I was asked by the committee to speak in this MENA, yeah. My friend told me, yeah, that now the doctors, the nurse, the hospitals, yeah, they're very confused. Why? Yeah, because in 1 year, yeah, we will have to move to electronic medical record. Yeah, I was also shocked. Yeah, I was also shocked because suddenly in 1 year, yeah, you have to move to transform, yeah, all the, yeah, I think it should be like periodically. I know it will be periodically, yeah, but the regulation said that the transformation will be done in 1 year. Yeah, that's why I think the hospitals, yeah, the doctors, because it is not only the hospitals, yeah, or the healthcare unit that have to make the EMR, yeah, even the private doctors, yeah, private midwives, private, yeah, pharmacies, okay, yeah, they have to make this EMR. Yeah, that's why I wonder how to educate the very conventional. I think if I don't want to say the old doctors, yeah, or physician, or the senior, yeah, the senior one, yeah, to have the e-medical record, yeah. And I think in medical record, yeah, sometimes, yeah, we have symbols, yeah, symbols that are drawn by the physician, yeah, like when I was pregnant, well, the where is the position of the baby? Yeah, is it already there to to be born? Yeah, there are symbols that cannot be written, I think, in the way of electronic, yeah, printing picture. Yeah, I don't know. Yeah, but we have to appreciate, to give appreciation to our Ministry of Health, because they think forward, they think forward, and they want to change, to transform this, but the readiness, I think, it is still far away. We did not even have a very we have a very lower cost of healthcare in Indonesia, and we have so many basic health problems, still happening in Indonesia. So I think to give your money, to make this infrastructure for the e-medical record is still, I don't want to say, pessimistically, but it is still far away. That's, I think, my answer, Mr. Kusnanta.
May I comment? May I comment?
Yeah,
well,
of course.
in relation to that, Marcela, if you look at my presentation, I presented problems that were encountered. So there were at least 3 studies that I presented that about the problems that were encountered in the implementation of e-medical record, and that included like the slow typing of doctors, and some doctors are not confident about the technology. So I think that is also the case in your in your country. So those 3, there was also, with regard to the symbols that you referred. Well, I'm a pediatrician, and I worked when I was still accepting patients. I stopped accepting patients after COVID and focused on clinical research and the law. So usually there are that's the positioning of the baby. You have whether that could easily be remedied. They could easily do that. So because it's not really very specific. Of course, if there are variations, you could just make a note. But with symbols or with a simple abbreviation, they would know. The obstetricians would know the position of the baby. It's not a problem.
Yeah, but the symbol is very easy, to understand,
Yes.
because I have like incompetencia cervix or something like that. I don't know, but the baby goes up, not goes down, and then I have to have the operation, the cesario, and he make the he have my card, the info not inform consent, the medical record, by the symbol of the like the baby and the head of the baby, so I can see, oh, the baby is my baby. Where is my baby actually? Something like that. It is when you use tablets, and the tablet span, it might be easy, but when you have to type, the drawing is easy, but when you have to type, then it is a little bit difficult. Okay, that's my answer, I think, Pak Jaka
Dr.
Kusnanta.
Marcela.
Yeah, okay.
I'm sorry. Perhaps the most unprepared is the majority of all of us in the face of the script of medicine that will be able to be so open. What do you think?
Okay, I think we have to be aware of the cyber attacks. The data should be like I don't know, stored, in some computing clouds or so on. I don't quite understand the term, yeah, for the computer, yeah. But why? How, for example, if cyber attacks, yeah, they attacks the Ministry of Health. Yeah, I don't know, yeah, the name, yeah, the storage, yeah, and then it is like somebody who writes other, yeah, then the doctors, yeah, they could like manipulated the data and so on. So when this is happened, so who will take the responsibility? I think that's also the issue, yeah, about the cyber attacks and so on. Yeah, it is a very big challenge, yeah, very big challenge, yeah, and we have to prepare it very carefully, yeah, when we want to move really to this whole electronic medical record. I think it's my answer. Maybe Dr. Villanueva wants to add something.
May I know I wasn't really able to catch the question. I wasn't able to catch the question. Could you repeat the question? About the hacking, or?
I think it is about the security of the data.
Oh,
yes,
yeah.
Pak Jaka? Is it about the security of the data?
Yes. With regard to, well, for EMR, if you look at, well, I don't know if it is the situation in your country, but what is the situation here is that all the data under the Universal Healthcare Law, which I also cited in my talk, they are supposed to be uploaded to the system of the DOH, the insurance, PhilHealth. Okay, so because of that, they have to have their own security system under the Data Privacy Act. If there is a breach, again, I mentioned that earlier, you should have one of the things that you should do in your privacy management plan is that you should have procedures on how to manage data breach. Okay. Now, when I was talking before with the National Privacy Commissioner, he said, well, because of this data sharing, you should have a data sharing contract or data sharing agreement with the other party to whom you are going to share big data. Okay, so that you will be able to tell who will be responsible for this type of breach. Usually, in a data sharing agreement, whoever holds the data when the breach occurred or where the breach occurred is liable, will be the one who will be responsible. Now, we have the fines in the National Privacy Commission here. It differs depending upon the violation. But there is a national National Privacy Circular, National Privacy Commission Circular, where for every processing act, even if there are so many victims, the maximum that they can find, that the maximum fine that the NPC can give is only 5 million pesos. Okay, 5 million pesos, that's about $100,000 US. Now, but that is not per person, but that is per processing act. So meaning, when you store, for every storage, there is a breach, then that's another, the next day another storage breach, so that's another maximum of 5 million. So it's per processing act. Okay, now, so it is incumbent, or it is up to the AMR providers to provide their own security. The circular of the National Privacy Commission states that the fine should be bigger than the amount that the company was supposed to spend for security. So there is this provision in the National Privacy Commission circular. So that, because if there's no provision like that, you would say, oh, I'll just pay the fine. Anyway, if I spend a lot for security, the fine will be lower. Now the fine should be bigger than what you will be spending for security.
Maybe there will be a
sorry
insurance
for
model.
Dr. Marcella and Dr. Roberto, because the
Okay.
time for Q&A session time is up. And
Okay.
then, yeah, we should move to the next session, returning back to
I think there is a break, yeah, a break, and
Yeah.
we will begin in 1 o'clock, yeah, for the
yeah,
national
returning back
speakers, yeah.
to Master of Ceremony, Dr. Henry Lewis. They will deliver the information for the next.
Thank you, Fiona. Thank you, Dr.
Thank you,
Villanueva.
Dr. Marcella.
Thank you,
Okay, thank you very much.
as well.
Roberto.
Thank you. Thank you.
All the
Thank you very much
audience.
for the invitation.
Okay, you're welcome.
Okay, thank you, Dr. Fiona, for sharing the insightful second seminar sessions and facilitating the seminar, facilitating the presenter from India, Philippines, and Indonesia. The session runs on track in timely manner, although a bit late. So now all our distinguished guests, invited speaker, participants, ladies and gentlemen, can now have 1 hour break. The seminar will then resume in the next 1 hour at 1 o'clock with the third sessions. And the third and the fourth seminar session will be facilitated by my colleague, Iwi. Stay tuned until the end of the seminar. The presence link will be shared by the committee at the end of the seminar today. Thank you, everyone. Have an enjoyable break and lunch. See you all in 1 hour. Over to the committee.
Can we leave the room and after that join again, or should we stay here? Pak Henry, could we stay in?
Can stay in the room or can also leave and join later.
Okay, then I will leave and then join again. Okay, thank you very much. Bye-bye. Bye-bye,
Thank you,
everybody.
Marcela. Thank you, Fiona.
Thank you.
Good afternoon, everyone. How was your lunch? I hope it was a yummy one on your tummy, full enough to recharge your energy for the rest of our very interesting sessions today. I am Tiwi, the MC for the next sessions. Don't worry if any of you wish to see the handsome face of Dr. Henry again, the previous MC. You'll see him again on the closing session, so stay tuned until the end. First of all, allow me to remind our general rules again. We will automatically put you on mute mode to minimize potential noises. So if you have questions, we have 3 options for you to choose. The first one, you can type on chat menu and the moderator will deliver it to the designated speaker. The second one, you can click on the raise hand menu on Zoom app. And the third one, for those attending this seminar on site here, just spontaneously raise your hands. You will have the privilege to be prioritized for the Q&A. Coming up, without further ado, we're going to start the third session. The main topic of the session is Health Law Perspective on EMR and PDP. Still moderated by our one and only female moderator today, Miss Fiona Cristabella. Miss Fiona, the screen is yours. Thank you.
Okay, thank you. Now, good afternoon, ladies and gentlemen. Welcome to the third session. It's the Health Law Perspective on EMR and PDP. Back again with me, Fiona. I will be serving you again as a moderator. Today, this time, you'll be hearing a presentation from our first national speaker, Dr. Mahesa Pranadhita MH, on this very timely, but before we get started, I wanted to take a few minutes. I will introduce about our speaker a little bit deeper. Our first national speaker, Dr. Mahesa Pranadhita MH from Masyarakat Hukum Kesehatan Indonesia or MHKI, and his education record: graduated from medical doctor from medical faculty of Samratulangi University Manado, graduated law magister of postgraduate concentration health law of Hasanuddin University Makassar, studying hospital management magister at Urindo, studying doctoral concentration health and religion at postgraduate of UIN Sharif, and his work and training as shown above at the slide. Dr. Mahesa, the presentation will be held for 25 minutes, and now you can begin the presentation.
Okay, thank you, Dr. Fiona. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, ladies and gentlemen. The Honorable Mrs. Endang Wahyati, Head of the Master of Health Law Study Program, Faculty of Law and Communication, Sugia Pranata University, all speaker, committee, ladies and gentlemen, all participants in the webinar this afternoon. First of all, I want to thank to invite me to this webinar. It is an honor for me to share presentation with the topic, the law perspective of personal data protection act for healthcare data. Okay, next slide, please. Okay, next slide. Next slide. Yeah. In the recent time, we have been faced with fact related to health data leaks. At the beginning of the pandemic, we were served by data on positive COVID-19 patient being opened to the public. Of course, we hope that there will be legal instrument that protect health data in Indonesia. Next slide. Yeah, the first time that gave rise to the term right to privacy was Samuel Warren and Louis Brandeis in 1890. They defined the right to privacy as the right to be let alone, and the other definition. Sorry, back slide. Sorry, back slide. Next slide, please. Yeah, the other definition, the right to privacy from Alan Westin in 1967. The right to privacy as a claim by individuals, groups, or institutional to determine for themselves when, how, and to what extent information about them is communicated to others. And from EU Charter of Fundamental Rights, privacy is access to personal data, interception of communication, choice or change of name, sex life, profession, or domicile, protection against environmental disturbance, and the right to establish and develop relationship with others. Next slide, please. Yeah, so for maybe the next slide back. The several principles regarding data protection, starting from the Organization for Economic Cooperation and Development, OECD. This is an organization international that encourages the making of good regulation in several countries until the data protection principle from the General Data Protection Regulation, the GRPR, in 2016 issued several principles of data protection, such as lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. Next slide, please. The United Nations Development Group has issued data privacy, ethics, and protection guidance notes on big data for the achievement of the 2030 agenda, which conveys several principles, including lawful, legitimate, and fair use, purpose specification, use limitation, and purpose compatibility, risk mitigation and risk, harm and benefit assessment. The other principle, data security, data quality, accountability, and also due diligence for third-party collaborator. Next slide, please. Several years ago, I was invited by the Malaysia Health Tourism Council to study the services of several hospitals in Malaysia. Almost all hospitals in Malaysia display the right to data protection. Even this information we can see in the elevator. Next slide, please. In the chain to the law on population administration, there are things that are very sensitive to health data. I think in the 16.6 law only mention a national identity numbers and a description of a physical or mental disability, whereas in the 2030 law, fingerprint and irises were included. The big question is to what extent this data is collected, stored, and kept confidentially. Next slide, please. Yeah. Sorry. Next slide, please. In the newly published law regarding the protection of personal data in 2022, the definition of personal data is data about an identified or identifiable individual or in combination with other information, either directly or indirectly through electronic or not electronic system. On the next slide, we will discuss several things related to this. Next slide, please. Yeah. I think there are many laws that regulated the protection of health data, such as Practical Medical Acts, yeah, I think in 2004. And also Narcotic Acts in 2009, Health Act in 2009 also, Hospital Act in 2009, Mental Health Act in 2014, Health Worker Act in 2014, Nursing Act in 2014, Midwifery Act in 2019, and the last this year's Personal Data Protection Act in 2022. Next slide, please. Yeah, I want to talk about patient right and obligation related to data protection, such as in the Medical Practice Act 2004. Patient right is get a complete explanation of medical procedures, obtain medical record content. In the Health Act in 2009, patient has the right to keep his personal health condition confidential, also has the right to claim compensation. In Hospital Act in 2009, patient obtain information about the right and obligation, and also privacy and confidentiality of illness, including medical data. Besides the right, I think patient have also obligation. In Medical Practice Act, patient should be provide complete and honest information about their health problem. Patient obligation also to comply with the advice and instruction of a doctor or dentist. Next slide, please. Beside patient, health officer, including doctors, dentists, nurse, or midwife, also have a right and obligation. In Medical Practice Act in 2004, health official right is legal protection, I think. In Article 50, legal protection as long as carrying out duty in accordance with professional standard and standard procedure operational, and obtain complete and honest information from patient and or their families. In Health Worker Act in 2014, also have a legal protection. Besides the right, health official also have obligation. In Medical Practice Act, they have an obligation keep everything he knows about the patient of secret even after the patient dies. In Health Act, in Article 48, health official have obligation maintain the confidential of the health of recipient of health services. Next slide, please. Yeah, there is what is known as the medical secret trilogy, namely medical secrets, approval and refusal of medical action, and also medical records. I only review a little about the component of this trilogy. Next slide. In regulation of Ministry of Health, number 36 in 2012 about medical secrets, parties obligated to keep health secrets such as a doctor and dentist, as well as other health worker who have access to patient health data and information, head of health service facility, personnel related to the financing of health services, other personnel who have access to patient health data and information in healthcare facilities, legal entity or corporation and or health service facility, also student who are in charge of examination, treatment, care, or information management in a healthcare facility. Next slide. In regulation of Ministry of Health about medical record in this year, 2022, there are additional parties who are required to keep medical secrets, namely other parties who have access to patient health data and information in health service facilities. Next slide. And also in the health Article 57, health secret can be open in terms of in statutory orders, also court order, permit concern, community interest, and also the person interest.
My apologies, Dr. Mahesa. You only have 5 minutes left for the presentation.
I'm going fastly.
Immediately to the conclusion. Thank you.
Okay, thank you. Okay, next slide, please. Yeah, the Ministry of Regulation about electronic medical record this year. We know the obligation of health facility to organize EMR into 2023, but the big question, how is the readiness of all health facility in 2023? Next slide, please. Yeah, at this time we are still pushing for the implementation of EMR. Other countries have implemented personal health records. Through PHR, everyone will know the history of their disease and treatment, even though they move around health facilities. I have discussed with the head of DTO Ministry of Health. The ministry is also accelerating the implementation of PHR through the Care Protect application. But of course, it needs preparation from the regulatory side. Next slide, please. Under the Information and Electronic Transaction Act, we call ITE, yeah, about ensuring an electronic system in considered valid. One of them is security certification. This is also related to presenting electronic document as evidence in courts. RME is evidence. Of course, its validity must be ensured. Next slide. This is a legal sanction, I think, in a Medical Practice Act and also in a Public Information Disclosure. In a Medical Practice Act is only for doctor and dentist. Next slide. In a Personal Data Protection Act, health data and information are included in specific personal data. Health data and information are included in specific personal data endanger the security. Physical health or mental health or personal data subject and or other people. Health data and information are individual record or information relating to physical health, mental health, and or health services. What is meant by endanger the safety, physical health, or mental health of the personal data subject and or other people, included change to the medical history data that have the potential to endanger the safety of oneself and or other. Next slide. Yeah. However, that remains unsure from the current regulation is where is the center for storing health data in Indonesia. Is it at the Ministry of Health, Ministry of Information, or at BPJS Kesehatan? In many countries, there are different central health data retention policy. Next slide. Because currently health data is stored in many places, can be in health facilities that have data storage. If they cooperate with the operator, it will be stored by the operator or even using the cloud. There is also data stored at BPJS Health, and currently health data is stored by the health platform. Next slide. Yeah, this is the legal sanction, Personal Data Protection Act. Obtain and collecting personal data that is not his to benefit himself or other resulting in loss to the data owner, refer personal data that does not belong to him, using personal data that that does not belong to him, sell or buy personal data. The last, my suggestion is derivative regulation are urgently needed to specifically regulate the protect of health personal data, health service facility that carry out the implementation of electronic system independently need to be monitored, supervised, and foster health service facility that cooperated with electronic system operator or PCI SE, must ensure that they have received a recommendation from the Ministry of Health. Health facility and health worker must be socialized regarding the protection of personal data, especially in health services. Patient and the public have the right to receive guarantees and information related to the protection of personal data submitted by health services. The last, I think we agree that personal data, especially health data, is very important to guarantee its protection. Thank you for attention. I return to moderator, Dr. Fia. Thank you very much.
Thank you, Dr. Mahesa, for the presentation. And now we gotta hop on to the next speaker. Our second national speaker is Dr. Joko Widiarto, JS DHMM Hakes, from Perhimpunan Dokter Ahli Hukum Kedokteran dan Kesehatan Indonesia, or Perdahuki. I will read some of his education, courses, and education and occupation record. Dr. Joko Widiarto, are you with us? Okay. From his education, he's from School of Medical Doctor from Universitas Diponegoro, and then postgraduate diploma Hospital Management, University of Leeds, UK, and then Magister Hukum Kesehatan, Unik Sugija Pranata. And from his occupational record is Kepala Puskesmas Rumbai, and then he ever works at PT Caltex Pacific Indonesia and medical officer or medical service, and as a medical consultant. And now we will hear the presentation from Dr. Joko Widiarto. He will give on 15 minutes for the presentation, Doc, and time is yours.
Thank you very much, Fiona. Good afternoon, everybody. Honorable Mrs. Endang Mayati, the Dean of Master Health Law Program, the Faculty of Law and Communication, Sugio Pranoto Catholic University, distinguished speaker, and seminar participant. First of all, please allow me to express my sincere gratitude to the organizing committee who gave me opportunity to share on the very relevant topic in this prestigious seminar entitled The Role of Hospital in Protecting Healthcare Data. Indeed, it is a great honor for me to be here with you all in this seminar, and I do hope that it will be fruitful for everybody. Slide, please. Yeah. This is the topic that I'm going to share with you all. It's about role of role of hospital in protecting healthcare data recently. Slide, please. Slide, please. This is the outline of our presentation, which is actually consists of a 5-portion session. Slide. I start with the quotation from Kudar and Jonathan Rakih in their books titled Hospital Organization and Management, the Text and Reading. They said that the General Acute Care Hospital is one of the most complex organizations ever established. So that we all the health people has to realize that this is very complex organization within the hospital. Slide. The complexity of the hospital based on Raki Endar in their books is because of at least there are 6 factors. One is the objective of this hospital, probably from a session to session a little bit different one to another. Then also because of the variety of human resources in a hospital. And we all know that the hospital is always deal with life and death, and also 24 hours operation within 7 weeks, 30 days, and then month. And also interesting thing in that we have to know is that within the hospital, there are a dual line authority, which is structural and also functional. The last factor that they mentioned is about the indicator of the hospital is probably different from hospital to another. Slide. So therefore, the hospital is full with the activities, technologies, human resources, capital, problem, and last but not least is very important that full also with risk that we are going to face. Slide. Our challenges at the moment is that we all know that the ICT revolution is one of the most popular around the globe. In Indonesia especially, that is also shifting paradigm on the doctor and patient relationship, so that the healthcare services is becoming now more complex and complex. The other factor that we have to think about is at the moment, our community tend to be the litigious community, so that we have to be careful on that. Also, the lifestyle in the population is trend to also becoming the hedonistic lifestyle. The other point that I told to you all that it is tend to be the collegiality among the health profession becoming more and more less at the moment. And then probably we also need a role model on that. Slide, please. Slide. Slide. Yeah, it should be a good corporate governance within the hospital, which is contained of HBL, hospital bylaws, internal regulation, good clinical governance, and also there has been a growing concern on the good ethical governance that was depend on the management, hospital management, manage the hospital, because we have a newly introduced Indonesian Hospital Association Code of Conduct that just released last month. And then also we all know that there is a new version of the International Code of Medical Ethics, which is approved in a WMA meeting in Berlin last October. And then also good code of conduct. It is also important. Slide. Facing this situation, therefore, the Minister of Health of Indonesia has just recently launched the 6 principle or 6 pillar on healthcare transformation in Indonesia. The first pillar is also, we call it the primary care, which is hopefully the primary care will be focused on promotive preventive infrastructure, healthcare facility, human resources, and strengthening healthcare management system. That is for the primary care. While for the referral system, Minister of Health indeed mentioning about the fostering of the healthcare access and quality of service in hospital through the sister hospital program, developing a center of excellence, education, research, and development. It is also interesting to note that based on the COVID-19 pandemic, we know that we have a problem with the healthcare resiliency in Indonesia. So therefore, Minister of Health put this pillar on the healthcare transformation in Indonesia.
Sorry for the interruption, Dr. Joko. The time for presentation is only 5 minutes remaining.
Okay, I will skip some of them. And then the important thing that is I like to mention is also health technology, which is currently we are talking about. Next, please. This is interesting to note that Indonesia need to speed up the issuance of e-health regulation. That was Minister of Communication, Information, Business Director. We while Minister of Health also having discussion on this and then release the Ministry Regulation number 20 of 2019. Next. This is the duty of hospital based on the law number, based on the Indonesian Association, Hospital Association Code of Ethics, which just recently launched by Percy. You know that number 17 and number 24 is talking about the medical record and confidentiality. Next. This is the duty of the hospital based on law number 44 of 2009. Number 13, the hospital has to pay attention on the protect of the right of the patient and also honor for the patient. Next. Next. Next, please. Yes. Next. This is about the International Code of Medical Ethics, which is the previous version is on the 2006. It is mentioned that the doctor has to respect the patient right to confidentiality. Next, while the new version, there are 40 articles. It's very, very interesting. There are some of duty of the medical profession, as mentioned in the new version of International Code of Medical Ethics. Next. Next. Yeah, this is about the Indonesian Code of Medical Ethics. You can see there is always mention about the privacy and confidentiality of the patient. Next. This is just Mr. Maisa said. This was a regulation, Minister of Health number 24 of 2022, some already mentioned by Maisa. This is all about the duty of the hospital in terms of medical record, electronic medical record. Next. This is the electronic medical record disclosure. So we can only disclose the confidentiality of the patient only based on the regulation, the existing law and regulation. Next. Yeah, this is about the regulation concerning the personal data protection. You can see later on. Next. Yeah, basically there are 6 factors that we need to remember. That is based on the hospital ethic, and then also based on Indonesian Code of Medical Ethics. Also law number 44, law number 14, law number 27, and also Minister of Health Regulation number 24 of 22. Next. So the main point of the role of the hospital is to ensure that everything within hospital is properly implemented based on law and regulation. Slide. This is the take-home message that I want to share with you. First, every healthcare facility has to implement reliable electronic medical record system. Hospital has the responsibility to keep personal data confidential. It can only be disclosed in line with the existing law and regulation. Role of hospital is to ensure electronic medical record system and its technical operation properly implemented. Next. Next.
Yeah, thank you, Dr. Joko, for the presentations. It's a really interesting topic, but unfortunately, we only have a little time to share. Hope we could get another time, the longer time to share again next time. And next, we move into the third speaker, national speaker. It's Dr. Muhammad Nasar, SPKK di Law, Asosiasi Dosen Hukum Kesehatan Indonesia, ADHKI. And the committee, please could present the curriculum vitae of Dr. Nasar next. And the curriculum vitae of Dr. Nasar as shown at the screen. To minimize the time, Dr. Nasar will be given time 15 minutes for the presentation, and now you could begin the presentation. The time is yours.
Yeah, thank you for ladies and gentlemen. It is my pleasure to be part of this important gathering. Ms. Moderator, I would like to show my gratitude to my boss in Unika, Ibu Marcela, and also Bu Enda for inviting for this meeting. Today, now I receive opportunity to meet leaders that shares their knowledge such as head of MHKI, Dr. Mahesa, MKK, Dr. Joko, and also next the chairman of Association of Medical Record of Indonesia, Pak Rano. My presentation today will complete the puzzle of knowledge that shared to us by previous presenter, which they are good friend of mine, like Professor Andre from Coimbra, I mean Portugal, and also, but I don't know why Prof. Andre Dexter from Erasmus University, Netherlands, is not be here today. I will to bridge between the discipline knowledge of law and medical science by trying to put in simple format. Please, yeah. I would like to show to you. I talk about the risk of enforcement of law of electronic medical record. Actually, I'm a lecturer in Unica Chukira Pranoto with the subject of health law. Next slide. Next slide. Slide. Or maybe you want to gonna me to operate the slide. Panitia, apa saya saja yang okay. Next slide, please. Yeah, ladies and gentlemen, the electronic medical record, of course, this is a digital version of the paper chart. Yeah, this is consists of clinician office, clinics, and hospital. EMR contain notes and information collected by and for the clinician. Jadi kepentingannya untuk pasien dan dokter, dikumpulkan untuk kepentingan pasien dan dokter. EMR are more valuable than paper records. Lebih berarti daripada kertas karena adanya kelebihan-kelebihan, misalnya overtime, identified patient for preventive visit, screening, monitor patient, and improve healthcare quality yang tentu lebih baik dari kertas. Slide, please. Slide, ya. We know electronic health record. Electronic health record is lebih lengkap dari electronic medical record karena dia berisi banyak hal, broader view of the patient. Jadi seluruhnya ada masuk di dalam, fisioterapi masuk, laboratorium masuk, apapun kegiatan semua ditulis. Itulah yang disebut dengan electronic health record. But to go beyond standard clinical data. Jadi dia lebih lengkap. Satu lagi adalah personal health record. Personal health record is contain the same types of information seperti IHR tadi, seperti electronic health record, kecuali manfaatnya atau perbedaannya adalah managed by pasien, dikelola oleh pasien, dibawa pulang oleh pasien. Jadi pasien itu bisa memperoleh data-datanya sendiri, dibuatkan oleh rumah sakit dalam sebuah kumpulan buku kecil diberikan kepada pasien. Itulah yang sebetulnya reformasi di dalam electronic health record yang belum kita kerjakan di Indonesia. Slide, please. Slide. Ya, ini sama saja. Hanya mengatakan bahwa electronic medical record is effort for public hospital reform. Jadi kita mereformasi hospital kita dengan cara membuka sepenuhnya. EMR is the core business of hospital. Ini tidak diragukan lagi. No reformation of hospital without EMR dan tanpa electronic health record. Slide, please. Ya, cost efficiency of work because of paperless. Ini adalah manfaat atau fungsi yang paling baik yang diketahui adalah karena menghemat biaya dan karena mengelola dengan tidak mengelola kertas. Ibu Bapak sekalian, to reduce mistake and negligence in medical record, mengurangi, menghilangkan kemungkinan kesalahan dan mungkin kelalaian, dan mendorong rumah sakit digital berkualitas tinggi menuju e-hospital. Ini Bapak sekalian, for the doctor, IMR can create a clear, membuat catatan medis yang jelas, rapi, standar, sehingga menghindari bahaya medis yang tersembunyi karena potensial membaca atau bacaan yang keliru karena tulisan tangan. Slide please. IMR in medical service, Ibu Bapak sekalian, need human resources. Jelas membutuhkan SDM yang mengerti sistem dan mampu mengerjakan dengan konsisten. Supported by with reliable device and always available. Selalu memadai, selalu komputernya lengkap, tidak bisa sepotong-sepotong. Please, slide please. Namun dalam pelaksanaannya IMR ini electronic medical record potentially fail or not success. Kenapa? Karena ada sesuatu yang mengganggu, yaitu persoalan kerahasiaan pasien. Persoalan kerahasiaan pasien, jadi reduce public trust on hospital. Ini kalau ini terjadi, orang tidak akan percaya lagi pada satu rumah sakit. Karena rahasianya itu, atau rahasia pasien itu bisa keluar. Doesn't not consistently keeping the standard. Kalau ada yang tidak menjaga standar atau ada yang tidak taat pada regulasi operasional rumah sakit sehingga banyak penyimpangan, dokter mudah merubah laporan operasi bila ada kasus terjadi misalnya. Ini the operational report if there is no case occurred. Ini Bapak sekalian sesuatu yang sangat ditangguhkan. Deviance in system implementation half-hearted IMR. Ini MR yang setengah hati. Half-hearted. Dikerjakan setengah hati hanya karena ada PMK 24 dikerjakan. Tapi dikerjakan dengan setengah hati. Dengan setengah hati. Slide please. IMR that potentially bring conflict in hospital. Bahaya kalau tidak mampu mengetahui dengan baik, ini akan gagal, kurang berhasil karena bisa membawa potensi masuk dalam rumah sakit. Ini berbahaya. Konflik karena yang pertama, konflik of data leaks, kebocoran data. Diagnostik dan prognosis pasien yang juga bocor. Orang-orang sudah dibilangin lebih dulu akan mati dalam beberapa hari. Ini sesuatu yang sangat berbahaya. Konflik because of medicine. Dosis. Hasil pemeriksaan pendukung yang tidak diinput atau tidak dilampirkan ini selalu terjadi di rumah sakit dengan IMR. Di luar negeri selalu ini dikeluhkan 70% adalah input yang tidak dimasukkan. Konflik karena catatan pasien dijebol orang. Oh, Gedung Putih aja bisa dijebol. Kementerian Pertahanan kita dijebol. Dan bisa diketahui publik. Khususnya pada penyakit-penyakit related to disease that have stigmatization or discrimination impact like syphilis, like HIV, like kusta dan sebagainya. Ibu Bapak sekalian, ada lagi satu, yaitu problem of signature, sign and stamp of doctor or pharmacy. Ini juga harus diselesaikan. Slide, Ibu Bapak sekalian.
For interruption, Dr. Nasser, the time is only 5 minutes.
Okay. Medical dispute related with the electronic medical record ini Ibu Bapak sekalian akan membawa konflik yang saya sebut tadi, konfliknya itu bisa besar, dan someone spreading the fragment of EMR that potentially bring lawsuit. Orang dengan mudah untuk mengatakan bahwa dia akan melakukan sengketa. Slide. This is effect of EMR and medical services related with element of warp speed, kecepatan bekerja, related with data accuracy, avoid misreading of handwritten. Ini semua bisa terjadi. Slide please. Small complete EMR from the perspective of a pasien ya. Ini dari sudut pasien. Dari sudut pasien, saudara, kita lihat bersama bahwa dari sudut pasien convenient because a quick process. Itu jelas. Pasien merasa senang karena semua cepat. Ini dari sisi angkes cepat dan tentu akan memberi manfaat. Slide please. Slide. Ya, dari potensial overflow problem EMR ini jelas. Who can write and delete the content of email? Siapa yang bisa merubah? Siapa yang bisa menulis kembali? Siapa yang bisa menghapus? Ini juga persoalan. How to protect the secrecy of EMR content? This is problem. This is problem. Slide please. Aware of the technological failure. How to create virtual technology. Who are allowed to know, able to read, and when. Ini juga persoalan besar. Persoalan besar. Ini kalau tidak diselesaikan, kelemahan-kelemahan teknologi seperti ini bisa menjadi sebab ya bagaimana masalah-masalah teknis ini bisa merubah macam-macam. Misalnya aplikasi troli bundar nirkabel dan pihak-pihak yang terlibat dan macam-macam lagi. Slide please. The risk of using EMR in perspective of law. Ya, risiko hukum penggunaan EMR. Yang pertama, gugatan terbukanya kerahasiaan. Ya, this is public known because many hold the key. Ya, the key. Lawsuit because of the handling of right of to know of pasien or patient law. Right to know, hak kewajiban untuk membuka. Hak untuk membuka, hak untuk membuka, hak untuk membuka. Dan gugatan karena merubah hasil catatan dalam EMR khususnya bagi yang ada masalah hukum. Ini saudara, orang change the result of notes in EMR itu dia hapus, ahli bedah yang tidak membuat catatan operasi, tiba-tiba ada masalah hukum, buru-buru dibuat. Itu siapa yang mau bertanggung jawab pada penghapusan dan sebagainya. Slide please. This is medical dispute. What's meaning of medical dispute? Dispute between sengketa antara sengketa medik adalah sengketa antara pasien atau keluarga pasien dengan dokter atau rumah sakit. Itu dulu. Yang mempersoalkan tentang pelayanan dan perawatan kesehatan pasien. Kalau sengketa medik ini karena selalu adalah disebabkan oleh latar belakang perbedaan harapan dan kenyataan yang terjadi, expectancy and reality that happen in patient. Slide please. Ibu Bapak sekalian, tantangan hukum tersukar dalam EMR ini adalah yang pertama, electronic signature. Yang kedua, device that work based on timestamp, untrust. Ini juga persoalan karena bekerja komputernya mati terus atau ganti-ganti dan sebagainya. Proteksi sistem yang dapat atau tidak dapat merubah EMR oleh pihak yang tidak memiliki otoritas. Orang di apotek bisa merubah hasil yang ada di laboratorium. Orang yang ada di fisioterapi bisa merubah putusan dari dokter dan sebagainya. Slide please. Slide. Terima kasih. Matur nuwun. Mudah-mudahan tidak lebih waktunya.
Thank you, Dr. Nasir, for the presentation, and for the audience who willing to give question to Dr. Nasir, you can keep the question, and later we will have a Q&A session at the end. And now move to our fourth national speaker, Dr. Rano Izudra MKes. Are you with us?
Yeah, I'm here.
Okay, for educational record, Dr. Rano is from Fakultas Kedokteran Undip, and then Magister Kesehatan or Simkes Undip, and then continue in the education at the candidate Dokter Ilmu Hukum, Hukum Kesehatan, and educational record as shown at the screen, and some publication that Dr. Rano has. Next, committee. Okay. Dr. Rano, the presentation will be given time for 15 minutes, and you could begin the presentation by now. The time
Okay.
is yours.
Okay, thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everybody. What a great meeting this afternoon we have, and thank you for inviting me for this great meeting. I would like to present my PowerPoint, the concept of regulating access right in electronic medical record. Okay, I'll skip my slides because of time. Okay. I'll start with the definition about medical record to make a same perception with us. The medical record, according to WHO, medical record is a compilation of pertinent facts of a patient life and health history, including past and present illness, and all treatment. And the key point is written by the health professional that contributing to that patient care. We will use this definition along the presentation. There is another definition about medical record from the regulation of the Minister of Health, number 24 of 2022, concerning medical records. It says that medical record is document that contain patient identity data, examination, treatment, action, and other services that have been provided to patients. It's nice to know that this regulation also defines electronic medical record is a medical record. So all principles about medical records can be applied to electronic medical record too. Because electronic medical record is a medical record created using an electronic system intended for the implementation of medical record. So now, what is access anyway? Access, we have many definitions about access. The first is to store data on and retrieve data from a disk or other peripheral device. And the second, to entrance to the internet or other online service or network. And in computer security, access is the opportunity for use of resources. So access is the activity of interacting with electronic system that stand alone or in a network. After we know what is access, we also have to know what is access right. The permission that are granted to a user or to an application to read, write, and erase files in the computer. Access rights can be tied to a particular client or server, to folders within that machine, or to specific program and data files. Because medical records contain a personal data, we also have to know what is personal data anyway. Personal data is data about a natural person that is identified or can be identified individually or combined with other information either directly or indirectly through electronic or non-electronic system. And personal data protection is the entire effort to protect personal data in a series of personal data processing in order to guarantee the constitutional right of the personal data subject. That is, a natural person to whom personal data is attached. So, personal data can be divided into general and specific, while the general personal data could be full name, sex, citizenship, religion, marital status, and personal data combined to identify an individual. And specific personal data could be health data and information, biometric data, generic data, crime record, children data, personal information, and others. While we talk about access, we have to think about who is the person that access the data. How about access policies? How about the procedure to make the access? Where, the place, and in what means of access? Which is data area that could be accessed? Is there any restriction about access time? Is there any restrictions on activities during access? And we don't forget about audit trail of access activity. We will talk about audit trail later. We could divide access by 4 levels. The first is access that delays or filtered read-only paper access, and at the top, fusion of personal health information and clinical record. About access control process, there are four key that we must remember. The first, that identification that define the user must be unique. No double users with double identity that allowed. The second, authentication. Authentication is the process to proving a user identity before someone is able to enter the system. Talking about authentication, there are 4 types of authentication. The first is something what you know. It's like password, PIN, personal data. The second is something what you have, just like private cryptographic key, authentication token. The third, something what you are. We call it biometric scan. And something what you do. For example, speak a phrase, handwrite the signature. There is 4 type of authentication. Sorry. The 4 level of proof follow in order of least secure. So authentication, what you know is the least secure, and what you do is the most secure. None of them are entirely foolproof. So we use 2-factor authentication to make it more secure. For example, a password with a token, a password with fingerprint scan. 1 factor from 2 different categories is more secure. The third about access control process is authorization. Authorization is a user access privilege in terms of what someone can or cannot do within an application or system after he or she enter the system. Authorization is the right or permission to use a system resources, the process of granting access. Someone who accesses the system could be just open and read. Or maybe you could also copy, download, and print. Or it could be also forward the document or make an editing. all activities while someone make an access must be tracking the action. So we have audit trail concept. Audit trail record that shows who has accessed a computer system, when it was accessed, and what operation were performed. So it's not just when he or she log in and log out, but what operation were performed. The concept refers to the most fundamental thing of the audit trail function, that is access management. About audit trail is a record of transaction in an information system that provides verification of the activity of the system. The simplest audit trail is the transaction itself. In Indonesia, we already have SNE number 27789. Yeah, from Badan Standarisasi Nasional. There are several SNE about health informatics from PSN. For example, SNE about jejak audit or audit trail, and SNE about human representation, code for human sex representation. Audit trail and access, as we have already noted, all access activity must be tracking by audit trail. It's about what to do with while editing, modification, display, deletion of information, or just about viewing, about specific patient, specific diagnosis, and other. That's all about my presentation. Thank you, and we can discuss later. Thank you.
Thank you for the presentation, Dr. Ano. It's very interesting topic. And then for all the audience who have a question, you could use the feature of raise hand or just simply write at the chat column below. For all the audience, you could deliver your question in English or in Indonesian. While waiting for the question from the audience, maybe the speaker, Dr. Ano, Dr. Nasser, and also Dr. Mahesa, maybe you have something to be discussed, something light to be discussed.
Yeah, I think I agree with Dr. Nasser and maybe, also Dr. Rana and Dr. Joko about the regulation of protection data. We have to monitor and also evaluation in the next regulation about protection, because like EMR, not all facility can be doing because so many infestation for implementation EMR. Maybe Dr. Anov, specialist about this, can explain how much infestation for develop EMR in facility like hospital or clinics. I think.
Yeah, I think, thank you, Dr. Mahesa. You are my boss. I think electronic medical record is a very, very good key to regarding the reform of hospital. Reform of hospital consists of increasing. The first one is increasing for the man behind the gun. The second about the system of the medical record, and the third and the last one regarding about the supporting like pharmacy, like laboratory, and so on and so on, diagnostic penunjang. But according to my view, if we talking about the hospital reform, the medical record, electronic medical record is number one. Thank you.
Okay, thank you, Dr. Nasser. And then now we have Dr. Desriani that has raised the hands. Okay, Dr. Desriani, please deliver your question.
Oke, terima kasih. Mohon maaf, saya izin pakai bahasa Indonesia. Saya ingin bertanya pada semua panelis, terutama kepada Dr. Ano. Ini mengenai cyber security atau perlindungan terhadap electronic medical record. Bila ternyata ada kebocoran data, Dok, itu apakah yang akan disalahkan nanti pihak rumah sakit atau dari Kemenkes atau seperti apa, Dok? Terus perlindungan hukum untuk rumah sakit untuk electronic medical record ini gimana, Dok? Karena kalau kita di manajemen biasanya selalu jadi tempat kesalahan ya. Jadi bagaimana? Karena negara kita saja yang cyber security-nya kuat juga bisa dihack ya. Apalagi untuk electronic medical record rumah sakit, dan apalagi kalau rumah sakit kita adalah rumah sakit kecil atau TPC ya. Yang kedua, saya juga berpikir untuk cyber security ini karena biasanya kalau sudah ada kepentingan politis tertentu, itu bisa saja ada kebocoran nanti. Bayangkan seorang public figure atau pejabat atau tokoh politik tiba-tiba terekspos nanti, oh ternyata penyakitnya ini, terutama penyakit yang tadi ada disampaikan atau siapa tadi ya, yang menyampaikan penyakit ya terutama yang ada stigma ya, Dok ya. Itu akan booming banget, bisa-bisa nanti di rumah sakit itu nggak ada pasien lagi, Dok. Terima kasih. Mohon pencerahannya.
Oke, Dr. Ano boleh menjawab pertanyaan dari
Baik.
Dr. Desriani.
Baik, terima kasih Ibu pertanyaannya dan mohon nanti bisa dilengkapi dari narasumber yang lain. Memang hal ini tetap akan menjadi concern pemikiran kita semuanya dan kita tidak menyepelekan hal itu. Namun saya yakin kita juga tidak berhenti hanya karena khawatir tentang hal itu. Menurut saya, karena sudah ada beberapa standar yang diterbitkan terkait dengan keamanan informasi, misalnya saja tadi sempat saya sebutkan sudah ada SNI nomor 27001 yang ada disebutkan juga dalam Permen Kominfo nomor 4 tahun 2016 tentang SMPI, Standar Manajemen Pengamanan Informasi. Nah, terkait hal itu, maka yang bisa kita lakukan adalah mengikuti langkah-langkah yang seharusnya dilakukan terkait dengan pengamanan tersebut. Bahwa misalnya kita sudah mengikuti langkah-langkah tersebut dan masih juga dalam tanda petik kalah dengan mereka yang berupaya menerobos, maka hal itu bukan merupakan hal yang 100% menurut saya menjadi kesalahan. Tapi memang kita tetap kejar-kejaran antara kemampuan dengan dalam tanda petik kelicikan dari yang berusaha menerobos tersebut. Tapi apabila kita sebagai PSE, pengelola sistem elektronik, berdasarkan PP yang mengatur tentang PSTE, PP 71 tahun 2019 tersebut, tidak melakukan langkah-langkah standar yang sebagaimana seharusnya dilakukan, maka khawatirnya itu bukan suatu kecelakaan, kebocoran data tadi, tapi merupakan suatu kelalaian. Nah, ini yang menurut saya perlu dihindari. Ya. Jadi, kita lakukan standar yang sudah ditetapkan oleh pemerintah. Walaupun kita tahu, semuanya juga tahu, tidak ada jaminan bahwa sudah melakukan standar itu pun tidak akan terjadi sesuatu yang tidak kita harapkan tersebut. Demikian, Bu Desriani. Mohon bisa dilengkapi Bapak Ibu narasumber yang lain. Terima kasih.
Thank you, Dr. Ano, for the answer, and maybe for the other speaker, Dr. Mahesa and Dr. Joko, you might deliver your opinion.
Ya, boleh saya nambahkan sedikit apa yang disampaikan Bu Desriani tadi. Memang ini satu dilema bagi kita semua, saya kira. Walaupun bagaimana tidak ada satu sistem pun yang betul-betul aman. Jadi Pentagon aja bisa ditembus, gitu ya. Apalagi yang kayak begini. Yang penting adalah kita sudah melakukan yang seharusnya kita lakukan. Jadi kalau kita sudah melakukan yang seharusnya dilakukan oleh kita, itu saya kira sudah cukup, dan itu beban perlindungan hukumnya pasti akan diberikan. Sama dengan dokter yang menjalankan praktek sesuai standar profesi, standar prosedur operasi, itu mendapat perlindungan hukum. Nah, yang perlu juga kita garis bawahi bahwa Undang-Undang 27 itu di pasal 15-nya ada 5 hal yang dikecualikan ya. Ini kan kalau kita mengacu membaca Permenkes 24 itu kan itu semua data itu bisa diakses oleh Kemkes. Full akses boleh. Ya. Nah, di pasal 15 Undang-Undang PDP itu disebutkan antara lain bahwa ini demi kepentingan untuk negara, kepentingan untuk penelitian, untuk publik itu boleh. Jadi mungkin pasal 15 inilah yang dipakai juga. Walaupun lahirnya belakangan dibanding dengan Permenkes 24, tapi sepertinya inilah pelindung dari Permenkes 24 itu yang mewajibkan semua data bisa diakses oleh Kemkes. Kaitannya dengan nama-nama tadi itu, kalau menurut Undang-Undang Wabah, Undang-Undang 8, itu memang disebutkan, apalagi dengan PP 40-nya, itu disebutkan bahwa dalam kondisi wabah yang mengancam jiwa orang, kita boleh merilis identitas lengkap dari pasien. Itu menurut ketentuan yang ada di Undang-Undang Wabah. Dan sepertinya ini juga masih, kecuali kalau nanti ada perubahan dari Undang-Undang 8 ya, tahun 84, sorry, Undang-Undang Wabah, ya, Undang-Undang nomor 8 ya. Saya kira itu tambahan dari saya.
Okay, Dr. Joko, thank you for the answer. And then another question for Dr. Ano from Dr. Renita Agustina. I will read the question here, Doc. Who has the access for the audit trail? The IT team? Yeah, Dr. Ano.
Yeah. Not everyone could access the audit trail. Jadi harus ditentukan dalam suatu organisasi siapa yang memegang kunci dan kendali atas audit trail. Satu. Lalu yang kedua, bagaimana kita akan menggunakan log hasil dari perekaman audit trail. Berapa lama kita akan menyimpan dokumen hasil audit trail. Dan yang penting lagi, karena audit trail akan menghasilkan log yang sangat besar, maka bagaimana cara kita menggali informasi atau cerita di balik data di dalam audit trail. Nah, dalam suatu organisasi, misalnya rumah sakit, mestinya sudah memiliki ketentuan di dalamnya sendiri siapa yang nantinya akan memegang kunci dan kendali audit trail tersebut. Yang pasti tentu tidak setiap individu di dalam sana. Nah, ini bisa saja oleh jajaran dari pimpinan atau pihak lain yang disepakati. dalam struktur tersebut. That's it.
Boleh nambah?
Oh, boleh Dr. Joko, silakan.
Iya, saya kira di Permenkes 24 cukup tidak diatur dengan cukup ya itu. Memang kewajiban dari rumah sakit juga harus menentukan siapa yang mempunyai akses untuk itu. Gitu. Kalau tidak diberi akses juga tidak boleh, apalagi melakukan audit gitu ya. Signature on file atau electronic signature itu juga diatur. Tidak semuanya orang bisa. Walaupun secara umum disebutkan di Permenkes 24 itu semua yang memberi jasa pelayanan kesehatan bisa diberikan gitu ya. Kalau kita kembali ke tidak yang terutama itu tahun depan semua fasilitas kesehatan dilakukan. The problem is that what the access, internet access, is that we're already on that. Seluruh Indonesia apakah sudah bisa menggunakan internet, akses internet dengan baik? Yang kedua tadi financingnya ya, berapa duit yang akan dikeluarkan oleh sebuah rumah sakit untuk implementasi dari electronic medical record itu. Dan barangkali yang perlu juga kita cermati adalah pembukaan rahasia pasien yang tidak dengan persetujuan pasien, itu persetujuannya sampai kepada Menteri Kesehatan, dalam hal ini melalui Dirjen Yanmed. Ini kan juga luar biasa sebenarnya. Berapa rumah sakit ada di Indonesia? 3.000 lebih. Berapa dokter yang praktek di seluruh Indonesia? Kalau nanti ada permintaan, misalnya tanpa persetujuan dari pasien, itu harus mendapat persetujuan dulu dari Yang Mulia Menteri Kesehatan. Itu saja barangkali yang untuk menjadi catatan yang perlu kita cermati bersama. Terima kasih.
Okay, thank you, Dr. Joko and also Dr. Ano. And then the next question is in Indonesian for all the speakers.
Ya.
Ya, begini dok pertanyaannya. Terkait rekam medis elektronik terintegrasi, apakah nantinya rekam medis di satu tempat bisa diakses di tempat lain? Jika bisa, apakah resiko kebocoran data semakin besar? Dan bagaimana cara mengatasinya? Terima kasih. The question is from Erin Yovita Kurniawan for all the panelists. Thank you.
Yeah. May I ask the question?
Yes, please, Dr. Nasser.
Yeah, moderator, Mrs. Fiona. Yeah, Miss Fiona. Conflict about or regarding conflict of data or data leaks, it's very dangerous, sangat berbahaya. Kenapa berbahaya? Karena ini sangat mudah terjadi. Di Amerika dalam 1 tahun ada 17 sampai selama tahun 2021 ada 2001 selama tahun 2001 itu ada 17 kasus yang masuk ke pengadilan dari 17 negara bagian. Di satu negara bagian bisa lebih dari satu, tapi ada 17 negara bagian dari 50 negara bagian yang melaporkan adanya kebocoran data. Tapi ini kan tahun 2001. Mungkin saat itu belum terlalu bagus perlindungan data. Tapi ini berasal dari banyak kepentingan. Kepentingan terbanyak adalah pencurian data ini adalah dari perusahaan asuransi. Perusahaan asuransi mau menolak membayar, dia butuh data untuk menolak membayar, untuk alasan untuk menolak membayar, dia cari itu data dengan berbagai cara, Pak Joko. Dan itu Pak Joko dilakukan pencarian data pasien ini dengan berbagai cara menembus kemana saja. Ini yang bisa terjadi juga di tempat kita ini. Karena ini kan soal kejujuran. Number one. The second one is kebocoran data itu juga karena dalam Permenkes 24 itu harus seluruh data itu dilaporkan kepada pemerintah. Nah, kalau ada 1-2 orang kepada Kementerian Kesehatan itu, kita belum tahu ya Kementerian Kesehatan itu mana. Apakah lewat dinas kesehatan setempat atau harus langsung ke biro atau satuan kerja di Kementerian Kesehatan yang mengurus soal data ini. Itu saya tidak membaca penjelasannya. Tapi kalau itu ke pusat dan permintaan data itu akan dilakukan kepada Menteri Kesehatan dalam hal ini Dirjen Yanmed, maka saya khawatir, khawatiran kan bisa. Saya khawatir maka orang-orang yang berkepentingan, orang-orang jahat yang berkepentingan itu akan mudah membobol data-data pasien. Ini ya hanya Pak Rano secara teknis yang bisa mikir ini. Bagaimana ini Pak, setiap rumah sakit memiliki kemampuan untuk melindungi data pasiennya. Ada sebuah rumah sakit saya lupa di mana, di New Zealand kalau saya tidak salah, sudah lama saya baca, itu akhirnya tutup karena rumah sakitnya tidak bisa dipercaya. Tidak bisa dipercaya. Banyak sekali kejadian yang membuat banyak sekali kejadian data pasien yang dirawat di sana itu berceceran. Dan kemudian itu menjadi berita luas, dan kemudian 2-3 tahun kemudian orang terjadi penurunan yang sangat signifikan pada jumlah pasien yang masuk ke rumah sakit itu, dan akhirnya rumah sakit itu ditutup. Saya kira inti atau izin atau maksud daripada PMK 24 kan tidak seperti itu. Tapi kalau salah ditafsirkan atau disalahgunakan, ya bisa saja dia akan mengalir ke sana. Kemudian yang saya juga ingin sampaikan bahwa ya ini pertanyaan dari Bu Nani Wijaya Budi yang cantik ini benar juga. Bagaimana ini tanda tangan dalam rekam medik elektronik ini bagaimana? Karena ini Bapak sekalian, rekam medik elektronik ini yang tidak aman, yang tidak dibuat dengan perlindungan yang cukup. Saya mendengar dari orang IT yang dekat, saya mengatakan pada saya, Pak, itu tergantung bagaimana kita memproteksi. Kalau kita beli yang murah-murah, maka hampir-hampir tidak terproteksi. Tapi kalau kita memproteksi dengan cara yang bagus, yang mahal katanya, ini orang IT bilang mahal, dia menggunakan istilah mahal, maka kita bisa memproteksi. Tapi terus terang saya tidak terlalu percaya. Kenapa? Pentagon aja tadi Pak Joko juga menyebut, Pentagon aja bisa ditembus. Kita di sini kementerian apa saja, pertahanan kan juga pernah ditembusi. Artinya itu kan tidak murah juga dia Pak. Dia bekerja juga dengan mahal, apalagi kalau instansi pemerintah. Kalau disuruh membeli 2 macam barang satu murah, yang satu mahal, dia pilih yang mahal. Dia punya alasan supaya berkualitas. Yang murah itu buatan Cina katanya tidak berkualitas. Tapi itu alasannya. Alasan saja sebetulnya. Nah, Ibu Bapak sekalian, kembali ke pertanyaan tadi, bagaimana caranya? Kalau soal cara saya tidak ngerti. Itu saya serahkan pada ahlinya. Tapi saya ingin katakan sebagai orang yang belajar hukum, saya ingin katakan bahwa ini adalah celah hukum. Celah hukum. Tanda tangan elektronik, celah hukum. Tadi saya sudah sebut dalam presentasi saya. Kebocoran data, celah hukum. Ada satu lagi celah hukum, yaitu SDM yang tidak berkualitas. Demikian Pak Ibu, bukan Ibu ini ya, belum Ibu ini kan, Fiona? Ya, to be Ibu. Demikian Fiona dari saya.
Yeah, thank you Dr. Nasir for the answer. And maybe the other speakers.
Boleh izin menambahkan.
Oke, Dr. Rano, please.
Thank you. Jadi yang dimaksud dengan rekam medis elektronik terintegrasi dalam konsep pengembangan di Indonesia itu telah disebutkan juga dalam Permenkes nomor 21 tahun 2020 yang diperbarui dengan Permenkes nomor 13 tahun 2022 bahwa pertukaran data antar Fasyankes dalam hal ini rumah sakit itu bukan berarti keseluruhan isi rekam medis akan bisa diakses dari berbagai tempat. Tapi yang dipertukarkan adalah resume medisnya. Nah, resume medis ini dari masing-masing rumah sakit disimpan di server rumah sakit masing-masing, lalu diupload ke dalam server resume medis milik Kemenkes di cloud. Rumah sakit lain yang membutuhkan untuk mengakses atas izin pasien akan mengakses melalui server resume medis Kemenkes di cloud ini. Begitupun pasien. Nah, jadi tidak antar pasien kes langsung, tapi ada server resume medis milik Kemenkes di cloud. Ini juga mengindikasikan bahwa rumah sakit boleh menyimpan data rekam medis elektroniknya berbasis cloud drive dengan syarat server cloud drive-nya ada di Indonesia. Nah, jadi konsep pertukaran datanya seperti itu sebabnya supaya bisa diakses dari rumah sakit satu ke rumah sakit lain melalui cloud drive tadi itu, maka yang diupload bukan PDF-nya tapi variabel datanya. Itu sebabnya muncul KMK nomor 1423 tahun 2022 yang menjadi pedoman standar variabel dan metadata dalam rekam medis elektronik. That's it. Matur nuwun.
Okay, thank you, Dr. Rano. And due to the time limitation, we have to end this Q&A session. And thank you for all the speakers, the audience. And before we hop on to the next session, I return back this presentation to the Master of Ceremony.
Yes, thank you, Dr. Fiona. What an eye-opener session for us. Thanks to Miss Fiona and all highly competent speakers. Well, ladies and gentlemen, I'm hoping that you are still excited as much as I am, even more, I guess. There are much more questions, but we cannot discuss it one by one. Apologize because the time is limited. And before we enter the fourth session, you can take your time to have a simple stretching, wiggle your hands, nod your head, take a sip of coffee like I do. Now for the last session, but not least, of course. Okay, apologize. We have to turn on the camera, sorry. The last session, but not least, of course, the topic is healthcare organization perspective on EMR and PDP. We will be referring to the Ministry of Health Regulation number 24 of 2022 on medical records, or what we call Peraturan Menteri Kesehatan nomor 24 tahun 2022 tentang rekam medis. Moderated by the Honorable Dr. Iketut Widiasa MPH. He is the head of Indonesian Medical Association or Ketua ID for Denpasar region during this very current period of 2021 to 2024, obtained his medical doctor from the University of Udayana and earned his master degree in hospital management from the University of Gadjah Mada. He is also the vice chairman of Indonesian Health Law Society for East Java region and CARS management surveyor. Ladies and gentlemen, hereby I will call upon Dr. Iketut Widiasa to take over the floor. Thank you, Doc.
Thank you, the Master of Ceremony. Can I check my voice? Did you hear my voice?
Loud and clear, Doc. Thank you.
Okay, thank you. Baik, my thanks to the Master of Ceremony. Good afternoon to all participants of the Third Health Law International Online Seminar. I'm Ketut Widiasa. I will guide your fourth session in this seminar. In our session, this session, we will give and we will discuss about the perspective of health profession organization on electronic medical records and protection of personal data. The speaker we will give the presentation in this session are the chairman or the representative of each professional organization. The professional organization that will give their presentation are Formiki, the head of Indonesian Medical Association, the Indonesian Dentist Association, the National Nurses Association, and the Indonesian White Midwife Association. This session will be divided into two parts, and first is the speaker presentation with the duration of 15 minutes for each speakers. For that, I ask permission to remind each speaker when the presentation time is about to end. After all the speakers have finished delivering the presentation, that it will be followed by a discussion session. The discussion session will last for about 30 minutes, and for that, I invite participants to submit your question either through the chat column or asked directly by participants who are in present offline at the Unica Hall, or activate the raise hand feature for participants to attend via Zoom. So now we will through to first presentation that will be brought by a representative of Formiki. The first now, our first national speaker is Suryo Nugroho Markus, IMD Perkes, SE and PH. He is a head of information technology and public relations, the Indonesian Medical Records and Health Information Technician Association. Atau bahasa Indonesia Ketua Bidang Teknologi Informasi dan Hubungan Masyarakat Formiki Indonesia. This is the formal education. He finishes nurse in Yogyakarta, and then followed by Rekam Medis dan Informasi Kesehatan tahun 2001. Kemudian menamatkan pendidikan di Sistem Informasi Manajemen Kesehatan, Ilmu Kesehatan Masyarakat Universitas Gadjah Mada di tahun 2010. He works at Antirapi Hospital at Yogyakarta from 1994 until now. He is also as a guest lecturer in Institusi Pendidikan Rekam Medis and Infokes di Yogyakarta. So now, Mr. Suryo, I will invite you. Are you with us? Are you with us, Mr. Suryo?
Okay. Yeah.
Okay.
Yes.
Suryo, yeah, I invite you to give your presentation for the next 15 minutes. The time is here, and we'll finish at 4 and 3 about 3:26. Thank you.
Okay. Okay, thank you, Mr. Moderator. I'm sorry. Presentation. Ya, Assalamualaikum warahmatullahi wabarakatuh. May peace be upon you all. Om Swastiastu, Namo Buddhaya, and greeting of each you. The Honorable Rector of Catholic Sugio Pranoto University of representing the Honorable Lecturer and Organizing Committee, and also the other audience who present on this day. It's an honor of having you all in this place in healthy condition. Thank you for the opportunity that given to me to present the material. Please allow me to present the professional chairman of the Indonesian Medical Record and Health Information Technician, Mr. Teddy Dayat, who is currently unable to attend. When this day I was given the mandate to present material about what is the view of our professional organizing getting of the issue of the personal data protection law and the regulation of the Minister of Health number 24/2022 about medical records. Yeah, this is a brief introduction. Myself, my name Suryo Nugroho Markus from Yogyakarta, Indonesia. I used to be a nurse. Yeah, I'm now I have experience as support compartment in Indonesian Hospital Association Yogyakarta. Now I am a lecturer and a practitioner of medical record and information system on medical management and a consultant of health management. Okay, as we know that there are three definitions of medical records, namely electronic medical record, electronic health record, and personal health record. Let's find out the definition. First, electronic medical record is an electronic record regarding individual health information created, collected, managed, used, and referred by doctor or the other authorized health worker in one healthcare organization. Second, electronic health record is an electronic record regarding individual health information that follow national interoperability standard and is created, collected, managed, used, and referred by doctor or the other authorized health workers in one healthcare organization. Last but not least is personal health record. Well, the definition of the personal health record is an electronic record regarding health information that follow national interoperability standard and can be drawn from multiple sources, being managed, shared, and controlled by individual patient. This rencana pembangunan dari jangka menengah nasional 2020 to 2024 is our national medium term program. It's a positive regulation in Indonesia. In this compilation, there is a clause that rules every single hospital in Indonesia applies electronic medical records. Here we tell you about the last regulation on electronic medical records. As we know, last July, the last regulation was issued in the form of a regulation of the Minister of Health number 24, replace the regulation of the Minister of Health. Okay. Below are some new things, namely with the existence of regulation regarding digital technology, include electronic signature, rules regarding ownership and confidentiality of medical record, and waiver of medical rights. The point mentioned above will be described in detail in the guidelines for the implementation of medical record. So we need to know that healthcare facilities currently consist of independent practice, place a doctor, dentist, and or other health worker, puskesmas, clinic, hospital, apotek or pharmacy, health laboratory, all other healthcare facilities that designed by the minister. And all these healthcare facilities must implementing electronic medical records. In terms of security and data protection, medical records must comply with data and information security principle, including confidentiality, integrity, and availability. So for data correction can be done by health and administrative personnel, including medical records and health information with a time limit of no less than 24 hours from the time the data is input. Okay, the right of access to electronic medical record is self-determined by the healthcare facility. And these are some of the obligation of healthcare facilities in implementing medical record. Okay, ladies and gentlemen, the latest rule regarding the period of retention of electronic medical records for 25 years from the patient last visit. So we hope that healthcare facilities will prepare the infrastructure related to the storage of this electronic medical record. Then how the how to bridge the transition of medical record to electronic in the transition period. We should look for appropriate regulation in this transition period. At the moment, we are compiling a manual for the implementation of this electronic medical record, the content which consists of one, patient registration, to distribution of EMR dates, clinical information, electronic medical record information processing, that input for financing claims, electronic medical record storage, electronic medical record quality assurance, and transfer the content of the electronic medical records. As now, the implementation of electronic medical records include healthcare facilities in hospital, community health center, clinic, independent practice place, health laboratory, pharmacy, and extra. Okay, and now there are reference or regulation regarding variable data and metadata used in the development of electronic medical record. Yeah, how is the role of the professional medical record in supervising the regulation of the Minister of Health number 24/2022? Yeah. What are the rules and problem of medical records and health information in current primary health care facilities? First, in the salary, my profession, yeah, in the salary, and then also competencies that intersect with information technology, namely help desk, database administration, and relationship to maintain patient confidentiality. And there is also an opinion that the task of a medical records is only an administration jobs. In fact, this is the competence of medical record and health information in the context of implementing electronic medical records. How about keeping the secrets of the medical record information?
I'm sorry, Mr. Suryo, your time is 3 minutes left. Thank you.
Okay, thank you. Then how do we maintain the confidentiality of medical record data contained in the work competency standard in the field of medical record and health information? We make efforts in the form of establish the security and confidentiality standard for medical record and health information, and create the security management guidelines and confidentiality of medical record and health information. And this violation of medical records and health information decision in making electronic medical record implementation decision, offers examination MOU with third parties if with vendors. Yeah. Also EMR contents design process, feature design content according to data variable business process, and leadership in EMR implementation. This medical record and health information preparation start from the education period. For MIKI and after MIKI joint agreement and currently being drafted. This preparation of training for the other health worker if there are management informasi kesehatan, health information management limitation, one curriculum, instructor, and organizer. Okay, all right. Keep spirit. Good luck for management information management in the RCP Lenggo. So as the conclusion, I'd like to wrap up my presentation on this 3 points, that healthcare facilities need technology for innovation and electronic medical record for improving the service quality and patient safety in hospital. This is the end of my presentation. Thank you for all attention. Hope this presentation brings you more insight and help. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Santi Santi Om. I am giving it back to the moderator. Thank you.
Thank you, Mr. Suryo Nugroho Markus, for your excellent presentation. So to the participant, once again, I invite you to ask questions through the chat column. For those who follow us via Zoom, and please, the question format is participant name underscore speaker name and underscore your question. And next, I will introduce the second speakers. Please, committee. Our second national speaker is my chief, Dr. Muhammad Adib Kumaidi, specialist orthopedic traumatology. He's the president of Indonesian Medical Association, or Ketua Umum Ikatan Dokter Indonesia. Next, now is the chief of Selamat sore, Dr. Adib. Good afternoon, Dr. Adib.
Good afternoon, Dr. Bonas.
Yeah, how are you today?
I'm sorry, I just landed from the Pontianak.
Yeah. Pontianak to Solo, right?
Yes.
Yes.
Now already at the Solo.
Oh, yes. Send my greeting to our President Joko Widodo. Please, Dr. Dr. Adib, next 15 minutes is for you to present your presentation in our session 4 for perspective of ED, Indonesian Medical Association, or electronic medical records. Please, next 15 minutes, time is yours, Dr. Adib.
Okay, thank you, Dr. Buna. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. My senior, my teacher and the professor, the excellencies, the chairman of the committee. Thanks for your invite me to discuss about this, and I will preparing with the slide. Okay. Could you see the slide, Dr. Bona? Yeah. Okay. First of all, I want to explain. This is the era, the disruption era about the digitalization of the like the telehealth and telemedicine. You know, telehealth is the use of the digital technologies to deliver medical care, health education, and public health services by connecting multiple users in separate locations. And secondly, the telemedicine. This is as the use of the medical information as exchange from the one side to another via electronic communication to improve a patient's critical health status. And from the World Medical Association, the recommendation, the WMA and the National Medical Association should encourage the development of national legislation and the international agreement on subject related to practice of the telemedicine, such as prescribing, physician registration, liability, and the legal status of electronic medical record. This is the recommendation for the WMA. So there are some in the Dutch language had recht in achter de feiten aan. That's main in the bahasa dia. Hukum selalu tertinggal di belakang kejadian atau peristiwa yang muncul di masyarakat. Yes, from the Indonesian Medical Association, PBID, we have the referensi. We have the literature about the telemedicine, about the recommendation from the Indonesian Medical Association about the future, the digitalization of the health in Indonesia. And some we have the tell about the perspective in the future about the telemedicine. This is the writers, me and Dr. Mahesa Paranadipa, as chairman of the MHKI, write about the book. So, what's the ethic issue in the telemedicine and the telehealth services? First, the fidelity. Secondly, the competency. Third, the transparency and informed consent. And for the privacy and confidentiality and the continuity of care. This is the ethical issue in the telemedicine and the telehealth services. In other countries, not the situation of the pandemic, telemedicine platform was already used the controlling patients services was support with device and healthcare workers. So, you know, in Indonesia, the condition, the pandemic, we learn with the pandemic and we expose and we have the regulation about the telemedicine as in the pandemic. But in the other countries, not at the pandemic situation, the before the pandemic situation, the telemedicine platform was already. So this is the, we can see about the electronic health records from the, with the vital parameter, with the emergency call, with the daily review of vital parameters. This is have the telemedicine center with physician and nursing. And we have the measuring device. That's important. We must to standardize about the device. You know, in the other countries like the Taiwan, Korea, Japan, and the Europe, the device, the medical device innovation was increasing the produce about the technology. Now in Indonesia, we are not have the standardized about the device, but the product must be ready and maybe one by one enter the Indonesian. So how about the condition? How about the standardization about the device? So the telemedicine is here to stay, but it has challenges. The reference from the University of California, San Francisco of the Health, which has contracted with Zoom for virtual visits since 2016, gave every doctor and clinician a personal link for the video conference. And the telemedicine calls for outpatient care spike from the 2% visit in February, more than 60% by that April. This is the condition, the need, the people need about the telemedicine. And WHO have the guideline in 2016, the recommendation on digital intervention for health system strengthening about the health content with the digital health intervention and how to about the digital application. And two priority in the digital intervention for health system strengthening from the WHO 2019, telemedicine from healthcare facility to consumer and telemedicine from healthcare facility to healthcare facility. This is from the HIMSS Analyticals have the MR adoption model cumulative capability with the states from the 0 until the 7 until the complete EMR, external WSA, data analytics, governance, disaster recovery, privacy and security, and preparing with the technology, enable medication, and so on. So this is the journal from the journal. My friend from the RSCM, Cipto Mangunkusumo Hospital, have the in the journal, right in the journal, but the telestroke strategies to enhance acute stroke management in rural setting. This is a systematic review and meta-analysis. And from the conclusion, the telestroke implementation in rural area was associated with the better clinical outcomes as compared to usual care. It is integration but pre-hospital and in-hospital setting. And we can see this is the very important about the system, about the telehealth, about the telestroke strategies. This is the cause about the stroke. So we have the telehealth implementation playbook in the American Medical Association about the identifying a need step, forming the team, defining success step, evaluating the vendor, making the case step, contracting until the scaling and the evaluation success. The American Academy of Family Physicians has a toolkit for building and growing a sustainable telehealth program in your practice. This is September 2020. In the American family physician have the first with the established rules and responsibility and check licensing and legal requirement and the customized telehealth appropriateness and approach, redesign your workflow, design your patient digital journey, assess the technology and assess and literate. With the key role, who is the clinical lead? The small practice, the physician, the large practice, the medical director. The operational, the practice manager and director of operation. And the IT lead is the practice manager of IT representative and IT director. So this is the important, the licensing and legal requirement, prescribing limitation, medical malpractice, and privacy and security. That's the problem about the digitalization of the health. So it is more attention to us about this. So what the unintended consequence from the journal, the yearbook of the medical informatics in 2016, the Gorgia, Sasi, Bhushan, and et al. Have the journal write about the unintended consequence of telehealth and their possibility solution. What the unintended consequences? The type, about the clinical, about the administrative, about the technical, about the ethics, about the human resource, about the finance and budgeting, and how to the solution and the implication. So we need the strengthening good telemedicine practical. Why? And that's why we must strengthen with what? With the data protection rules, with the clinical standard and guideline, with the organizational standard and guideline, with the technology and equipment standard and guideline, with the ethical standard and guideline, and human resource standard and guideline. So from the number 1 and number 6, what is already in the standard in Indonesia? We have the rules, we have the regulation from the Ministry of Health about the data protection. We have the regulation about the electronic medical record. So we must do preparing is not only one, but we must be preparing about the one by one, because if we don't push about the regulation, some have the problem in the future about the program. So now from the reference, we know about the general data protection regulation and medical practice. What happened after the GDPR regulation to healthcare organization in Europe? This is we can benchmark in Europe to understand the regulation and to give the analyze about the how to measure about the personal data protection, and we just with the implementation step by step, audit and review, and awareness about the PDP. Yeah. So and how to anticipate about the standard operating procedure and workflow in the organization. And we have the standard operation procedure with the information governance revised, and we gave the regulation of the PDP.
Sorry, Mr. Adib. Yes, yeah.
Yes, two slides more.
Yes.
Okay. Yes.
Thank you, Adib.
Yes, this is the, I think all of the audience know about the agrotis salus lex suprema. Ya, keselamatan pasien adalah hukum yang tertinggi. Yes, this is the last slide. Thank you, Mr. Bona. I have my presentation could be understand, and thanks for chairman invite to me, and thanks for all. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you, Mr. Adib, for your excellent presentation. Even though your English is very good, for me it's hard to understand, but but for all the participants, I sure that we understand for what that you have give to us. Okay, thank you, Mr. Adib. We will wait for next 3 presenter. So I will invite you at the session, the discussion session. So I will invite our third national speaker in this session. Please, committee, to deliver the CV of our third national speakers. Okay, our third national speaker is Dr. Gigi Edi Sumarwanto, MM, MHAKES. He's a head of law and interinstitution relation atau Biro Indonesian Dental Association. Next, he's finished his dentist at Fakultas Kedokteran Universitas Gadjah Mada. He also has General Secretary of PDGI 2005 until 2008. He's also a surveyor CARS and surveyor SIRMA, also as me, Dr. And also the Dewan Pembina CARS, Ketua Kompartemen Hukum Persi Pusat, Ketua Biro Hukum PDGI, and also Ketua Kompartemen Hukum RC Semarang. So, Dr. Edi, are you with us? Dr. Edi?
Yes, thank you, moderator.
Thank you, Dr. Edi. Next, your 15 minutes. Next 15 minutes is time is yours.
Okay.
Please. Thank you, Dr. Edi.
Yes. Good afternoon, everybody. I will start my slide presentation. Sorry, I will present in bahasa Indonesia. PDGI perspektif on IRM. PDGI, next slide. Next slide. Jadi PDGI adalah Persatuan Dokter Gigi Indonesia, dan ini adalah satu-satunya organisasi profesi dokter gigi. Ada 43 ribuan dokter gigi yang ada di Indonesia, dan PDGI ini mempunyai satu legalitas tercatat di dalam Menteri Hukum dan HAM, dan PDGI ini juga menjadi member dari Asia Pacific Dental Federation dan juga FDI World Dental Federation. Jadi PDGI ini cukup besar karena mempunyai dokter-dokter gigi yang menjalankan praktek, dan adanya regulasi mengenai rekam medik ini tentu bukan hal yang mudah, karena yang tidak praktek mandiri mereka juga praktek di rumah sakit, sehingga harus mengikuti regulasi yang ada. Next slide. Nah, medical record of dentistry ini ada 4 hal sesuai dengan regulasi yang ada, bahwa 4 bagian itu. Pertama adalah tentu berisi identitas dari pasien. Jadi yang kedua terkait dengan odontogram. Jadi odontogram ini adalah bagian dari rekam medis khusus dokter gigi yang memberi gambaran gigi di dalam rongga mulut yang berisikan data tentang bagaimana jumlah gigi, bentuk gigi, susunan yang ada, dan itu dituangkan dalam bentuk gambar atau denah standar. Jadi ini untuk mengetahui keadaan gigi gerigi dalam pasien, di dalam pasien. Jadi dalam hal ini barangkali memang ini kekhususan di dokter gigi, bahwa medical record ada satu namanya odontogram. Nah, odontogram ini memang belum sepenuhnya tersosialisasi dengan baik. Artinya kalau kita melakukan satu survei gitu, belum semua konsisten mengisi odontogram dengan baik. Padahal odontogram ini adalah bagian dari medical record. Apalagi nanti dengan adanya rekam medik, tentu persoalan ini akan menjadi hal yang serius. Bagian yang ketiga adalah terkait dengan tabel perawatan. Artinya apa yang kita lakukan terhadap pasien, dan kemudian bagian yang keempat adalah terkait dengan lampiran penunjang. Apakah ada satu pemeriksaan-pemeriksaan seperti radiologi dan sebagainya. Next slide. Nah, odontogram ini bisa sebagai satu alat bukti hukum karena memang menarik. Bagian gigi ini adalah yang paling keras ya, dari organ manusia, sehingga meskipun barangkali pasien karena kasus bom yang kemudian seluruh organ rusak atau kebakaran yang semua hangus, itu kondisi gigi itu biasanya masih bisa diidentifikasi. Jadi identifikasi ini banyak terkait dengan kepentingan forensik. Jadi karena tadi menjadi bagian yang keras. Dan tentu sebagai resume dari keadaan gigi dan mulut itu bisa digambarkan dengan kondisi odontogram. Dan juga sebagai alat bukti nanti di dalam pengadilan dalam kasus-kasus hukum. Next slide. Nah, gambaran gigi seperti yang tadi saya jelaskan di dalam odontogram. Misalnya gigi yang pernah dicabut, itu akan tergambar di dalam odontogram. Dengan membaca odontogram akan tahu bahwa pasien ini berapa yang sudah dicabut. Kemudian gigi yang masih ada berapa. Ini bisa diidentifikasi melalui odontogram. Jadi tidak hanya sekedar senyum manis yang kelihatan dari depan, kemudian rekam mediknya tidak berbunyi, tapi odontogram akan memberikan sebuah gambaran. Termasuk gigi yang berlubang. Lubang gigi yang mana, sebelah mana, artinya posisi-posisi gigi ada regionalnya, nah ini juga akan terdeteksi di dalam odontogram. Dengan mengisi odontogram baik, maka seluruh gambaran gigi itu bisa terpotret di dalamnya. Termasuk gigi yang tidak rapi. Gigi yang terlalu keluar, gitu. Atau gigi yang terlalu masuk, atau gigi yang tidak tumbuh. Semua bisa tergambarkan di dalam odontogram. Jadi odontogram ini adalah bagian dari rekam medis dokter gigi yang sangat penting. Next slide. Nah, ini adalah gambaran mengenai dental odontogram. Yang di sini akan bisa digambarkan. Ada pedoman untuk pemberian kode-kode di dalam penulisan dental odontogram. Sehingga rekam medik dokter gigi yang dilengkapi dengan odontogram dan diisi dengan baik, maka semua informasi data pasien ada di dalam odontogram. Apakah itu gigi dicabut, apakah itu gigi ditambal, apakah itu gigi berlubang, apakah itu gigi dewasa, apa anak, apa rahang atas, apa rahang bawah, kiri atau kanan, semua bisa dibaca dengan odontogram. Next slide. Nah, peserta semuanya, kita sekarang dihadapkan kepada satu ketentuan. Kalau kita lihat di dalam Undang-Undang Praktek Kedokteran, disebutkan bahwa setiap dokter dan dokter gigi dalam menjalankan praktek kedokteran wajib membuat rekam medik. Dan kemudian di dalam pasal berikutnya, pasal 47 ayat 2, rekam medik sebagaimana yang dimaksud pada ayat 1 harus disimpan dan dijaga kerahasiaannya oleh dokter atau dokter gigi dan pimpinan sarana kesehatan. Ini tentu sangat menarik. Next slide. Ya, oke. Jadi Undang-Undang Nomor 29 tahun 2004 tentang praktek kedokteran ini yang kita bisa sebutkan bahwa setiap dokter gigi wajib membuat, kemudian harus melengkapi, kemudian membubuhkan nama, waktu dan tanda tangan, dan menyimpan. Ini yang memang sesuatu mengikat. Karena ini adalah perintah undang-undang. Nah, next slide. Bagaimana sekarang dengan regulasi yang ada? Bahwa dari Peraturan Menteri Kesehatan Nomor 269 tahun 2008 yang sekarang dengan Peraturan Menteri Kesehatan Nomor 24 tahun 2022. Tentu ada hal-hal yang sangat berubah, yang sangat berbeda. Next slide. Nah, electronic medical record. Kita melihat bahwa di dalam Peraturan Menteri Kesehatan Nomor 24 itu kemarin diterbitkan tanggal 31 Agustus 2022. Nah, dan paling lambat 31 Desember 2023 itu sudah harus dilaksanakan. Nah, dalam pelaksanaan ini ada hal yang bahwa elektronik rekam medik ini terhubung dengan ada istilah Satu Sehat Kementerian Kesehatan Republik Indonesia. Barangkali Kementerian Kesehatan punya satu tujuan terkait dengan big data kesehatan masyarakat di Indonesia. Nah, jadi standar data dan sistem ini mengacu pada Kementerian Kesehatan. Next slide. Nah, dokumen dan isi dari rekam medik elektronik ini, kita melihat bahwa rekam medik ini adalah miliknya pasienkes atau dokter, sedangkan isinya adalah milik pasien. Isi rekam medik itu diberikan kepada pasien atau keluarga, tapi juga bisa kepada pihak lain atas persetujuan pasien. Jadi rekam medik ini bisa diberikan kepada keluarga itu kalau pasien itu secara hukum itu karena umurnya masih anak-anak atau di bawah 18 tahun.
Izin Dr. Edi,
Atau,
waktunya tinggal 3.
Ya.
Izin Dr. Edi, waktu tinggal 3 menit lagi.
Baik.
Terima kasih.
Baik. Jadi isi rekam medik ini artinya bahwa bisa juga diberikan kepada pasien saat dirujuk. Nah, bagaimana slide berikutnya? Next slide. Tentang kerahasiaan ini tentu kita menjadi persoalan. Karena pasien mau pulang, itu sudah harus diberikan. Atau pada saat mau dirujuk. Nah, dan ini bisa diberikan kepada pasiennya, bisa keluarganya, bisa orang lain, tentu atas persetujuan pasien seperti yang tadi saya sampaikan. Next slide. Nah, ini persoalan yang menurut kami serius. Pada pasal 3 ayat 2, fasilitas pelayanan kesehatan sebagai yang dimaksud ayat 1, itu adalah tempat praktek mandiri, termasuk adalah dokter gigi. Ya, dokter gigi. Yang harus melaksanakan elektronik rekam medik. Next slide. Nah, jadi ini sudah saya bahas. Next slide. Biar cepat saja. Jadi terkait dengan persoalan sistem elektronik yang dikembangkan oleh Kementerian Kesehatan ini, fasilitas pelayanan kesehatan itu kita bisa lakukan dengan sendiri atau penyelenggara sistem elektronik melalui kerjasama. Nah. Next slide. Tentang kebocoran. Kebocoran sudah banyak sekali cerita yang pernah kita dengar. Ini hanya merupakan salah satu potret yang kami sampaikan. Bagaimana nanti kemudian menjaga kerahasiaan. Karena bagaimanapun juga dokter gigi di dalam penyelenggaraan praktek mandiri maupun di sarana pelayanan kesehatan, dia punya kewajiban menjaga kerahasiaan. Sedangkan terkait dengan pengendalian informasi RK-Medik ini, kita tentu masih banyak bertanya. Bagaimana keamanan data kita? Next slide. Nah, ini sebuah pertanyaan yang coba kami sampaikan mengakhiri dari slide saya, yaitu apa sebetulnya solusi yang terbaik? Apakah Indonesia sudah siap? Apa perlu dilakukan satu revisi? Ya, ini tentu sebuah pertanyaan gitu. Jadi kami melihat bahwa ada persoalan-persoalan yang barangkali perlu dibahas, sehingga apakah pelaksanaannya bisa bertahap. Jadi batas waktu Desember 2023 tentu bukan hal yang mudah. Dokter gigi yang ada di daerah-daerah dengan kesulitan-kesulitan komunikasi, apakah bisa melaksanakan RK-Medik dengan baik? Padahal ini adalah sebuah regulasi yang harus dilaksanakan. Saya kira demikian dari kami dalam perspektif PDGI menyoroti RK-Medik. Terima kasih.
Terima kasih Dr. Edi atas presentasi Dr. Edi Sumarwanto yang luar biasa. So I will continue to our fourth speaker today, and our fourth national speaker today is from the National Nurses, the Indonesian National Nurses Association. They will bring this committee, Dr. Harif Fadilah SKP SHMH. He is a president of Indonesian National Nurse Association, or PPNI. Dr. Harif Fadilah will be present his presentation with the pre-recorded video. So please the committee, please. Yes. Okay.
Good evening, everybody, all of the participants of seminar, all of the speakers, the great speakers from other profession and professional. So I would like to thanks to our campus Unika Sugiya Pranoto, especially the committee who entrusted me to deliver the presentations at this great seminar in the frame of the third Health Law International online seminar by Unika Sugiya Pranoto. I am very proud of my campus. Congratulations to this seminar. I would like to share my screen, please. Okay, I hope we are all clear this slide. Yeah. The theme discussed this time is indeed a theme as is a current being faced. Even though the discussion has been very long by various party, various opportunity, especially in health sector and professional health sector. So right now, I try to discuss in the short time how PDP and EMR are from a nursing perspective. So there are several wise words of experts that we can learn from related to this theme, our theme today. From Carlos Ruiz Zafón, he said, the value as a secret depends on the person from whom it must be kept. So it is very, very important thing to we get the point. Yeah. Okay. So how about in nursing? Especially in nursing or nursing profession, there are general beliefs related to our theme today that can be used as a moral and professional reference in carrying out the profession. According to International Council of Nurses, 2015, nurses believes that people receiving healthcare services should be seen as the primary owner of their health information, with the right to access their health information and determine any sharing of their health information with others. It is the belief all of nurses from all the world, I think, by the International Council of Nurses have to describe it is the position, our position in nursing, our nursing position in health information. And then how the perspective INA is Indonesian National Nurses Association, PPNI, the organization, only one organization in nursing in Indonesia, yeah, PPNI. So we collect the national nursing from all of Indonesian province, district, and other remote area. Yeah. And then we have more than 1 million member. Yeah. So that we have to struggle the develop the profession together, so that in this opportunity to in a perspective on PDP, protective data personal. So personal data protection is one of human right, which is a part of personal protection. Yeah. This personal protection is stated in Article 28G of the our Constitution, Undang-Undang 1945, UUD 45, we call it in Bahasa. Ya. This personal protection or privacy is universal. And then in this sense, that is recognized by many countries. As a background of this presentation, we know the industry of 4.0 has driven the development of the digital world in Indonesia until now. According to Hotsuite, we are social. 2022 data shows 204.7 million Indonesians use the internet, and 93.5% of them are active as a social media. This condition so require public and government awareness to protect personal data. Disclosure of personal data without control is proven to pose many risks of various acts of violation of human rights and criminal. Nursing as a service or care provider in the health sector cannot be separated from the protection of human rights, because health and health service are universal human rights. So we have many principles. One of principle in the health care system is protection. It is I got from several acts, like Act number 1038, according to nursing, 36 in according to health professional, and other act. Yeah. The principle of protection, especially about nursing, is principle of protection is that nursing practice setting must provide maximum protection for client, public, and nurses own, their own. The protection that is the obligation of both parties is related to the protection of personal data, which may only be informed to other parties with the person's permission or according to laws and regulation. So this is a relation with our belief, what I mentioned before. So, and then how to protect the information, health information, the public or community, especially in the health sector. We know, and we know the term of a professional obligation. The professional obligation related to the legal, ethic, and discipline their profession. So we have to must to keep secrecy. Keep secrecy is a very important indicator to some professional health care, how to give the professional caring. On the professional obligation, keeping secrecy as a professional obligation. What we related to the legal, ethical, and discipline aspect. So the implementing with the how to develop the MIS, Management Information System, especially in information health record as one part of the management information system to protect the information or PDP too. Yeah. So that and then health information are related individual record or information with physical, mental health and or health services or care. It is the definition of health information. And then management of health information in health services is with medical record. We know a medical record is the term of how to describe the management of health information in health services, which is a form of MIS. Yeah? The health information, there are various parties who have obligation in this management. Consists the healthcare facilities, hospital, PSG, private practice, health professional, client, and other like insurance company and other parties. Yeah. So the second sub-theme, the inner perspective of EMR, how the according to Ministry of Health Regulation 24 to 2022. So nurses have a professional obligation to maintain medical record that contain client health information according to their roles, responsibilities. Not all of the medical record, but role according to their role responsibilities. In today's advanced technology era, the management of medical record has a great opportunity to switch management from manual to digital system. Ministry of Health number 24 2022, we can get the describe about that. It's a provide legal basis from electronic digital implementation. Cause we found the regulation. There are the newest, the newest content. The electric system of electrical medical records, the activity of organizing electronic medical records, and the security and protection of electronic medical record data. So about that regulation, how a nurse and EMR. So what I mentioned before, the MOS regulation to give foundation or strengthening of the electronic medical record. So in medical record, the nurse contribution in several parts consists the clinical information filling or electronic medical record content transfer, a part, not all of content, because there are many health professionals like medical doctor, dietitian, midwife, pharmacist, and other contribution in this electronic medical record content transfer and clinical information filling. And then in this situation requires awareness and ability of nurses to use technology in the implementation of EMR is very, very important to us right now. And then EMR provide opportunity for nurses to be more professional because they have more time to meet client. So before this situation developed, like electronic medical record, we use manual. We use manual medical record. In manual medical records, nurse maybe all of their time use the medical record as a manual is very wasting time. So we have to make effectiveness in care of the patient, how to more long to meet the patient, meet the client. So we get the many problem. So we have to meet the problem solving with the other team to give the quality of services. Yeah. So the others hand, electronic medical record can sharpen professional sensitization and ethical and legal aspect and discipline. So because right now we know about we have IT Act, yeah, we get the described in our condition right now. So many cases, low cases related to the how to use the information in media social and other. So they give the sensitization to our professional health to more aware this situation, yeah, with the ethical and legal and discipline aspect. So the last my presentation, INA is a professional organization. How the role in this situation? So INA should assist the nurses in understanding and conducting their responsibilities related to information health system, especially in keeping accuracy and delivery information. Yeah. And then support effort to establish national protocol, guideline, and standard for portable health record, with contribute in the national team and other. Yeah. So advocating a safe system for nurses in administering medical record, with we develop guideline and other. Should also monitor research and introduction guideline on health information information adapted for use in their healthcare facility and the impact of changing technology on people's rights to health information. Thank you. Hopefully my presentation is useful for you all. Thank you very much. Good evening. Assalamualaikum warahmatullahi wabarakatuh. Good evening, everybody. All of.
Baik, terima kasih Dr. Harif Fadilah. Thank you, Dr. Harif Fadilah, for your presentation. And next, our last speaker in this session, in this seminar, I will present our fifth national speaker, Ibu Siti Romlah SKM MKM. She is representing Dr. Emi Nurjasmi Ankes, Chairman of the Indonesian Midwife Association or Ikatan Bidan Indonesia. So Now she's worked as Ketua Konsil Kebidanan Konsil Tenaga Kesehatan Indonesia masa bakti 2022-2027, and also she's head tim teknis PPIB, Humas PPIB, and also bidang pelayanan PPIB since 2018 till 2022. So now I invite Ibu Siti Romla. Siti Romla SKM MKM. Are you with us, Ibu Siti?
Okay, yeah. Yeah.
Okay, Ibu Siti, your next 15 minutes time is yours to present your presentation. Please, Ibu Siti.
Ya, terima kasih Dr. Ketut Widiasa. Izin kami share screen. Ya, mudah-mudahan terlihat ya. Assalamualaikum warahmatullahi wabarakatuh. Suara saya terdengar jelas kah?
Terdengar sangat jelas, Ibu. Izin presentasinya, panitia.
Baik, izin. Ini sudah terlihat ya.
Sudah, sedang dalam proses, Ibu. Ya.
Oke.
Mungkin bisa diulang, Bu. Ya.
Oke, baik, saya ulang ya.
Yeah.
Atau yang ini aja deh. Ya, lihat. Oke, sudah terlihat. Baik, Ketut. Atau dia saja boleh, enggak apa-apa.
Di tempat saya masih muter-muter, Ibu Siti. Sebentar. Mungkin panitia sudah bisa melihat presentasi Ibu Siti. Panitia mungkin bisa membantu.
Ya, bisa terlihat.
Sebentar, Ibu, belum tampak di slide saya. Sebentar.
Oke, kalau gitu boleh deh ditampilkan oleh panitia.
Baik, terima kasih, Ibu. Mungkin bisa dibantu oleh panitia. Please, the committee.
Baik, sambil menunggu materi, pertama-tama izinkan kami menghaturkan permohonan maaf karena seyogyanya Bu Emi sendiri yang ingin menyampaikan materi ini, tapi karena ada satu dan lain hal ya, sehingga diwakilkan kepada kami. Kami mengucapkan terima kasih kepada Ketua Panitia dan juga Ketua Prodi Program Magister Hukum Kesehatan dari Fakultas Hukum dan Komunikasi Unika, Suji Japrana. Sugi Pranata ya, yang luar biasa telah menginisiasi seminar ini. Dan juga tidak lupa Bapak-Bapak pembicara ya sebelum kami dari Poliki, ID, PDGI dan juga PPNI. Mudah-mudahan sudah bisa ditampilkan.
Bisa, Ibu, silakan di next slide saja.
Oh, dari kami.
Ya, dari panitia, Ibu.
Oke.
Silakan, Bu Siti.
Dari panitia. Oke, baik.
Izin mungkin Ibu Siti bisa stop share ya.
Sudah stop share.
Silakan Ibu dilanjutkan, Bu.
Ya, baik. Terima kasih. Kami mengawali presentasi dengan amanah Bapak Presiden melalui pesan kesehatannya, di mana bahwa titik dimulainya pembangunan kesehatan itu adalah dengan mulai menjamin kesehatan ibu hamil, kesehatan bayi, kesehatan balita, kesehatan anak sekolah ya, karena ini adalah merupakan golden period untuk menyiapkan manusia Indonesia yang unggul. Belum mengamanahkan betul jangan sampai ada stunting ya, kematian bayi yang meningkat begitu. masalah AKI dan masalah AKB ini masih cukup menjadi perhatian penting ya. Dan ini juga nanti akan ada kaitannya dengan rekam medis ya. Kita tahu bahwa proyeksi kematian, angka kematian ibu berdasarkan data Supas tahun 2015 AKI kita adalah 305-400.000 dan di mana kita dapati seharusnya total kematian ibu adalah angkanya 14.640 dan ternyata yang terlaporkan tidak sampai 5.000, hampir 10.000 yang tidak terlaporkan. Begitu juga untuk kematian neonatal ya, di mana berdasarkan SDKI 2017 kematian neonatal itu harusnya 15 per 1.000 kelahiran hidup, di mana berdasarkan data harusnya adalah total kematian neonatal itu adalah 72.000 dan yang terlaporkan tidak sampai 20.000 dan hampir 55.000 ya yang tidak terlaporkan. Untuk itulah perlu mekanisme pencatatan dan pelaporan yang valid tentunya untuk mengatasi underreported ini. Nah, kemudian didukung juga dengan hasil audit maternal prenatal yang dilakukan oleh POGI bersama EMAS dan juga Kementerian Kesehatan dan IBI yang dilaksanakan tahun 2014 ya pada masa akhir MDGs sebelum mengawali fase SDGs ini, yaitu yang dilakukan di 12 rumah sakit dengan 11 rumah sakit umum daerah dan 1 rumah sakit swasta, di mana ingin melihat seberapa baik kualitas asuhan kualitas pelayanan kesehatan maternal dan neonatal. Dan ini didapati ternyata kualitas prarujukan ini masih kurang memadai, dibuktikan dengan 31% masih terjadi keterlambatan dalam rujuk dan 9% saja dari pasien yang rujuk kita mendapat tindakan stabilisasi. Begitu juga dengan tata kelola di rumah sakit, kita lihat bahwa 53% pasien yang masih mengalami pengambilan keputusan klinis yang tidak tepat ya. Belum lagi 47% terlambat untuk dilakukan eksekusi, 47% lagi mengalami ketidakakuratan dalam monitoring, sehingga kalau bisa disimpulkan ya sekitar 70% sebab kematian sesungguhnya dapat dicegah. Ya, dan ini diambil dari rekam medis pasien yang meninggal yang tentunya sudah disisir, sudah dihilangkan, sudah dikeluarkan ya kasus-kasus yang komplikasi maupun yang kasus dengan faktor risiko dan penyakit penyerta. Nah, sehingga kenapa ibu ini meninggal? Ini yang didapati hasilnya. Nah, ternyata hanya 26% pasien yang meninggal dalam masa jam setelah masuk rumah sakit dan sisanya 74% ternyata meninggalnya setelah golden period itu dilewati ya. Nah, untuk itu kami dari PPIB tentunya sangat mensupport Kementerian Kesehatan ya dengan komitmennya melakukan transformasi sistem kesehatan dengan 6 pilarnya ya, sehingga kita akan mendukung mulai dari transformasi pelayanan kesehatan primer, transformasi pelayanan kesehatan rujukan, transformasi SDM kesehatan dan juga transformasi teknologi kesehatan. Nah, tentunya sesuai dengan tugas kewenangan bidan ya, di mana bidan memberikan pelayanan pada kesehatan ibu, kesehatan anak, kesehatan reproduksi dan juga keluarga berencana, di samping pelaksanaan tugas berdasarkan pelimpahan kewenangan, pelaksanaan tugas dalam kondisi keterbatasan tertentu seperti pada DTPK. Dan kita ketahui bahwa pelayanan kebidanan adalah bagian dari sistem pelayanan kesehatan yang tentunya diberikan oleh bidan dalam bentuk asuhan kebidanan yang dilakukan baik secara mandiri, kolaboratif, konsultasi, pendelegasian, dan juga rujukan. Semakin tingkat fasilitas pelayanan kesehatan, semakin kompleks pelayanan kesehatan yang diberikan oleh tenaga kesehatan, dan ini sangat diperlukan interprofessional collaboration. Dan alhamdulillah tadi Bapak kita dari PPNI juga sudah menyampaikan pentingnya IPC ya antar provider di dalam fasilitas pelayanan kesehatan. Nah, tentunya IB akan sangat mendukung ya konteks interprofessional collaboration ini. Nah, kemudian untuk strata pelayanan tentunya disesuaikan di mana bidan akan menjalankan peran fungsinya mulai dari tata pelayanan kesehatan primer ya, baik itu di puskesmas dan jaringannya, kemudian klinik dan juga di tempat praktek mandiri bidan. Kemudian di rumah sakit baik itu di level sekunder dan juga tersier ya. Kemudian tentunya dalam memberikan pelayanan mengacu kepada konsep profesi di mana bidan melaksanakan asuhannya berdasarkan filosofi, kode etik profesi dilandasi oleh regulasi baik itu secara independen, kolaboratif ya ataupun bagian dari teamwork, tentunya fokus pada perempuan berdasarkan evidence based dengan asuhan yang berkesinambungan dengan pendekatan yang humanistik, holistik dan komprehensif. Nah,
Sepertinya Ibu Siti Romlah keluar dari ini ya.
Ya, maaf, kayaknya tadi sempat terlempar ya.
Ya,
Sinyalnya kurang baik. Ya, untuk landasan hukum mungkin nanti saya lewati saja, di mana salah satunya saat ini yang kita bahas seharian adalah terkait Permenkes 24 tahun 2022 ya, di mana kaitannya bahwa bidan dalam melakukan pelayanannya tentunya memberikan asuhan kebidanan ya, baik bersifat holistik, kemudian humanistik berdasarkan evidence tentunya dengan pendekatan manajemen asuhan kebidanan, baik itu pelayanannya pada upaya promotif, preventif, kuratif, dan rehabilitatif sesuai dengan kewenangannya. Izin, saya belum melihat ada share screen-nya. Apakah tidak terlihat nih atau nah, baik. Kita lanjut slide berikutnya. Nah, slide berikutnya izin. Ya. Ini kayaknya ke atas balik ke bawah.
Depan, ke bawah.
Ke bawah. Iya, ke bawah. Ini tadi kami sampaikan. Ya, slide berikutnya. Lanjut pada slide standar asuhan kebidanan, di mana ini menjadi acuan bagi bidan dalam proses pengambilan keputusan dan tindakan yang dilakukannya, tentunya sesuai dengan wewenang dan ruang lingkup prakteknya ya. Dari dia melakukan pengkajian. Lanjut slide lagi. Slide lagi izin. Ya, izin slide lagi. Ya, lanjut. Tadi lanjut 2 slide lagi dari sini. Ya, satu lagi. Ya, satu lagi. Nah, ya ini standar asuhan kebidanan walaupun sudah sangat lama ya belum terupdate, bahwa ini adalah acuan bagi teman-teman bidan tentunya dalam proses pengambilan keputusan dan tindakan yang dia lakukan ya, tentunya sesuai dengan kewenangan dan ruang lingkup praktiknya ya, di mana mulai dari bidan melakukan pengajian, rumus diagnosis dan juga atau masalah, kemudian melakukan perencanaan, implementasi, evaluasi, dan sampai pencatatan asuhan kebidanan ya. Terus lanjut aja. Lanjut. Nah, ya untuk itu ya ini saja dia langsung baik. Ya, kita tahu bahwa di dalam undang-undang tentang tenaga kesehatan dikatakan bahwa setiap tenaga kesehatan yang melaksanakan pelayanan kesehatan perorangan tentunya wajib membuat rekam medis menerima pelayanan kesehatan, dan dengan rekam medis menerima pelayanan kesehatan itu harus disimpan dan dijaga kerahasiaannya baik oleh tenaga kesehatan maupun oleh fasilitas pelayanan kesehatan ya. Tadi tentunya kita sudah diskusi banyak sekali terkait ini. Lanjut. Nah, tentunya kami mendukung untuk transformasi rekam medis yang sudah dilakukan oleh Kementerian Kesehatan, di mana tentunya transformasi ini ya dilandasi oleh filosofi, sosiologi, dan juga yuridis ya untuk penyelenggaraannya, karena kita tahu bahwa perkembangan teknologi digital dalam masyarakat ini akan mengakibatkan transformasi digital juga untuk pelayanan kesehatan, dan di mana untuk penyelenggaraan rekam medis secara elektronik tentunya ini harus menggunakan prinsip keamanan dan kerahasiaan terkait data dan informasinya yang tadi juga sudah kita diskusikan ya cukup banyak ya oleh pembicara-pembicara sebelumnya. Dan tentunya dengan adanya transformasi rekam medis ini ya maka nomor 269 tahun 2008 tentunya terkait rekam medis sudah dinyatakan tidak berlaku ya dengan berlakunya PMK 24 tahun 2022. Lanjut. Slide. Nah, ya kita tahu bahwa rekam medis adalah dokumen yang berisikan data identitas pasien, pemeriksaan, pengobatan, tindakan, dan juga pelayanan lain yang telah diberikan kepada pasien. Dan kita tahu untuk rekam medis elektronik adalah rekam medis yang dibuat dengan menggunakan sistem elektronik, tentunya diperuntukkan bagi penyelenggaraan rekam medis. Ya. Nah, kita tahu juga bahwa penyelenggaraan rekam medis elektronik ini dilakukan sejak pasien itu masuk Fasiankes, tentunya sampai pasien itu pulang, dirujuk, atau bahkan pasiennya meninggal ya. Dan setiap fasilitas pelayanan kesehatan wajib menyelenggarakan rekam medis elektronik ini. Tadi juga sudah dibahas ya. Lanjut. Lanjut. Ya, baik. Untuk kegiatan penyelenggaraan rekam medis elektronik ini kita tahu langkah-langkahnya mulai dari langkah pertama ya, ada sampai langkah ke-8 dan tentunya di dalam fasilitas pelayanan kesehatan bidan akan berkontribusi tentunya dalam konteks IPC pada pengisian informasi klinis ya. Di mana kita tahu juga bahwa pada penyelenggaraan rekam medis elektronik slide sebelumnya kali ya, Mas. Pada penyelenggaraan rekam medis untuk tempat praktek mandiri, baik itu mandiri dokter, dokter gigi, dan juga tempat praktek mandiri tenaga kesehatan lain, ya termasuk tempat praktek mandiri bidan, di mana penyelenggaraan rekam medis elektronik ini menjadi tanggung jawab tentunya penyelenggara ya. Dan kemudian untuk itu tentunya kita akan fokus pada pengisian informasi klinis, dan tentunya untuk pengisian informasi klinis kita akan bisa sharing informasi terutama terhadap ya tenaga kesehatan dan juga jika dibutuhkan untuk kepentingan tentunya pasien. Lanjut. Slide tadi sudah diskusikan banyak, yaitu terkait kewajiban seluruh Fasiankes yang harus menyelenggarakan rekam medis elektronik ini sesuai dengan ketentuan Permenkes, di mana dikatakan adalah paling lambat pada tanggal 31 Desember 2023. Sehingga untuk menyikapi ini semua, slide berikutnya. Slide berikutnya. Ya, tentunya kami menganggap bahwa rekam medis elektronik ini adalah merupakan salah satu bentuk ya bukti kemajuan teknologi informasi dalam layanan kesehatan. Dan untuk pemanfaatan komputer sebagai sarana pembuatan dan juga pengiriman informasi medis ini merupakan upaya yang dapat mempercepat dan mempertajam bergeraknya informasi medis untuk kepentingan ketepatan tindakan medis maupun tindakan asuhan. Kemudian informasi elektronik dan juga atau dokumen elektronik ini tentunya akan dianggap sah sepanjang informasi yang tercantum di dalamnya dapat diakses, ditampilkan dan dijamin keutuhannya dan juga dapat dipertanggungjawabkan sehingga dapat menerangkan suatu keadaan dan asuhan yang diberikan. Nah, kemudian dalam upaya menjaga keamanan dan kerahasiaan informasi pada rekam medis elektronik, tentunya sudah ada ISO yang tadi juga sempat terbahaskan nomor 27001 yang menyatakan bahwa sistem informasi yang ideal tentunya harus mencakup 3 aspek, yaitu terkait confidentiality, integrity, dan juga availability. Ya, dan PPIB tentunya mendukung terutama untuk meningkatkan akuntabilitas profesi dan juga akuntabilitas institusi pelayanan kesehatan dengan pemanfaatan RME ini yang tentunya merupakan teknologi ya dari rekam medis manual ya, tentunya dengan dasar bahwa informasi pada RME ini akan menjadi lebih terintegrasi karena sudah memungkinkan ya adanya kompatibilitas dan juga interoperabilitas ya, kita harapkan sehingga untuk mencatat yang pengulangan redundant itu sudah bisa diminimalisir. Nah, kemudian penggunaan RMS secara terintegrasi dalam asuhan kebidanan tentunya akan dapat meningkatkan kualitas pelayanan kebidanan karena teman-teman bidan tentunya akan lebih bisa berorientasi pada pasien. Tadi yang kami sampaikan adalah fokus pada perempuan, kemudian fokus juga pada keselamatan pasien, bisa melaksanakan secara adil, efektif, tepat waktu, sesuai tentunya dengan standar response time, dan juga bisa efisien dan berkesinambungan ya, tentunya dengan pemanfaatan data-data yang ada di dalam rekam medis elektronik ini. Lanjut.
Ini
Ya
Bu
baik.
Putri, waktu tinggal 3 menit lagi.
Ya. Baik, untuk itu ya manfaatnya ya, tentunya akan dapat meningkatkan kualitas pelayanan kebidanan, mendorong profesionalisme bidan untuk bekerja lebih taat pada standar, lebih efisiensi waktu, tenaga dan biaya, kemudian mengurangi kesalahan pencatatan dan juga tentunya kita akan memiliki ya bukti hukum ya yang valid dan juga akurat. Dan tentunya harapan kami ke depan adalah bahwa untuk RME ini tentunya membutuhkan SDM yang mampu mengerjakannya secara konsisten sehingga perlu dukungan alat atau device ya sarana prasarana support system yang sangat memadai, kemudian juga di mana kita semua harus menjaga komitmen ya bersama ya, baik itu dari kita sendiri tenaga kesehatan maupun juga Fasiankesnya, dan tentunya untuk proses ini tidak mudah karena ini merupakan masa transisi yang tentunya akan ada selalu perbaikan ya, yang berkesinambungan secara terus-menerus, dan kita harapkan terakhir adalah bahwa setelah tentunya kita siapkan semuanya dengan baik, kita akan sosialisasikan kepada teman-teman bidan secara masif untuk pemanfaatan RME ini. Demikian kami berharap nantinya kita semua bidan akan bisa menjawab tantangan kebutuhan kesehatan ibu dan anak dalam konteks interprofessional collaboration. Terima kasih.
Thank you.
Semoga paparannya ya.
Baik, terima kasih Bu Siti Romla.
Maaf terhadap insiden.
Yang jelas bukan insiden keselamatan pasien, Bu Siti.
Ya, terima kasih.
Baik, terima kasih atas presentasi yang luar biasa, komprehensif dari Ibu Siti Romla yang mewakili Ibu Ketua PPIB pada kesempatan sore hari ini. Baik, I invite all participants and all speakers to join our last session in this seminar. But unfortunately, Dr. Adib, the chief of Indonesian Medical Association, regret that he cannot join us at the discussion session because of trouble in the internet provider. So first, I invite the participant who will ask directly. Is there any participant who will ask directly at the Unica Hall or at the who attend in Zoom? Please raise your hand in your feature in Zoom. Is there any participant who will ask directly to the speakers? Okay. If there's no question at the who will ask directly, I will ask to the speakers. Yeah, there's too many questions at the chat column. Wait a moment. Wait a moment. Pertanyaannya di mana? Okay, baik. There's a lot of questions in the chat column in the Zoom. So most of the question delivered to Mr. Suryo Nugroho Markus. But I will first we'll read the first question from Ana Agung Gede Putra Semarajaya to Mr. Suryo. Mr. Suryo, is there any law violation when translating the manual document to electronic medical record? Mr. Suryo Nugroho, are you with us?
Yeah.
Yes. Yeah, please answer the first question from Dr. Ana Agung Gede Putra Semarajaya, who asked, is there any law violation when translating the manual document to electronic medical record? Please, Mr. Suryo.
Thank you for the question. I'm sorry, Mr. Moderator, I prefer speak Indonesian language. The question is very complex, and I'm afraid I will answer wrong. Okay. Mohon maaf, jadi saya menggunakan bahasa Indonesia untuk menjawab lebih lancar, gitu ya. Kalau ada beberapa pertanyaan yang agak mudah, gitu ya, nanti saya jawab menggunakan bahasa Inggris. Baik, yang terkait dengan aspek hukum, saya kira tadi sudah dibahas di pertemuan sebelumnya. Jadi yang terkait dengan bagaimana menyalin, gitu ya, kalau bahasa menyalin di bahasa kita mungkin lebih kepada alih media, begitu ya, alih media dari dokumen manual ke elektronik. Kita tahu bahwa nanti pada 1 Januari 2024, apabila elektronik rekam medis itu diberlakukan kepada seluruh fasilitas pelayanan kesehatan. Nah, di sana sudah mulai elektronik. Lalu bagaimana dengan dokumen manual yang terdahulu? Gitu ya, saya kira lebih ke arah sana. Nah, ini ada proses alih media, dan alih media ini histori dari catatan medis, catatan keperawatan, catatan kebidanan ini dapat diakses untuk keberlanjutan pelayanan di kemudian hari. Gitu ya. Jadi histori itu tidak hilang. tapi histori harus bisa dibaca apapun bentuknya. Gitu. Nah, selanjutnya di 1 Januari ke depan itu baru data ini karena tersimpan di database yang tersebar di dalam database-database, tabel-tabel itu juga bisa diakses kapan dibutuhkan gitu. Ya. Mungkin saya kira begitu. Tapi kalau terkait dengan bagaimana proses menyalin secara aspek hukum gitu ya, mungkin nanti saya kira tadi sudah dibahas di pertemuan sebelumnya. Gitu. Saya kira demikian. Gitu. Terima kasih.
Baik, terima kasih Bapak Suryo. Saya lanjut ke pertanyaan berikutnya ya. Dari Ibu Retno, sebentar. Masih untuk Dr. Pak Suryo dari Yani Kristina. What are Pormiki's effort in facilitating their members for not be eroded by digital transformation? Jadi peran Pormiki terhadap
Pormiki ya, baik.
Ya, silakan.
Yeah, thank you. Pormiki strive with all might by increasing competence, drugs, standardized training, and now we are currently developing a curriculum and modules to breed our 40,000 member in fulfilling skills and knowledge about electronic medical record. Jadi saat ini kami juga sedang menyusun kurikulum untuk rekam medis elektronik bagi anggota-anggota Pormiki untuk meningkatkan kompetensinya sehingga tidak tertinggal gitu ya, tidak digerus oleh nanti profesi yang lain juga sehingga nanti apabila dari tenaga kesehatan lain misalnya perawat, bidan, dokter itu ada kesulitan di dalam electronic medical record, nanti dari teman-teman profesi rekam medis informasi kesehatan dapat membantu di sana, dapat berperan gitu. Begitu juga di dalam PMK 24 sudah disampaikan apabila tidak ada tenaga PMK di sana maka tenaga kesehatan lain ini dapat menggantikan dengan pelatihan. Nah, yang ini kami saat ini sedang menyusun kurikulumnya sehingga nanti semua mengacu di dalam kurikulum ini. Jadi kami anggota PMK ada sekitar 40 ribuan dan juga tadi sudah sampaikan kita kerja ada MOU dengan asosiasi pendidikan sehingga profil lulusan PMK itu nanti sudah ke digital transformation atau ke rekam kesehatan elektronik. Ya, saya kira begitu. Terima kasih Pak Ketua Desa.
Ya, terima kasih Pak Suryo. Jadi kita lanjutkan ke pertanyaan berikutnya masih ke Pak Suryo lagi dari Ibu Margareta Indah Wiji Lestari, Pak. Saya bahasa Inggris ya. From my observation, Pantirapi Hospital has implemented the electronic medical record very well. Nah, ini komplimennya. This is the compliment for you, Pak. So what are the crucial things that must be considered in preparing for the implementation of EMR, both in terms of hospital management governance and hospital clinical governance, which are closely related to legal aspect? Please answer for the first question first, Pak.
Okay, thank you. Ini agak panjang sampai Indonesia ya, karena terkait dengan pengalaman di rumah sakit ketika kami mulai menerapkan electronic medical record. Ya, kalau kebetulan saya di Rumah Sakit Pantirapi di Yogyakarta, kita sudah menerapkan electronic medical record rawat jalan 2010, lalu rawat inap di 2018. Ya. Nah, tentu saja peran penting itu ada tiga faktor utama di dalam kesuksesan implementasi atau kalau kita disebut dengan hot fit ya, human, organization, and technology. Jadi dari sisi tata kelola manajemen juga ini sangat harus support dari organisasi dan teknologinya. Nah, memang tadi kebetulan ini ada dari PDGI, kami memulainya memang dari dokter-dokter gigi gitu ya, karena dokter gigi ini kompleksitas layanannya, lalu juga rajin gitu ya kalau di tempat saya ya, sehingga menjadi pilot project. Jadi konsepnya adalah dari pilot project dari dokter gigi dulu, selanjutnya yang lain. Kami membutuhkan waktu sekitar 6 bulan untuk full electronic medical record di rawat jalan, dan 2018 kami juga sudah rawat inap untuk electronic medical record. Nah, yang terkait dengan pertanyaan kedua tentang total failure mode effect analysis atau FMEA, pada aplikasi ya, resikonya banyak ya. Jadi yang pertama sudah disampaikan aspek kerahasiaan, lalu yang paling penting sekarang selain kerahasiaan, yang juga penting maksudnya adalah downtime. Gitu ya. Bagaimana jika terjadi downtime ketika klinisi, dokter, perawat itu sedang melakukan pencatatan, sedang melakukan input gitu, lalu sistemnya down, apa yang dilakukan? Ini harus ada satu prosedur, itu hasil dari analisa resiko bahwa apa yang dilakukan, berapa menit yang toleransi yang bisa ditoleransi untuk terjadinya downtime tersebut. Jika lebih dari masa toleransi, apa yang dilakukan? Ini tentu saja harus dibuat prosedur untuk semua fasilitas kesehatan apabila terjadi downtime pada sistem rekam medis elektronik. Saya kira begitu. Jadi menjawab pertanyaan kedua, adanya kontingensi, mitigasi dan juga kontingensi plan yang ditentukan oleh masing-masing fasilitas pelayanan kesehatan. Gitu. Terima kasih, Pak.
Baik, terima kasih Pak Suryo. Jadi saya belum melanjutkan pertanyaan, tapi sudah Pak Suryo langsung jawab. Terima kasih luar biasa sudah membantu pekerjaan saya, Pak Suryo. Jadi our best practice is from hospital ya Pak ya, infant therapy hospital. So in hospital setting, there will be your hospital will be place for benchmark for many hospital for the implementing the electronic medical record, Pak. Yeah. So congratulations, Pak. But we also held the electronic medical record will be held in another setting, from example clinic, puskesmas, and also the doctor praktek mandiri. Yeah. So next, Pak. Next question. I don't know, Mr. Retno Merati Hartani asked to whom, but I will baca in bahasa. Izin bertanya, apakah ke depan juga akan diterapkan bahwa medical record itu dibawa pulang pasien dalam bentuk digital yang bisa pasien sharekan ke vaskes lain atau orang lain sesuai kemauan pasien? Dan bagaimanakah kemungkinan pemenuhan kondisi Permenkes tentang elektronik rekam medik bahwa tanggal 31 Desember 2023 sudah harus diterapkan? Apakah pemerintah juga wajib bertanggung jawab terhadap pemenuhan itu? Nah, mungkin tadi sudah dibahas di sesi ketiga ya Pak. Mungkin ada yang bisa membantu kembali menjelaskan ke Ibu Retno Melati Hatani terkait dengan hal ini? Terkait dengan penerapan. Silakan Pak.
Ya, saya sedikit menyampaikan nanti di nanti yang lain. Jadi saat ini kan dari Kementerian Kesehatan melalui DTO itu sudah mulai sosialisasi untuk konsep Satu Sehat. Ya. Satu Sehat ini kan platform gitu. Ya. Untuk aplikasinya ada Peduli Lindungi. Ya, apa yang sudah ditulis, apa yang sudah diinputkan di sistemnya masing-masing, baik itu di Hospital Information System, baik itu di puskesmas simpus dengan simpusnya, itu nanti akan dipertukarkan datanya. Nah, apa data yang dipertukarkan? Itu tadi sudah dibahas di awal bahwa resume. Nah, resume yang akan dipertukarkan. Bentuk resume ini, item-itemnya sudah ada di dalam regulasi untuk variabel dan metadata. Jadi tidak semuanya gitu. Tidak semua data itu akan bisa dibaca oleh vaskes lain itu tidak. Nah, caranya adalah dengan ketika konsepnya adalah pasien itu karena membawa smartphone gitu ya, di Peduli Lindunginya dia bisa buka, tetapi tidak serta-merta bahwa ini bisa di-share kemana-mana begitu ya. Tetapi ketika dia periksa ke antar vaskes, maka di sana akan bisa membuka tentu saja setelah pasien itu datang, gitu kan. Setelah itu datang, dan di sana pasien memiliki nomor namanya Indonesian Health Service. Jadi kalau saya periksa di satu rumah sakit memiliki nomor rekam medis, saya datang ke puskesmas ada nomor rekam medis di sana. Nah, ketika di semua itu ada satu namanya nomor Indonesian Health Service. Ya. Jadi konsepnya begitu. Itu menjembatani juga untuk pasien yang tidak membawa smartphone, membawa tadi dia datang ke vaskes. Nah, di sana datanya juga sudah bisa dibaca. Tentu saja setelah pasien tersebut melakukan proses registrasi yang otomatis itu persetujuan ke vaskes tersebut untuk membuka, gitu ya. Dan sekali lagi bahwa tidak semua data bisa dibuka. Terima kasih.
Baik, terima kasih. Mungkin izin menambahkan juga terkait dengan isi rekam medis yang mungkin dalam Permenkes 24 itu sebelumnya dikenal dengan discharge summary atau resume medis itu di dalam Permenkes 24 itu kalau tidak salah namanya isi rekam medis ya Pak ya. Kalau tidak salah itu di pasal 24 pasal 26 ayat 8. Jadi terkait dengan isi rekam medis itu dibawa pulang oleh pasien dan wajib diberikan oleh rumah sakit itu untuk pasien-pasien yang rawat inap. Nah, kalau yang pasien rawat jalan itu tidak wajib diberikan kepada pasien, tapi untuk rawat inap wajib diberikan discharge summary-nya atau isi rekam medisnya, dan itu dapat diberikan dalam bentuk digital. Kalau tidak salah seperti itu yang pernah kita bahas sebelumnya, Pak. Baik, terima kasih. Mungkin ada jawaban dari para narasumber. I invite all speakers to respond to the last question, Pak Dr. Edi atau
Menambahkan, Dr. Bona.
Ya, silakan dokter, monggo.
Ya, saya dari perspektif organisasi PDGI. Jadi saya kira memang kalau pemerintah berkomitmen bahwa rekamedik ini akan dijalankan per 1 Januari 2024, maka tentu kami organisasi profesi harus jauh-jauh sebelumnya melakukan sosialisasi di internal organisasi kami sendiri tentang pentingnya bagaimana menjaga hak-hak pasien terkait dengan kerahasiaan dan sebagainya, kemudian juga mensosialisasikan bagaimana implementasi rekamedik itu di dalam khususnya praktek-praktek mandiri, karena persoalannya apakah memang ini juga akan diberlakukan untuk praktek mandiri ini per 1 Januari 2024. Karena menurut hemat saya kalau rumah sakit, kebetulan saya dari Persi juga, itu sarana prasarananya memungkinkan, SDM-nya banyak dan terkait dengan penyediaan aplikasinya, sistemnya, SDM-nya itu memungkinkan. Tetapi untuk praktek mandiri memang ini kita pertanyakan apakah pemerintah tetap akan memaksakan berlaku per 1 Januari 2024, karena tentu tidak semudah membalik tangan. Ini menyangkut soal kesiapan, kemampuan, skill, biaya, dan sebagainya. Saya kira demikian, Dr. Bona.
Baik, terima kasih Dr. Edi atas tambahannya. Memang ini adalah sebuah perubahan dan perlu di-manage perubahannya dengan lebih tersistematis ya Dr. Edi ya. Oke, is there any adding answer from the other speaker? Or last but not least, because we yes, Ibu Marcella.
Dari ya,
Please, Marcella, please. Silakan Ibu Dekan.
Baik, sedikit aja pertanyaan untuk Pak Edi. Itu menurut Pak Edi kesiapannya bagaimana ya Pak? Saya tahu kalau rumah sakit besar di urban area seperti Jakarta, Semarang itu nggak ada masalah ya. Tapi yang di remote area itu bagaimana ya? Orang ketika kemarin mungkin dari yang lain juga ya, ketika kemarin pandemi aja itu ada mahasiswa itu yang harus jalan sekitar 10 kilo sampai dapat internet ya. Padahal di daerahnya juga ada puskesmas yang di daerah remote begitu ya. Jadi itu kesiapannya bagaimana ya? Saya kok agak sanksi begitu. Karena itu butuh infrastruktur yang sangat lengkap. Belum lagi sumber daya manusianya ya. Jadi tidak semua itu bisa mudah melek. Saya sendiri terus terang saja saya tuh tipe gaptek begitu. Jadi kalau misalnya suruh apa nanti salah mencet ini gitu ya kalau bahasa Jawa. Itu mohon pencerahan Pak Edi atau Pak Surya dan Bu Siti.
Baik. Izin menjawab Bu Marcella.
Ya, silakan Pak Edi.
Dokter ya. Ya, baik.
Mangga.
Sebagaimana ini Ibu Marcella, slide kami tadi yang terakhir, bahwa kami mengusulkan adanya suatu pelaksanaan dari regulasi ini untuk dilaksanakan itu bertahap. Jadi hendaknya tidak kemudian secara bersama-sama seluruh unit pelayanan termasuk praktek mandiri. Kami 40.000 lebih dokter gigi ini tersebar di seluruh Indonesia, yang sebagian juga ada di daerah-daerah perifer yang bicara listrik saja kadang-kadang pasokannya tidak stabil. Kalau kemudian bicara bahwa mereka harus mempunyai satu jaringan untuk IT-nya, bagaimana terakses dengan kementerian dan sebagainya, tentu ini bukan hal yang mudah. Oleh karena itu, kami tentu mengharapkan ada satu kebijaksanaan gitu, bahwa pelaksanaannya itu bisa bertahap. Kalau rumah sakit, kami diskusi di organisasi perumah sakitan siap mendukung, meskipun barangkali rumah sakit tertentu yang levelnya masih rumah sakit kelas D dan sebagainya yang ada di daerah khususnya, itu beberapa memang mungkin ada yang kesulitan. Tapi saya kira dengan jeda waktu 1 tahun, harapan kami dengan nanti difasilitasi oleh pemerintah maupun juga komitmen dari seluruh jajaran perumah sakitan untuk mendorong agar RK-Medik ini bisa berjalan, moga-moga bisa. Cuma yang untuk praktek mandiri, klinik-klinik yang kecil-kecil ini yang saya pikir ada persoalan serius, karena ini menyangkut soal skill, pembiayaan, dan juga sumber daya yang lain yang dibutuhkan. Saya kira demikian, Bu Marcella.
Yes, Ibu Marcella.
Baik, terima kasih.
Terima kasih, Bu. Belum lagi nanti BPJS belum naik ya, Dokter Edi ya, masih Rp2.000 untuk dokter gigi.
Ya.
Baik, thank you, Dokter Edi. So, because it's our
Dokter
time.
Bona, ada pertanyaan satu yang untuk saya itu.
Oh iya. Oh, Mas, sebentar, Dokter Hap. Mohon maaf, Pak Arif. Saya kelewatan, maaf. Silakan Pak Arif untuk memberikan jawaban di pertanyaan tentang regarding nursing care. What nursing care guidance system do you suggest to be applied in electronic medical record, especially in integrated patient development medical records written by nurses as nursing care professional? Thank you.
Baik, terima kasih Pak Bona. Bu Margareta dari Pantirapi ya, saya kira juga mengerti bahasa Indonesia. Jadi saya izin menyampaikan bahasa Indonesia.
Silakan.
Saya mendapat poin pertanyaannya. Jadi memang pertama adalah peraturan ini memang baru, walaupun kita tadi slide saya sampaikan, kita diskusikan telah lama. Ya, peraturannya baru terbit ya, sebagai penguat landasan dan strengthening daripada pelaksanaan electronic medical record ini. Nah, pertanyaan Bu Margareta ini penting untuk kita hayati, bahwa didasari oleh, menurut saya memang untuk rumah sakit ya, rumah sakit itu para pakar teori mengatakan bahwa 80% aktivitas di rumah sakit itu adalah nursing care. Maka sangat relevan sekali pertanyaan Bu Margareta itu, ya, bagaimana integrated system atau pedoman integrasi sistem integrasinya dapat dikembangkan oleh keperawatan, begitu maksudnya tadi. Jadi atau bahkan oleh PPNI mengembangkan. Menurut saya ini tanggung jawab lebih spesifik sebenarnya tanggung jawab Vaskes nih, pimpinan Vaskes sebagai pengelola pelayanan rumah sakit. Tapi secara umum sebenarnya tanggung jawab pemerintah untuk mengembangkan sistem ini yang aman, yang berkualitas untuk dijadikan acuan bagi berbagai pelaksanaan penyelenggaraan rekam medis yang terintegrasi. Catatan saya terintegrasi tadi pertanyaannya Bu Margareta. Apa yang sudah kami lakukan atau PPNI lakukan? Nah, karena kita sadar bahwa 80% kegiatan rumah sakit itu adalah nursing care, maka kita ingin perawat-perawatnya itu juga harus benar melakukan aktivitas yang 80% itu yang terdiri dari nursing care. Makanya saat ini kita kembangkan pedoman-pedoman memang belum terintegrasi dengan interoperability dengan berbagai asuhan. Tapi saya berharap dengan adanya yang sudah dikembangkan ini bisa dialih mediakan seperti Pak Suryo tadi sampaikan, kemudian bisa interoperability, bisa linkage gitu ya. Saat ini misalnya bagaimana guideline untuk penegakan diagnosis keperawatan, ya, guidelines untuk bagaimana choice of intervensi keperawatan, luaran keperawatan, bahkan kita mengembangkan guideline untuk bagaimana mengembangkan prosedur operasional keperawatan yang ada di rumah sakit. Nah, itu bahan-bahan yang saya kira dapat dijadikan sebuah bagian penting dalam rangka menyusun integrated system, terutama dalam health record rekam medik ini gitu. Jadi saya kira itu Pak Bona, karena mengingat bahwa Permen 24 itu juga memberi catatan dua hal yang saya sangat penting tadi, yang menurut saya ada peran nakes, yaitu informasi klinik. Yang kedua adalah bagaimana menyiapkan bahan-bahan untuk melaksanakan rujukan catatan-catatan penting. Saya kira itu. Terima kasih Pak Bona, Bu Margareta, terima kasih atas pertanyaan yang luar biasa. Mohon maaf
terima
saya
kasih.
tadi baru landing Pak, jadi nggak bisa presentasi
Nggak apa-apa.
langsung. Ini
Siap,
sedang di
Pak Arif.
jalan.
Terima kasih. Terima kasih Pak Arif. Dan karena setelah ini
Pak
masih
Ketut,
ada
masih ada satu lagi.
bagaimana Pak itu panitia? Aduh, ya baiklah. Karena nanti jam 17.15 akan sudah ada paper presentation, saya izin mungkin Ibu Siti bisa menjawabnya dengan singkat, padat, dan jelas ya Bu, terkait pertanyaan Ibu Margareta mengenai bentuk dokumentasi asuhan kebidanan. Silakan Ibu.
Baik, terima kasih tentunya dari IBI ya, bersama juga dengan Koci. Saat ini dengan keluarnya PMK 24 2022 sedang mendevelop modul yang terakhir subnot yang tentunya nanti akan berisi ya terkait catatan klinis bidan, dan nanti modul ini akan di-bridging tentu pada platform aplikasi yang sudah disiapkan, terutama ini diuji coba di rumah sakit. Saya memberi apresiasi kepada Pak Harif ya, karena ini sudah established. Nah, kita bidan sudah menginginkan dan mudah-mudahan bisa segera terbridging ya, dan harapannya nanti ini juga tentunya mengikuti integrated system yang tentunya diinisiasi oleh Deko ya, mulai dari pelayanan teman-teman bidan di level primer ya, tentunya terutama di PES. Nah, nanti tentunya terintegrasi dalam Simpus, kemudian sistem rujukannya kita akan terintegrasi nanti dengan SIS-rute, dan nanti harapannya juga sampai ke RME dari fasilitas pelayanan kesehatan rujukan, tentunya dengan interoperabilitas data yang nanti bisa difasilitasi oleh TO untuk pengembangannya. Dan mudah-mudahan nanti setelah 2024 ya, berharap apabila belum tercapai, terutama untuk tempat praktek bidan mandiri yang kita tahu bahwa jumlah anggota PDGI yang sekitar 40.000 itu adalah bagi kami masih sedikit Pak. Kami bidan itu hampir 400.000, di mana yang tempat praktek mandirinya itu sendiri ada 40.000. Jadi betul-betul pengembangannya kami rasa memang tidak cukup dalam waktu setahun, dan kami nanti juga akan berkoordinasi dengan Kementerian Kesehatan untuk kira-kira adanya penanganan waktu ya masa transisi ini. Terima kasih.
Baik, terima kasih Bu Siti. Kita berharap kesempurnaan itu sistem ini akan berjalan di akhir Desember 2023, tetapi kalaupun tidak tercapai dengan mengingat disparitas geografis, kemampuan di masing-masing daerah yang sangat timpang, jadi mudah-mudahan akan ada evaluasi dari Kementerian Kesehatan dan juga nanti advokasi dari organisasi profesi kesehatan, PDGI, untuk nanti kepada Menteri Kesehatan agar ini bisa dilakukan perpanjangan lagi. Tapi mungkin itu kita tetap upaya maksimal untuk menyiapkan semua fasilitas sarana prasarananya Ibu ya. Baik, terima kasih. Baik Bapak Ibu, karena ini waktu sudah habis, jadi saya mohon maaf atas segala. I would like to thank to all your speakers for your excellent presentation. I also thank to the all participants who asked many questions in this session. I know that this is not enough for answer your question. So at least, and in the last, I won't be concluding, saya tidak akan menyimpulkan apapun, because the speaker has delivered their presentation very, very good, and I apologize if there are any mistakes while I'm guiding the session. So next, I return to MC. So thank you very much for your attention in this session. Thank you very much. Om Santi 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, salam sejahtera untuk kita semuanya. Terima kasih. Terima kasih Bu Dekan.
Truly, it was an enriching session for myself and for every one of us, I believe. Thanks to Dr. Widyasa, all distinguished and super enthusiast speakers and participants. And for your information, we just got a word from the international speaker from Netherlands, Associate Professor Andre Den Exter, PhD. He sent apologize for not being able to join us earlier this morning due to network issue. Anyway, he promised to send us a video recording of his session, and we will share it to all participants along with his PowerPoint material. Now, we'll have a quarter-hour break before we get into our next agenda, paper presentation. Do whatever it takes to recharge yourself during the break, and please get back here by 5:25 p.m. Semarang time. Thank you, and see you again in 15 minutes.